Obviously, if it's a class action lawsuit, then it's pretty easy to.
So what's your request, sir?
My request is to find out if Officer Schultz knew, to find out if the prosecution knew that there was a recall on those vehicles. And in light of the fact that these vehicles were recalled because of this malfunctioning throttle body for I believe it's counts 1 through 73 to be dismissed.
All right, what's the response from the state defendant?
Thank you, Your Honor. As Trooper Schultz testified during his examination, consistent with our research, there are no active recalls listed for the Ford Escape. As Trooper Inspector Schultz noted during his testimony, that Ford listed an extended warranty for the throttle body on the Escape. The warranty was extended to 10 years of age and 150,000 miles. The Escape is more than 10 years old and has more than 150,000 miles. Also, he noted specifically in his report that he did not note any defect in the throttle body as previously described in this report. There was no recall in the throttle body. NHTSA did do an investigation into allegedly defective Ford throttle bodies, which would have impacted this year. Basically, the electronic throttle body failures would have resulted in engine stall or surge while entering traffic from a stop position or while driving at highway speeds, neither of which I believe occurred here. Further, Inspector Schultz would testify that that does not prevent the brake from working. So if this had been activated on this car, which it was not, but if it had been, and this defendant would have pushed down on the brake, it would have stopped the car. Further, if this was a problem, there would have been the malfunction indicator lamp or the wrench light would have been illuminated, as Trooper Schultz or Inspector Schultz testified when he started the vehicle and checked the indicator lights. None of them were lit. Further, if there was this, he would have observed material buildup on the commutator. There was no such buildup observed. There were no problems with the throttle, electronic throttle body. That was part of his report. Therefore, this is, although there may have been some cars who had this problem, the car that the defendant was driving on this day did not have that problem. That was testified during the vehicle inspection. The defendant had the opportunity to cross-examine Inspector Schultz with regard to that. And again, in running the defendant's mom's VIN number through NHTSA, National Highway Traffic and Safety Administration, there are, for this particular VIN number, for this car that the defendant was driving, 0 unrepaired recalls. So it's a mood issue.
I don't believe it's a mood issue. And I actually have, the report should be in the mailroom as we speak. I had everything sent over priority mail, the actual information about the class action lawsuit, the actual information about the recalls for those models. Like I said, 2008 through 2010. Now, in all fairness, Your Honor, that's why I was asking for a Brady claim on this. Seeing as how when vehicles are purchased from the manufacturer, they're still sold as is. There would be no way to know that there's anything malfunctioning with the vehicle until it actually happens. And seeing it's a class action lawsuit,
Well, I mean, they would know.
no one would sue the Ford company if there weren't malfunctioning vehicles. There would be no class action lawsuit if these vehicles were not malfunctioning.
Yeah, about that.
And I believe with that,
At 150,000 miles, dude.
like I said, the information is easily obtainable. I should have the information in the mailroom right now
But someone stole your paperwork again?
that you can readily view this information about the class action lawsuit, about the recall. It wasn't just the 2010 model in question. It was 2008 through 2010. The information about the malfunctioning pertains strictly to the throttle body.
Let me address your
Caution.
claim, sir. So, not trying to cut you off, I don't need the specifics about a class action because as it relates to this case, the fact that there's a class action would not mean there's a Brady violation by the state. In fact, you even indicate it was readily known and something you were able to find out. I'd further note that you had a full and fair opportunity to cross-examine the inspector regarding his mechanical inspection. It's not new information. And more importantly, as it relates to this particular vehicle, based upon the testimony of Inspector Schultz, it's speculative as to whether this vehicle would be impacted, number one, by the class action, and number two, any throttle body problems. Because again, there was a full inspection. That report was provided to you. He testified on direct examination about there being no active recalls. And more importantly, he testified about what impact the throttle body would have and what he would expect to see if there were any issues with it. I am aware that the ICF, I did receive an email. It's one page with what you said. It's, I have to turn my head. I got to figure out how to flip it. So give me a second.
Just for the record, Your Honor.
Hold on, let me finish my record, okay? So I'm going to turn because it's the only way I can read. It says, your ICF says the state's expert witness who did the inspection on the vehicle in this incident needs to be recalled no later than Wednesday. I just learned of some information that is extremely vital. I understand the information that you're providing me, but again, you had a full and fair opportunity to cross-examine this witness. This information was apparently well known. I'd also note the vehicle's registered to your mother. And from my understanding of recalls, I think what is common knowledge is that a registered owner would receive information regarding the recalls and what to do. And presumably she would have provided that information to anyone operating that vehicle or taking care of it. We have none of that information before us by way of fact or even an offer of proof that even she received that information and did nothing with it, or whether anyone else who operated that did anything with it or not. The bottom line is there is absolutely no Brady violation by the state. This is not the type of information they would have been required to turn over. And from my understanding and review of Exhibit 83, what's important to this case is that the mechanical inspection specifically looked at that issue nonetheless and found that as to this particular vehicle, there were no issues with that would have impacted the mechanical function.
Sorry,
during
bud.
the incident
No
in
play there.
question. I'll accept the state's offer of proof as to what would have been the issues based upon the information provided. And again, without anything further from you by way of your offer of proof, I can't make a finding, number one, that there's a Brady violation, and number two, that the information you seek to cross-examine him on would have any impact whatsoever. So I'll deny the request to dismiss the case, and I'll deny the request to recall this witness.
Your
Hold
Your
on.
Honor.
Hold on. Let me have the state just make their statement. I'll give you the last word on it. Go ahead.
The Inspector Schultz's mechanical inspection report was provided to the defense on April 29th, 2022. I noted that when the defendant was cross-examining Inspector Schultz, he did have the report in front of him and it was asking questions directly related to information contained in that report.
All right, go ahead, Mr. Brooks.
When you spoke to the owner of the vehicle, that's who gave me the information. My mother gave me the information of this. I had no knowledge until she told me. And that's how I came into the information. And she was the one that said, I'm going to send you all the information that you need so you can present it to the court. So I
understand that, sir,
this
but
wasn't
your request
information.
is not timely. So you have had this information for quite some time, either through counsel.
I did not have it for quite some time.
Let me make my record, either through
It
counsel.
was just told to me.
That's not what I'm saying. You've had the information about this report for quite some time, either through prior counsel or through all of the discovery that was turned over to you when you took over your representation of your own case. The fact that you have now learned this, it's a little bit too late. And I understand that may seem fair to you, but even when I consider the information that you're providing to me, it's speculative on your part as to whether there's any impact on this particular vehicle because of the inspection that was done. And you had a full and fair opportunity to cross-examine the inspector about information that was readily obtainable and researchable by you prior to the time that you cross-examined this witness.
It was not really readily available for me to expect at the time. I don't have access to the internet. So how would I be able to?
Mr. Brooks, you're telling me your mother had that information.
No,
so,
I'm
and
telling
I'm
you,
trust.
she just told me this information. I have the phone calls.
I mean, that's too
prove it.
bad,
I
man.
understand that. I'm denying the request, sir.
And I would like a.
So that's my decision.
I object to that, Your Honor.
I understand.
I
I've made my
object to that.
decision. I expect that you respect the decision, at least
No.
as we're not going to debate it further.
Yes.
I now have the
It needs to be-
ICF,
It
the
needs to
one
be
from the state to be
addressed, Your
provided
Honor.
for the state.
It
Madam
needs to
Clerk,
be
I just gave
addressed.
that to you. All right, so
I
Mr. Brooks, in
respectfully
light of
object.
that,
I respectfully object, Your Honor.
Tanisha,
And
thank you for
request
becoming a
the
member
legal
over there on YouTube.
reconsideration of your ruling, Your Honor.
it's denied. The request for reconsideration is denied. There's no legal basis for me to do
I
that at this point.
respectfully reject that ruling and take exception to that ruling, Your Honor.
All right, Mr. Brooks, we need to keep going.
For the record, may I request a legal or factual basis for your ruling, Your Honor?
I provided an oral ruling today. The record stands, sir.
For the record, may I respectfully request a written judicial finding of facts and conclusion of law on this issue?
Your request is denied.
For the record, may I respectfully move for an interlocutory declaratory appeal of this matter?
I wouldn't be the one you would make that request to, sir. So I
For
can't
the record, may I
answer that
move
yes
to
or
stay
no.
these proceedings until the instant matter is adjudicated by a court of competent jurisdiction?
That request is denied.
Based on what law or fact, Your Honor?
The request is denied.
Based on what law or fact,
What,
Your Honor?
any other requests, sir, I'd like to.
Because it's what I say.
Based on what law?
There's no
or
legal
fact.
basis that you've stated for me to do that, sir.
I would like to invoke the jelly
It
belly
has- it
rule
has been,
of
The request
Hogwarts.
is denied. The request is
What do you
not
mean
a
you're not gonna
proper
respect
motion.
that?
There's no legal support
I said
for the
Hogwarts.
motion. There's no factual support for the motion. So it's denied.
Good night.
For the record, it appears that this court is acting in contempt of the law, Your Honor.
Does it, man?
Can you show me how or where this court is following the law of respecting this matter?
That's a very vague statement, sir. There's no legal relief that you're claiming. There's no motion before the court based in law or fact. So this court cannot address that last statement of yours.
Your Honor, with all due respect, I would like a motion for finding a fact.
Denied.
Under what law and fact?
I
Your
made
Honor?
an oral ruling, sir. There's no requirement I do so in writing.
So you're denying a legal, you're denying a motion for finding a fact.
Ma'am,
So how do I know what you're doing is legal, Your Honor?
all right, Mr. Brooks, we're going to move forward. At this time, I want to.
How do I know that this is legal, Your Honor? Can you show me that it's legal?
Mr. Brooks, we're moving forward. So your
Doesn't
request
seem
is
like
denied.
it doesn't seem
Mr.
like
Brooks,
you're-
I need to give you some
it
advisements,
doesn't
and
seem
I'd
like
ask that you
I don't
stop
need
interrupting
your
me.
advice.
No, I have to
need
give you advisements, sir, regarding
I
your
need
right
you
to testify.
I need to do your job without prejudice and without
Mr.
bias.
Brooks has
Your
now
Honor.
interrupted me multiple times. He's failing to respect the court's oral rulings here today. It's something that he's done repeatedly throughout this trial. Mr. Brooks, I need to go through some advisements. Unless you have a witness to immediately call, I need to go through this particular discussion on the record with you regarding your right to testify.
You don't need
Do you
to
have
go
a witness
through,
to
you don't
call,
need to go
sir?
through anything with me on record. You
Actually,
need to,
I do so,
Actually,
sir.
you
That is
don't.
required by
actually
law.
you don't. You need to do your job as a public servant
Mr. Brooks,
and honor the oath that you
I
took,
need to
Your
go
Honor.
through these advisements, and if you're going to keep interrupting me, you will forfeit your right to be present, and you
So
will
you're
be
holding me in
removed
contempt
to
again.
the next courtroom so that I can properly go through these advisements
I
without being
still-
interrupted.
And I still don't have to answer. I still don't have to answer whether I'm in this court or not. So you're holding me in contempt yet again.
Mr. Brooks, I've not held you in contempt. I've found that you have forfeited your right to be present by your conduct, which is one of the options available to this court under Illinois versus Allen, under State versus Vaughn. It's also referenced in State versus Anthony. So I am going to keep going, sir, despite your protestations.
Your Honor, with all
I
due
need you
respect,
to
in Illinois
not
versus
interrupt
Allen,
me.
in
This is
Illinois
another
versus-
interruption.
In Illinois versus Allen,
Mr. Brooks,
do
I'm
they
not
say-
going to have a debate with you on
I'm
the
not
meaning
trying to
of
have a
Illinois
debate.
versus
I'm not
Allen.
trying to have a debate.
You
I'm
are
merely
advised
trying
that
to
a
understand
continued,
Illinois versus Allen.
Mr. Brooks, you are advised that continued interruptions will result in you forfeiting your right to be present during this next phase of the trial.
Okay, but you saying that I'm
I've said
forfeiting
that
my
multiple
right.
times.
You
I've
saying-
given you multiple
You're
opportunities to
holding
stop
me in
interrupting
contempt.
me.
You're holding me in contempt
Mr. Brooks,
by
I'm not holding
removing
you
me
in
from the
contempt
courtroom.
for the second time here, and I've
Your
also
Honor.
repeated that.
Your Honor,
He's
with all-
interrupting me yet again.
with all
Mr. Brooks, I
respect-
need you to stop talking.
With all respect, in Illinois versus Allen,
All right, Mr. Brooks continues to want to debate with me the meaning of Illinois versus Allen. It is a clear indication to this
I'm
court
trying to
that
understand,
he
Your Honor.
wants to disrupt these proceedings, even
That's
in a
not true.
mild manner, tone
That's
of
not
voice.
true.
I've
I'm
reminded
seeking
him
to
repeatedly
understand, Your
regarding
Honor,
the standards
because
of
it
form and
doesn't-
civility, and one of the
Illinois doesn't.
bedrocks is that he
Illinois
not
versus
interrupt.
Allen does not state.
All right, I'm going to
that-
remove him to the next courtroom so that I can go through
It does
proper
not state-
advisements with him without being
It
interrupted.
does not
We'll clear the
state
courtroom
that
and
you
we'll
can be
resume
present from
once he
cameras.
is over there. Again,
It
I'll make
doesn't
the
state that
appropriate
you can be
findings when
present
he is
from
there.
cameras, or that you could be,
Yes, we're off the record.
or that you
until,
could be.
he's in the
Okay,
other
so
courtroom. I'll
you're
be
making a
stepping off.
tacit agreement for something that I.
So here we go. Darrell Brooks, man. Darrell Brooks. World class jackass is where we're at, man. We have missed. I didn't miss him this weekend. I don't know about you guys, but I really did not miss looking at this face all weekend. What a guy, man. I know we have a couple minutes here, so I'm going to grab a couple quick videos. That's industry slang for videos. Yeah, I did it for you. We can take a look at that. From last week, that man, this guy, it blows my mind how much of a raging tool shed this guy is. But let's let me show you this here real quick. It's what is Brooks' defense? A lot of people are asking questions. I don't think that he has a real definitive answer for that. If you were to ask him, I think he'd give you a list of 10 things that he's hoping to accomplish, all of which are asinine, because he's, Well, let's see what some of the pros have to say here, and some of the things that he's done here with the judge. So this is one of the few breaks. This is one of the breaks that we took last week. This is some of the outbursts that we've had to look at with this guy, and man, just a class act, real class act guy. There we go. All right. So this was this is when he gave the judge the icy stare. She even felt threatened and ended up having to cut to recess. So
Want to run the record back?
Mr. Brooks,
So I'm the only one. I got one.
Mr.
I got one
Brooks.
ear that work, and I heard that.
this
Come on,
is to benefit you so that
No, it's
you
not.
understand
Ain't none of
your
this to benefit
witness
me. So let's
has
be
a
clear about
prior
that.
record.
Your Honor, when I leave the table, I'm away from the courtroom and I have to elevate my voice. This is the
So she had to
alleged
elevate her
record
voice
of Abel
just for
Lescott.
that.
Stop talking.
Come on, man. Like, I don't know who y'all be thinking y'all fooling. I'll set the value in return for value this document.
One more interruption and you're going to be removed to the next
That's
courtroom.
what you want to do.
put him in timeout.
It's not what I want to do. Do not interrupt Attorney Opper.
So can
Your
you
Honor,
tell,
I
can you
believe he
please-
has 7 prior criminal convictions
Yeah, and
via OWI second from
he just
1997.
slammed on the desk.
And OWI third from 1997.
Yeah,
And OWI fourth from 2003. Criminal trespass to dwelling from
Man.
2006.
All right, I need to take a break. This man right now is having a stare down with me. It's very disrespectful. He pounded his fist. Frankly, it makes me scared. And
what's
we're
messed up is
thinking
that it makes the judge feel scared, right? Like this judge is in a position where she feels intimidated by by this clown, that she'd be in a position where she'd even have to feel some sort of way, it's really pretty unbelievable, I just want to make sure that we're not missing anything from the trial. All right, cool, we're good there. What else do we have here? Sorry about the cameras, guys. I'm gonna be playing that for a little bit as well, trying to get that dialed in. This also was from last week. This guy, man, he is without the ability to not be a highlight reel of stupidity, and it blows my mind that at one point the whole courtroom started laughing at him, and yeah, let's just, the clips are the way that he is questioning her verdict or her jurisdiction and the way that, and the things that she's presided over. She's made it clear there are certain things that I will and will not allow. There are certain things that, she's gone through proper court proceedings, and he just can't seem to wrap his head around the fact that he's not getting his way. He's throwing fits. He's throwing these little tantrums. And
How are some of these answers allowed to pass when they're coming straight from reports made by the people on the stand? Very curious.
I don't understand your question. I'm not sure what you're asking me.
I don't think he knows.
What I'm asking is, reading from the report that the people on the stand are giving, the report that they gave to law enforcement.
If you're asking me whether there's a mechanism in the rules of evidence and how to establish that before the jury, the answer to that is yes. If you're asking me,
oh, they kicked him out. Okay, so that's where we're at right now. So we're back in court. He's been removed. He's probably reading the Bible again.
record that this morning, although Mr. Brooks was not raising his voice, there were repeated interruptions.
Of course, we're in another courtroom
wanted
again
to debate
because he can't handle.
rulings that I made
being an
after
adult.
the fact. Just this morning alone,
So yeah, share the
about
stream out.
26,
if you would,
27
please.
different times he interrupted me or spoke over me. Once I made a decision on his motion to dismiss and his request to recall a witness, he then asked if for written findings. I denied that. He then asked for what law I was following. I indicated I wouldn't explain that further, that I already made an oral ruling. He asked for a stay. He asked for dismissal. All of those things I either denied or said I wouldn't answer, specifically as it relates to the request for an interlocutory appeal, since I would not be the judge or court to which a request would be made. That is something that would be made to the Court of Appeals. And although I would have authority to grant a stay pending appeal, there is no appeal that's pending. I gave Mr. Brooks multiple
He's
opportunities
5'8",
to
I
stop
think.
talking. I asked him
Trailhead,
repeatedly to
464.
stop interrupting me. I advised him that if he continued, he would forfeit his right to be present in this courtroom and would be taken to the neighboring courtroom.
He's hiding behind the
I believe
Bible.
I gave that warning at least twice. Of course, this comes on the record before this court over the first 15 days of trial, where Mr. Brooks has, by his conduct, forfeited his right to be present on a number of occasions due to his conduct. I do appreciate that this morning he didn't yell at me, he didn't raise his voice, he didn't speak in an angry tone. But given the history in this case leading up to today, and knowing what this court needs to get through in terms of whether he has any witnesses or whether he intends to testify himself, there's a very important colloquy I need to have and an advisement of his rights that I need to go through. And I simply am not able to do that with him constantly interrupting me and then not respecting the oral rulings that are made.
He said, Judge, I ain't listening to your cauliflower. I don't care what you say.
Has to be brought back over to this courtroom under Illinois versus Allen. Of course, he needs to
Not be a tool shed.
Pledge that he is willing to conduct himself consistently with the decorum and respect inherent in the concepts of courts and judicial proceedings. I, of course, have repeatedly, even without him making such a pledge, brought him back into the courtroom where I felt a sufficient time has passed. And he, at many times, has been able to conform his conduct. I would note during the vast majority of the testimony that was provided during the state's case, he was in the courtroom. If not during the entire time, he was able to cross-examine witnesses. We had a couple of issues during the testimony of witnesses he called. And of course, last Friday was, in my opinion, probably one of the most challenging days, I should say, to date. It's my hope that we can continue with Mr. Brooks in this courtroom. At some point today, I'll certainly invite him back over when I get through these advisements. Mr. Brooks, you have been muted. I will make that, put that on the record as well. I will unmute though and ask Mr. Brooks, because you did not answer the question previously. Other than you potentially testifying on your behalf, do you have any other witnesses present at the courtroom, at the courthouse to call today? I need an answer to that question, sir.
So we addressing subject matter jurisdiction that we haven't addressed when I was just over there, or since I've been over here? Are we addressing subject matter jurisdiction?
I'm going to mute him just for a second. No, I'm not going to address subject matter jurisdiction. This is a common ploy by Mr. Brooks. When I attempt to go through certain things with him, ask him questions, he tries to divert our attention away to subject matter jurisdiction. I have issued a written decision on that. He has not filed any type of interlocutory appeal regarding that. This court's position is there is subject matter jurisdiction, and I'll deny verbally and orally at this point his request to dismiss the case based on a lack of subject matter jurisdiction. Mr. Brooks, I will be asking you a couple of questions. I do need a response. I am unmuting you. Do you have any other witnesses other than yourself available at the courthouse to call this morning, meaning now?
This is the jurisdictional challenge right here. So are you going to address subject matter jurisdiction and prove it for the record or not?
So I've asked Mr. Brooks twice now whether he has any witnesses to call other than himself. He has declined to answer that question. Sir, if you fail to answer that question, I will interpret your failure to answer that as a no, and you will lose the opportunity. You will forfeit the opportunity to call any other witnesses on your behalf other than yourself. So I will ask you one last time, sir, do you have any
Please
other
call
witnesses
yourself.
At the courthouse available to testify
Pretty,
right
please
now?
call yourself. I would, the best day of all of our lives
I'm
is
not
if he
getting a
calls
response
himself.
at all.
Like amazing,
You've been unmuted,
go
sir.
back and forth questioning, object to himself. Shut up, dude. Well, you're unmuted, so there you go.
Well, me muting you doesn't affect you being able to hear the court because
Yes, it does.
that only
Yes, it does.
mutes your audio coming into this courtroom. I confirmed already
Why is my
that
audio muted to begin with?
that is simply a misstatement. I
'Cause you're a
confirmed
raging
with the
asshat.
bailiffs that the audio and visual were
Why is
working.
my audio muted to begin with?
Because you interrupt the court repeatedly. So I'm going to ask you yet another way, even though for 3 times now he has failed to answer this court. You indicated last week that you would like to call your mom as a witness, Dawn Woods. You were provided with notice that the state would not be assisting with that in any way. You indicated when that was said that if you wanted your mom to testify, she would obey you and she would be here.
That's exactly
So
what
I
I said. I
trust
tell her
that
to be
you've
here,
made
she'll be here.
arrangements for her
I
to
tell her
be
what to
here.
do, she
Are you
show up.
going to call Dawn Woods as a witness this morning and specifically now? I will
Are you
ask
talking
you
to
a
a
second
ghost?
time, sir. Do you have Dawn Woods available to call as a witness this morning?
He's always looking somewhere, man.
He's been unmuted though.
He knows he's
For a
unmuted.
while now.
He
You can
knows.
obviously hear him.
Headphones on, I heard it.
I will ask Mr. Brooks a third time for the record. He's finally putting on the headphones.
He's not.
Is Dawn Woods
She
in
just
the
doesn't have-
courthouse
he has headphones on,
available
so.
to testify right now? Do you intend to call her?
Hold on.
I'm not ready to talk yet.
For the record, Mr. Brooks only puts on the headphones when he's in the other courtroom. He does not put them on when he's in here. The audio and the visual work just fine in that courtroom.
When I'm in the actual courtroom, I can hear it. I don't need to be muted.
Mr. Brooks's statements that the audio doesn't work when I mute him is simply false.
I didn't say nothing about the audio not working, so you need to stop lying on the record.
I'm not lying on the record, sir. I've
You are
confirmed.
lying on the record.
All right, I'm going to mute him once again because now he's raising his voice. Now he's angry. He's thrown the headphones. He certainly does not seem to want to answer any of the questions this court has. I asked him 3 times if he had any additional witnesses to call. I warned him that if he did not answer that question, he would forfeit his right to call additional witnesses other than perhaps himself. I then specifically asked him about Dawn Woods because that is the person he indicated he wanted to add to his witness list last week, and I granted his request to do that. I asked him twice. He did not respond to that. Based upon his failure to respond, based upon this court advising him that if he failed to answer that question, he would forfeit his right to present any additional witnesses, again, other than perhaps himself. I'll find that he has forfeited his right to present and call any additional witnesses based upon his conduct in this case. I would direct Mr. Brooks to the case of State versus Anthony, although that squarely dealt with a person's right to call to be themselves a witness in their own case. They talk at length in that case about how rights even constitutional rights can be forfeited by conduct. Of course, the right to be present can be forfeited by conduct. That was established in Illinois versus Allen. And then the right to present evidence on your behalf can also be forfeited based upon conduct. Although a criminal defendant does have a right to present a defense, doing so must be guided by the rules of evidence, the rules of procedure, and also with respect for the dignity, order, and decorum that is needed in the courtroom. Mr. Brooks has demonstrated this morning that he is not willing to answer simple questions about calling witnesses. He reverts back to raising the issue of subject matter jurisdiction, which, as this court has previously found, I believe is simply a distraction tactic, a delay tactic, and a disruption tactic.
Yeah, 100%.
When considering that the court must be concerned not only with the defendant's right to present a defense, this court must balance that with preservation of dignity, order, and decorum, and the numerous procedural and evidentiary rules that control the presentation of evidence. Because in my findings today, Mr. Brooks has been unwilling to answer simple questions regarding the calling of witnesses. Again, I'll find that he has forfeited his right to present further witnesses. I would like to go through a number of advisements with Mr. Brooks regarding his right to testify. I will unmute him for that.
Here comes the argument, right?
I ask Mr. Brooks to put on his headphones if he is unable to hear me, and just to be 100% safe and secure on the record, I'd ask the bailiffs who are over there to advise him. I'm going to directly be speaking with him, and if he's unable to hear me, to put on the headphones at this point. He's unmuted. I've also been advised by not just the bailiffs who are over there, who I can hear through the audio, but also from the clerk who's in that courtroom, through my clerk who's in this courtroom,
Yeah,
that
he
the
can hear.
audio
He
is
knows what's
very
going on.
loud and clear.
Yeah, he's very
Mr.
aware.
Brooks, I would like to go through with you your right to testify and your right not to testify. We are at the stage in the proceedings where it is important that this court conduct a colloquy with you. I will advise you that if you
He said,
refuse to
"I listen to
answer
your
my
cauliflower."
questions, refuse to acknowledge me,
Oh, so many
you
sound
can
bites.
forfeit your right to testify on your own behalf. Again, that's State versus Anthony, 2015, Wisconsin, 20. Mr. Brooks, you need to be aware and are so advised that you have a constitutional right to testify. Did you hear me say that? There's no response by Mr. Brooks, and he does not have the headphones on, and he has a book in front of him, although I haven't seen a page turn. If you testify, sir,
She just
the state has the right to cross-examine you.
Sure.
That means to ask you questions after you give your initial testimony.
Please testify.
Did you hear me advise you of that?
Yes, he heard. Oh, he's got his headphones off. So now they're going to turn
No
the speaker
response
on.
by Mr. Brooks. Sir, you also have a constitutional right not to
We just need a
testify.
bullhorn.
If you decide not to testify, you are further advised that doing so cannot be used against you, and I would so advise the jury. Did you hear me advise you of that?
I think he did.
Once again, no response by Mr. Brooks. The decision to testify is for you and you alone to make. Did you hear me say that? There's no response by Mr. Brooks. It's my understanding that Mr. Brooks has the equivalent of a 12th grade education. that he attended school either up to or through 12th grade.
Got a PhD
and
and being a
either has
douchebag though.
GED or an HSED. There's been some conflicting information on paperwork throughout this case, but I'll find that he does have a high school education. He is currently in custody,
Good for him.
of course, at the Waukesha County Jail. I'm not aware of any medication that he has been taking. Sir, have you taken any medication within the last 24 hours or any drugs or any alcohol?
What's up, Joey? Check in. Where's everyone watching from right now?
I'm not
Just
receiving a
curious.
response to that. I'm aware that he's able to read and write English. I would refer back to the record made during my colloquy with him regarding the waiver of counsel and his ability to be aware of rights, his ability to, I made a finding at that point of his understanding, and based upon his conduct throughout this trial, including the waiver of right to attorney hearing, I'll make a finding that he has the ability and understand, he can read, write, and understand the English language.
Am I unmuted?
You've been unmuted the entire time, sir.
So what are you talking about? Is you talking about subject matter jurisdiction and how you gonna verify it on record?
So he did,
Prove it on record?
he did
Now
not answer my
He said,
question.
wait,
if the
you've been
record's
talking to me
not
this whole
clear
time?
About whether he's had any
Oh,
drugs,
what's up,
alcohol, or
PA?
medication
Betrayal,
within the last
Wisconsin.
24
Yeah.
hours.
Minnesota.
I'll ask him, sir, has anyone made any threats
Mucka.
against you to influence your decision on whether to testify on your behalf in this trial?
Mucka, Mukwano.
Although he turned and said, what did you say? Again, I believe he's fully able to hear this court at this time based upon how the audio is functioning in the other courtroom. He did not respond to that. Has anyone made any promises to you to influence your decision?
You saying. So if you can hear me, I don't hear everything you saying, and you know I don't hear everything.
Because he takes his headphones off like an idiot, and he acts like that's an excuse.
Mr. Brooks is interrupted with very disrespectful words at this moment.
Mhm.
I believe that he is feigning his inability to hear and that he's done so throughout this case. There's absolutely no indication. He puts the headphones on when he wants. He takes them off when he wants to. While in this courtroom, he hasn't had them on. He's only used them while in the other courtroom. But again, I've confirmed multiple times that the audio is loud and clear. And his statements that he can't hear, his statements that when I mute his audio, that it mutes his audio, are simply false.
Karen, you're a rock star, man. You're coming through with all the legals.
Mr. Brooks, have you made...
Am I still unmuted?
You are, sir. And I'll make a record that per the lieutenant over in the other courtroom, the
Looks like
volume
a
is
balding
2 times
8-year-old.
louder than it is in this courtroom.
You need to stop making false records saying that I said I can't hear you at all. I said I have trouble hearing you when I'm over here.
No, you don't.
That's what I said.
The bailiff hears
So
you.
I would appreciate it
God
if you
hears
make
you.
the record clear and correct.
Clearly,
You need
you heard me
Jesus.
say that for him to make that distinguishing
Yeah,
statement.
I'm sitting right
So-
here. Don't you see me looking all up to the microphone?
No one can see anything.
I don't have an issue hearing you at all, sir.
Can you hear me when I'm right here?
I can.
I can.
Once again, per the lieutenant who's been in both of these courtrooms, the volume in the adjacent courtroom where Mr. Brooks is at is 2 to 3 times louder than it is in this courtroom. Mr. Brooks, have you made a decision?
What about this courtroom?
Have you made a decision to testify in this case?
Now, have you
Oh,
made a
this guy.
decision to tell
I
me
will ask you
so
again,
I
sir.
jurisdiction?
Have you made a decision to testify
Have you made a
in this
decision to
case?
address subject matter jurisdiction? Have you made a decision to be impartial? To answer what your name is? To answer if you have a claim against me or
I'm
don't
going to
you
mute him
have a
for the
claim against
moment just because once again, he's
Click.
attempting to divert away from what this
Click.
court needs to do
Oh,
by
the
going through the proper colloquy.
You guys
and
know this
regarding
whole
his right
case
to
would have been
testify.
2
He's
days
asking me
run and
about
done.
subject matter jurisdiction. He's making
Yeah,
statements
riding dirty.
about this court that are disparaging and about my oath. Again, a
Oath.
clear attempt, in my
That was very Wisconsin.
opinion, to
Wolf,
simply stall these proceedings and to
Palm
disrupt
Beach,
them.
Florida. What's up, Shannon?
I will unmute him and I will ask him for a third time with the understanding that if he fails to answer the question
He's an
in
idiot.
the affirmative, I will interpret his failure to respond as a no and that he is not going to testify. So once again, I am
All right,
unmuting
Destiny.
him.
He's running out of time
Sir,
and he knows it.
Have
He's
you made
running
a
out of
decision
time.
on whether to testify in this case?
Share the stream, guys. We're getting down to the final hour here. We're definitely past the 11th hour now. We're at
There's
a
no
point
response
where
by Mr.
this
Brooks.
is getting
I
to
will
that
ask it
point
yet
where we're going to be
another
able to
way,
have
sir.
all the closure of
Do you
sentencing
want
that
to
we've been looking
testify
for.
on
So
your behalf in this case?
definitely share the stream, guys.
Yes, you have been.
We
Sir,
can
do
finally
you
get rid of
want
this
to,
asshat again.
How long have I been unmuted? 'Cause you just
sir, do you want to testify in
just
this
said
case?
you was muting me when I had the headphones on just a minute ago. You just said you was muted. So when have I become unmuted? Or did you?
When have I become
in the
unmuted?
first-
Oh man, I got so many sound bites I
Mr.
want to
Brooks,
for you guys.
I'm asking you one last time. Do
didn't
you
ask
want
me
to,
nothing because I haven't heard nothing that you asked. So how you gonna ask me something and then just answer for me?
Mr. Brooks, do you want to
You can't answer
testify?
for me.
All right, I'm
You
going
can't
to
answer for me.
answer. I'm going to
You
mute
can't
him
answer
again.
for me.
Again, it is very clear to this court that he uses the statement that he can't hear as a means to delay. It's a distraction. It's very evident that he hears this court and that he's choosing to willfully not answer this court. This court, as I indicated earlier, is tasked with the duty to ensure that there is efficient and effective presentation of relevant and probative evidence in this case. This court is attempting to go through the needed colloquy with Mr. Brooks, and he at all times during this colloquy has refused to answer simple questions. I personally do not want to make this more difficult, but I must establish these ground rules that he must answer these questions in order for this court to make the appropriate findings. Without him providing answers, this court is left with no choice but to find that he is forfeiting his right to testify on his own behalf. This court must also preserve dignity, order, and decorum. Again, ensure relevant and admissible evidence is presented, and also honor the defendant's right to present a defense. The simple requirement that he answer questions is required, frankly, due to the defendant's prior conduct throughout this trial. His repeated defiance, his repeated outbursts, his repeated failure to follow simple rules of courtesy and decorum, his repeated interruptions of this court, and this court having to repeatedly remove him to the neighboring courtroom and making findings that he has forfeited his right to be present. Of course, this record is abundantly clear at this point that Mr. Brooks is not even in the main courtroom, because this morning alone, he is yet to conform his conduct to the simple standards of courtesy and decorum that are required of all participants in these court proceedings: the court, the prosecutor, the defendant, the jurors, the public. Absent an adherence to these simple rules, including the rules of evidence, the rules of procedure, and the rules of civility and decorum, and without a pledge by Mr. Brooks that he will follow these things, then on balance, this court will find that he has forfeited his right to testify. I've now made a much more full record of what is at stake, and I will give Mr. Brooks an opportunity again to go through the colloquy with the court regarding his right to testify. I am unmuting him and will attempt to go through this procedure once again. If he fails to answer these questions, then he is forfeiting his right to testify by his own conduct. I would acknowledge that such a procedure is certainly not ideal, or making a finding that he is forfeited is not ideal, but as Mr. Brooks's conduct and Mr. Brooks's conduct alone that has forced the court to make this determination. So Mr. Brooks, you are unmuted. You have been for about a minute. I want to go through the questions again. Are you aware that you have a constitutional right to testify? Mr. Brooks, are you aware that you have the constitutional right to testify?
Are you aware that you're practicing law from the bench?
Mr. Brooks, do you understand and are aware that you have a constitutional right not to testify?
I don't understand. No, I don't understand.
Are you aware that you have a constitutional right not to testify?
I don't understand, and I'm not aware, so why are you asking me questions?
All right, I'll do this another way, sir. Sir, you are advised that you have a constitutional right to testify, and that if you choose to
I don't
testify,
understand.
that you would be subject to cross-examination by the state. Did you hear me say that?
I didn't hear you say anything. I don't understand what you're asking. I don't
He is
understand.
willfully choosing not to answer that. Sir, you are also advised that you have a constitutional right not to testify.
Your Honor, with all respect, you've been trying to.
Did you hear me say that?
answer questions for, I didn't hear you ask me anything. And I
Sir?
don't understand.
Stop talking and I'll ask it again. Sir,
Can you ask me to stop talking in it?
I'm asking you to stop interrupting me so that you can hear the questions. Even though I fully believe you hear them, I will attempt to do
I
this
got the
one last
headphones on.
time.
You have to hear them. I got the headphones on.
All right, then let's,
Obviously, you can see that.
once again, Mr. Brooks is being disrespectful. He is
That's not being
blurting out
disrespectful. I'm saying-
information.
I'm saying
He
you're
reverts
right.
back to subject matter jurisdiction. He
saying you're
accuses
right.
this court of not honoring its oath. He just accused me of practicing
haven't.
law without a license. Again,
You
all
No,
attempts
I said
to
practicing law
deflect
from the
away.
bench. I
I'm
said
gonna mute him
practicing
once
law.
again. This court has simply tried to no avail to get Mr. Brooks to answer simple questions, confirming on the record that he has been advised that he has a constitutional right to testify, and that he also has a constitutional right to testify. I was very clear prior to unmuting him and telling him that I would go through these questions once again, that I needed him to follow the rules of decorum and civility and not interrupt this court. He has done nothing to demonstrate decorum. Again, repeated interruptions. It is, again, from my perspective, simply a tactic on his part to delay these proceedings, to disrupt these proceedings. He reverts back again to things like subject matter jurisdiction, practicing law without a license. Then he makes requests about interlocutory appeals, etc. The record is full of his tactics in this case. He would not pledge to be civil, to be courteous. He would not pledge to honor the rules of evidence or the rules of procedure. He would not even answer simple questions regarding his right to testify and whether he heard that or not. And based upon pursuant to State versus Anthony, and looking at the balancing test that this court must consider, this court simply cannot allow Mr. Brooks to get on the witness stand unfettered without an acknowledgement that he will honor the rules of procedure, that he will abide by the rules of evidence, that he will honor rulings that are made by the court. He has demonstrated repeatedly throughout this trial that when this court makes a ruling that he disagrees with, he tries to engage the court in an argument about the legal basis, even though I've provided the legal basis on the record, or in the case of subject matter jurisdiction, even when there's a written determination on the issue. When looking at State versus Anthony, this is a case where the Wisconsin Supreme Court was faced with a similar situation, although not as egregious as I would say here, because in State versus Anthony, that was not a case where the defendant was ever removed from the courtroom based upon his conduct. Although in State versus Anthony, they noted it isn't a requirement to forfeit your right to testify to previous to that be removed from the courtroom. So not as egregious as a case, but this court has a history over 15 days of trial where Mr. Brooks has repeatedly been removed from the courtroom, where he has repeatedly demonstrated he has absolutely no regard for courtesy and decorum. He is what I would describe as a stubbornly defiant individual who simply wants to say what he wants, when he wants, without a filter, without regard to the rules of evidence and the rules of procedure. As State v. Anthony discussed, the right to testify, although a fundamental constitutional right grounded in personal autonomy, is not absolute. For example, there's no constitutional right to commit perjury. There's no constitutional right to present irrelevant evidence. Moreover, a criminal defendant's right to present relevant testimony is subject to reasonable restrictions. Those restrictions, again, fall primarily under the rules of evidence and the rules of procedure. The court in Anthony cited the U.S. Supreme Court from Arkansas versus Rock, wherein that court stated the right to present relevant testimony is not limitless and may in appropriate cases bow to accommodate other legitimate interests in the criminal trial process. For example, numerous procedural and evidentiary rules control the presentation of evidence and do not offend the defendant's right to testify. Throughout this trial, Mr. Brooks has repeatedly accused this court of violating his First Amendment rights of free speech. I've told him repeatedly his First Amendment free speech rights are not unfettered and that they are limited in the court of law for the very reasons cited by the Supreme Court in Rock. The takeaway from Arkansas versus Rock is that a defendant may forfeit his right to testify by his conduct. Whether a criminal defendant may forfeit his or her right to testify through conduct incompatible with the assertion of a right was reviewed by that court. That court went on to discuss waiver and forfeiture and ultimately went on to conclude the following. We now conclude that the right to testify may in appropriate cases be subject to forfeiture where conduct incompatible with the assertion of the right is at issue. The balancing test that this court must go through are the interests, again, as I've already stated, for the rules of evidence, the rules of procedure, civility, and decorum, and balancing all of that against Mr. Brooks's right to testify. This court is not making an arbitrary decision. The decision I make here today is, in my opinion, proportionate to the conduct demonstrated by Mr. Brooks throughout this trial, and specifically today, based upon his failure to even engage the court in a simple colloquy regarding his right to testify and his right not to testify. He was repeatedly warned that the failure to answer the questions would be taken as by this court really as no, meaning the specific question, have you made a decision? And as for all of those reasons that this court will make a finding, he has forfeited his right to testify. With that, then, there are no other witnesses to present for the defense. Before I bring the jury out, I'll ask the state if you intend to call any rebuttal witnesses.
We have no rebuttal case, Your Honor. Thank you.
All right. I would like Mr. Brooks to be brought back over so that he is present in the courtroom when the court advises the jury that the defense is resting. I realize that will be over his objection. I'd ask that he honor that. Mr. Brooks, I'm going to unmute you. If you can pledge to this court that you will honor that ruling and that you won't challenge that directly in the presence of the jury, I will bring you back over for that. Are you willing to make that pledge, sir?
Make what pledge? I'm not making no pledges.
Sir, you
asked me a question, now I can't answer.
Yeah, no, go ahead, answer.
You're trying to coerce me into violating my right to remain silent. How can you coerce me into my right to remain silent? So you're not going to protect my constitutional rights? Because I didn't answer nothing that you was trying to ask me before when I had the headphones on, and you can't make a decision for me.
Yeah, well, you made the decision for yourself by not making the decision,
You're
and that's
violating
kind of
my
how it goes.
constitutional right.
Sir, if you'd like to testify, then you need to simply go through the colloquy with this court, which I've given you 3 opportunities to do, and you have decided not to.
When I know, you can't tell me what I decided.
Just ignoring and not wanting to answer doesn't give you carte blanche to just be a douchebag and not
Are
do
you
anything.
By
willing
law,
to-
you can't- Your Honor, by law, you cannot coerce me.
I'm not coercing you, sir.
Well, you're making a decision for me based on something that I did not say myself.
Last Friday, I specifically directed your attention to State versus Anthony. I discussed very briefly at the end of the day on Friday the case law that is relevant on this topic, including State
he knows
versus
he's cooked,
Anthony,
man.
Rock versus Arkansas,
Friday.
and Chambers versus
he
Mississippi
knows.
to specifically put you on notice.
He feels the
Mr.
dark,
Brooks,
cold
I'm gonna mute
abyss
him. Again,
creeping in
I'm
from
not
behind
gonna
him.
have a debate. I've made a finding. I've given him yet another opportunity. If he's willing to go through the colloquy with the court, he wants to challenge me instead.
He
and
called
say
it cauliflower
doesn't
earlier. It was
consent.
hilarious.
His lack of consent to this entire procedure is noted for the record. Based on his inability to pledge to this court that he will honor that ruling and be respectful of the jury, I'm going to leave him in the other courtroom. The jury's going to be brought out, and he will remain muted, and I will simply advise them, as I have throughout this case, that he's appearing from another courtroom and that his appearance from the other courtroom should not in any way be held against him or influence their verdict in any way. I will tell them that there are no further witnesses for the defense, and then I'll ask the state if there is any rebuttal, and then the jury will be excused for the day because we will have I anticipate will be a very lengthy discussion on jury instructions. Again, I will advise Mr. Brooks that if at any point in time he wants to come back over, he needs to advise the bailiffs, but it does need to be accompanied by a pledge that he will follow the rules of civility and decorum, and he will not specifically challenge the court's rulings regarding closing off of his ability to call witnesses or testify on his behalf. All right, let's have the jury brought out.
At this time, I'd like to encourage everyone that's in here to set up notifications. Keep in mind that regardless of how this goes today, there's going to be process and procedure we're going to have to go through. Excuse me. We're not done. So, yeah, you guys, if you would, please make sure to set up notifications. What you have to do is follow the page. Go to CJTV Media, follow the page, and then I believe you'll start getting notifications that way. If not, set up notifications. If you're on YouTube, also there. If you're on Twitch, Rockfin, Twitter, whatever, we're live on all those platforms. Notifications are important. So when I schedule things, you'll get that, and you can kind of put it on your calendar, get reminders, because I know a lot of these things kind of slip past, early mornings especially. So yeah, it's a big deal. We're in the final hours here. Today is going to be kind of a protocol procedure type thing, and then we're going to move into what's going to be who knows. I'm curious what you all think in the comments here. How long will the jury take for their decision? I'd like to have everyone chime in, comment in on that. And then also, do you think he's going to beat
Thank you,
this?
everyone. Please be
Thumbs up,
seated.
thumbs down. Thumbs up, thumbs down. I'm going to put that in there as well. Yeah, in the question.
Ladies and gentlemen of the jury, at the moment, Mr. Brooks is appearing from another courtroom. This must not be held against him in any way and must not influence your verdict in any manner. At this time, I will advise the jury that the defense case is rested, and I'll ask the state whether there's any rebuttal evidence to present.
No rebuttal, Your Honor.
All right, then with that, I will declare the evidentiary phase of this trial concluded. I'm going to excuse
10
the
minutes,
jury
2
for the
days.
remainder of the day so that the parties and I go through all of the jury instructions. And I
2.5
anticipate
hours,
bringing you in
less than a day,
tomorrow
1 day.
morning. Instructions may very well take most of the day. My hope is to then have the closing arguments and then have the case be turned over to the jurors. If not by tomorrow evening, sometime Wednesday morning or early afternoon. With that, I'll rise for the jury then. Please turn your notebooks into the civilian bailiff.
Wait, what did she just say? Wednesday morning or Thursday afternoon? Tomorrow morning or Wednesday afternoon? My days just disappeared when she said that. What did she say for the timing on that? I don't know why I fully drew a blank on that one completely. Tomorrow morning if they finish the area. She said, mind you, there's like 100 pages of at 14-point font of jury
Before we begin,
instruction,
I will have
apparently.
Teresa
So
print off what at least we do have for both
this
parties.
will be
I'd like to take a short comfort break. I'll invite Mr. Brooks to come back over, and then we'll start with that jury instruction conference. We'll take about 10 minutes. Thank you, everyone. We are in recess.
So they're going to take a quick recess. They're going to do right now. They have to do jury instructions. Yeah, he does. I'm going to pull up just. I'm just going to start throwing some clips up here that are just to me brilliant, showcasing the type of idiot we're dealing with here. He's really, you guys, he's one in a million. This guy is to his credit has really just showcased to all of us honestly where the system has dropped the ball. He's danced through the system since he was 17 years old. He's gotten little to no charges for the things he's done. I mean, in all sad honesty, Darrell Brooks has done a phenomenal job of laughing in the court's face, and he's doing it this entire trial. You know, they're 16 full, I think, days in, and 13 days into the litigation of this, and he's maintained just a laugh. You know, his entire decorum has been just completely. I guess you could say it's been a perfect example. Of exactly how defiant people can be when they've been taught through the course of their life that they can get away with it. I'm not saying you gotta, kick the kids down a flight of steps, but spare the rod, spoil the child. I think that at some point, this guy, even the way he talks about his mother, the judge made a point about saying something. She said that that if he ordered his mother to show up, she would obey. That's almost like, I swear I'll pull it up almost word for word, how he flexed. It was a flex moment for him where he was like, they said, we could send a subpoena to your mom. And he said, if I tell her to show up, she'll show up. She does what I tell her to do. Ain't no question about that. If I tell her to be here, she'll obey. And it was one of those things where if you don't, I mean, anyone in here with any therapy that's gone through therapy, I think we all, if we haven't, should. Anyone who has any psychology background of any kind, or is just aware of human cues, that right there showcases in the best form exactly his view of not just women, but of people. He feels that he can control the world around him. He feels that he can tell people what they will and won't do. He has a, it's funny, as you've heard this term a lot. I have a lot, not towards me, but out in the ether. That toxic masculinity, and and usually it's one of those like, all right, man, come on, stop generalizing and saying things. I get it with this, that's toxic as hell to think that your mother is going to obey you if you tell her to do something. It just blows my mind. But the way he's dealt with all the women in this case, and then you watch him deal with men night and day. Go back to Abel. That guy they had gone over his extensive criminal history, and he had, I think, seven charges. The guy had done time. You know, he was a stylist. And they were basically saying, we're not going to dig into your past. We're going to acknowledge that you have one, move forward, right? And while doing that, Darrell Brooks, this whole, you know, tough guy, bravado, the whole shoulders back, you know, chin out, swagger that he puts out there, fully disappeared. It melted away. And it was amazing to watch how beta he went when an alpha stepped up on the stand. The minute the guy got up there and started answering questions, Darrell Brooks went from this tough guy to he wouldn't even look at him, and it's entirely symptomatic of what he's been doing in his life, getting skated through things. He did 11 months for statutory rape of a minor of his ex-girlfriend, who he impregnated at 15. He jumped through multiple assault, strangulation, and suffocation charges, assault and battery charges, resisting arrest charges, drug charges, failure to register as a sex offender. He's got a rap sheet that should have put him behind bars for 30 plus years. And he did no more than 3 since he was 17 for all charges, and was able to dance out of the jails on his own recognizance, meaning that they PR him, personal recognizance, saying that as long as you promise to come back for court, we'll let you out of jail right now. They were, they went through COVID. He was sitting on a $10,000 bail for past charges, for failure to register as a sex offender, for all these things that he was looking at, and assault charges, I believe. And he was able to get that mitigated down to $7,500 for one, because he wanted a speedy trial, because he knew how to work the system, knowing that the COVID had just ravaged the court systems in the whole world. And so he was able to pull that card. Well, the judge wasn't able to grant him a speedy trial, reduced his sentence or his bail by $2,500. Then he waited a month and a half, and put in another request. They couldn't do that, so they dropped it to $500. Basically, like, all right, just give us something and we'll let you walk. $500, never reported back. I believe the next time we see him is probably now while he's in holding after he assaulted his girlfriend, ran over her with his car. His ex-girlfriend, the one he beat up the day of the parade, the one that he impregnated at 15 while he was running her, as he put it, as a prostitute in Las Vegas out of Oakland. So this is the guy we're looking at. This is the guy we're dealing with. But this was him. This was him yesterday, just in his brash form of insubordination, if you want to call it that. I don't even call it that, because that shows that there's a certain element of agreed decorum. This is him just being a complete prick. You know what I mean? And it's nuts.
You don't call yourself a judge as much as bias you put up in here. Don't even tell the jury the truth. Got no integrity whatsoever.
This is him just talking directly to the judge right now. She's standing up there listening to him say these things.
None.
Thank you, everyone. Please be seated. I would like an update on whether Mr. Brooks filled out a subpoena for Don Woods and provided that to the state. Has that been done?
No, we haven't received anything, Your Honor, and obviously she can appear here voluntarily if Mr. Brooks wants to arrange that. I don't believe a subpoena is necessary. We had subpoenaed her, and she was under state subpoena. So I know that at least some point she had notice, but our position would be, Your Honor, that we will not be responsible in any fashion for producing Miss Woods. Mr. Brooks talks to her on a daily basis. If he wants her here, he can produce her on Mondays.
Yeah, they ain't got to worry about that.
So I just wanted to know, because I know a subpoena form was filled out.
If I want her to be here, she gonna be here.
I agree with
So
the
just
state
know
that
that.
she could certainly appear.
It ain't even got to be no arrangement. All I gotta say is come. She gonna come.
All I gotta say is come. She gonna
That's
come.
simple.
That's simple.
Mr. Brooks, do you intend to call her as a witness? Because I'm directing
Yeah,
you to have her here at 9
We said all
a.m.
that at the beginning, man. Like, I don't even want to be in here that much longer. Just do what you got to do so I can get up out of here. I'm tired of being in the courtroom that has no integrity whatsoever. How can you even call yourself a
Mr.
judge?
Brooks, I need to make a record of
I need to make a record too.
You don't.
When am I going to get the chance to do that?
All right. I need to make a record. He's being removed to the other courtroom. He is yelling at me. He's not going to let me make a statement or make the record that I need to make. He hasn't sat down for the better part of 2 hours.
You can't fire me. I quit.
I'm not holding you in contempt.
If it's criminal or civil, so I can hit you with you.
I need to clear the courtroom because I do need to make.
Give you what you know is coming.
I need him to go to the other courtroom because I do need to put some things on the record. The record should reflect
contract between you
that
I'm amazed
Mr.
people in the
Brooks is
courtroom
yelling at me.
What is the crime?
Shouting at him.
He is.
Who makes the claim? And what
He
is
is. I will make the record when we get back. I will step off, but Mr. Brooks, you're being
it?
taken to the next
Mr.
courtroom.
Brooks. Don't try to address me
Thank
like
you.
that, like we cool. You don't have no integrity. How can you even call yourself a judge? Making tacit agreements, being biased, judicial misconduct, trying to steal somebody's system.
So that, for one, that's Darrell Brooks. Real, just the joy of a human being. Here's another one of him. The DA. Okay, so this one is wild. So while he has his ex-girlfriend on the stand, Darrell Brooks decides that he wants to go ahead and do what he can to flex on her. He wants to make her feel as small as possible. This is the woman that he raped and impregnated at 15, mind you. So she's on the stand now for the second time, beaten and battered from this man multiple times and charged for it, charged as a child sex offender because of his rape of this woman, of this child. Fast forward, again, another beating, and then he runs her over, then beats her up again the night of the parade attack, has her on the stand and decides that he just wants to ask her questions like, well, do you have a job? Are you working? Do you have kids? Do you take care of your kids? Are any of your kids living with you? He knows she lives in a shelter, and he's asking questions that are absolutely unrelated to the case, doing it for no other reason than to make her feel small. Then he tries to flex a minute with trying to prove that she's not afraid of me, which has nothing to do with anything. It's just another opportunity for him to put a finger on top of her and, give a shove down on that forehead. He has these pictures, and he says, I want to go ahead and have her look at these pictures. He tries to have them slid up to her. They shut that down, and they're pictures of children, or pictures of a child, I'll say. A couple, I think 3 pictures. These were pictures of the grandchildren. That 15-year-old had a baby when she was 15 to 16. That child now has a baby, right? This is back in 2006, mind you. And there's grandchildren in this now. And those pictures he claimed were from her. But he wouldn't produce the letter or the envelope or anything that came in, just the pictures. The judge called him on it, said, no, there's no proof that these even came from her. We're not going to show these to her. We're not going to put these in as evidentiary findings for any reason at all. And during this argument, you can see the DA was really starting to finally get their cockles up, right? And she said, listen, if you produce a letter saying these are from, Ms. Patterson, we could talk about it. But there's no letter. And he said, why would I have these? Have you ever received a letter? Have you ever done this? And he's throwing all these wild statements at her. And really, he's doing what he did before when he was holding a statement. And one of the questions, when he was questioning one of the witnesses, I believe it was Corey, the woman who he also beat up the night, or slapped around, whatever you want to say, assaulted the night of the parade attack prior to driving through the crowd. He said, I have the report right here. Do you want me? And she's like, okay. He's like, do you want to change your statement? What you're saying right now? Under oath? No. I have the report. I'll read it. I said, go ahead and read it. He said, I'll do it. Are you sure you want me to? Yes, I do. Okay, well, I want to change the subject. And he put the paper down. And then 30 seconds later, he's like, well, I'm going to have to find that report. Like, he never had it. He does these theatrical, moments of showcasing, trying to be somebody who's not. Well, with these pictures, they asked him, they said, we're going to take a break. Feel free to go back to your cell. If you want to produce these letters, produce this evidence, feel free. And then finally the DA objected and said, I'm objecting. You know what? This is ridiculous. He's doing nothing more than trying to make her feel bad. He's trying to prove, which isn't proof, that she's a bad mother, which has nothing to do with this case, nor would it have any bearing, even if that was proved, and that, granted, that's just opinion on things. You know, I mean, everyone has a different life. You know, this poor girl was being raped and used as a prostitute when she was only 14, 15 years old. Like, the life she was living, to judge her for having gone through the life she's gone through and getting to the point where she's gotten, she got her CNA, you know, certificate. She was living in a women's shelter as of last November. You know, she had a bunkmate, Corey, who was supportive. You know, she found a circle of people actually that were there, that were willing to stick up for her. You know, we can judge people as much as we want by the things we see them do and their, you know, their personality, right? But the character comes through in people, like the guy, Nicholas Kirby, who was ready to climb over the state. He was ready to climb over the bench after Darrell Brooks, and while he was doing his examination. And then at the end, I'll show you. I'm done with him. Get rid of him. I'm good. I have no more use for this guy. I was just laughing because there was nothing about the examination during the questioning that was relevant. But she has people like him who was on a call, was on a run, like running. You see him running to try to go and defend her from Darrell Brooks. Her friend Corey, who stepped in and said, "No, don't go with him. We don't want you to go with him. We know how bad he is." He slapped her around. So, but trying to prove, and so the DA is saying, like, hey, he's trying to prove she's a bad mom. Has nothing to do with it. We know those pictures aren't from her. We have recorded phone calls from his mother where he's asking her to send him pictures. Then they backtrack these pictures, and they did come from his mother, and they might have been originally in the possession of Miss Patterson, but they had been given to a friend of hers at one point, and then his mother, had asked that friend if she could have those pictures so she could give them to Darrell. So there was no letter, like he kept claiming, that was sent from Miss Patterson straight into the jail to Darrell Brooks. So all of this, you know, the theatrics that he has here are, you know, perfect, par for the course. Well, but what the DA did say, and I'll show this video here in 2 seconds, was that he was like, and furthermore, Darrell Brooks is trying to prove that she's a bad mother. That would open the door for us to question him as a parent. He has no children with him. He has not paid child support. He's been brought up on charges for not paying child support. And furthermore, Miss Patterson, whom he impregnated at 15, was a minor, and he was convicted after pleading guilty to statutory rape of a minor, which he has not filed his sex offender status in any place he's ever lived. And Darrell Brooks lost it because he finally had someone calling him out. And well, here, I'll play the video. And it was, for me, it was a highlight moment, because, you know, it's exactly what we expect to see from Darrell Brooks. You know, this guy. You know, it's perfect. It's perfect, you guys. And so here we go. And here we go. Boom. So this is his response. Let's do this.
With all due respect, did the state have to put their witnesses in?
I'm sorry, but every time he says, "with all due respect," I gotta hit him with.
Or truthfulness or untruthfulness. It's not specific instances of conduct. It's character evidence, which frankly wouldn't even come from the witness.
Get up. Anyway.
Order and tell me.
It's irrelevant what the state did.
Did they have to do that?
They didn't need your assistance to do that.
Did they have to do it?
No, they did not.
I didn't have to be provided with. We're going to call this witness at this time,
but they're
this
able
witness at this
to
time.
contact
They
their
didn't have to do that, so why should I have to
and
do that?
accommodate their schedules. This is not about you. It's not about the state. It's about the witnesses.
It's about what's fair. It's about what's fair.
No, frankly, sir, it's about you trying to control what's happening. In this
How am I controlling what's happening?
Calls
I'm
him out.
Shackled to the table with
here's the
with a shock
situation.
device
It is
on my ankles.
9:52.
So how's I'm trying to control anything? I just want this
I'm
to be
going
fair,
to
and it hasn't been fair.
Mr. Brooks, it's fair.
No, it's not. If I have to do something that they don't have to do, how's that fair?
It's fair.
Explain to me how that's fair.
The process that it has been set up to frankly help you.
No, it's not helping me by it's helping the state
no,
by being able to say, if we know the time and we know the person and we know this, then we can be prepared. So we'll already be ready.
Mr. Brooks,
that was the whole aim of that.
And I would have had her come in later. You didn't want to answer that question.
There was no question. There was no question to answer. I did what you asked me to do, Your Honor. You said
you didn't.
yes, you did.
This is hilarious. Okay.
You asked me to
So real quick. So this is when they were talking about, and the other videos right here. I got it ready to go. But this is also funny because what he's talking about is how he had to provide a witness list and the time in which they were going to show up, like what order they were going to be there. And he refused to do that because I don't think he has any organizational skills whatsoever. All these boxes and all this stuff that's been prepared has been prepared by the state appointed attorneys prior to him firing them, if you will, and going self-defense pro se. So he's been self-defended since jury selection and on. So for the last 3 weeks, basically. So, but all of this case was presented by his defense team that was there. That I'm sure, thank God that they got released, so they didn't have to sit next to this POS and defend him. But now he's arguing about the fact that how is he gonna? Well, here, just
Give them my witness
Mr.
list.
Brooks,
I gave them my witness list.
Yesterday,
It's not my fault.
I'm very
It's not my fault they
expressly-
weren't gonna be prepared to
Mr.
do
Brooks,
their
here's the
to
deal.
do
The
their
jury's-
cross.
and what he's saying there, and sorry to keep stopping this, is he doesn't want to give them the list in order in which they are going to appear. And his effort there is to slow them down in being able to prepare any cross-examination for his witnesses. And if you guys watched Friday, every one of his witnesses, and Thursday, every one of his witnesses was 100% detrimental to his case, down to the victim's mothers, who he even objected to her testimony as she was being cross-examined by the DA. I mean, we were all in tears. We were all bawling. I mean, she had 4 children that he hit, and he was calling her statements and testimony hearsay. This fool. And so what he's trying to do is slow it down so they weren't able to provide any kind of questions. Not that they need any. With the witnesses that were called, there was no cross-examination needed. Just some clarification points, but there was no cross-examination needed. Everything was damning for his case.
coming out, and I'm gonna stand my ground on this.
I'm gonna
It-
stand my
it
ground
is-
too, but I'm
if
not
you
gonna
don't
be
call
disrespectful or disruptive.
If you
I'm just
don't
stating I
call
want it to be
her
fair.
When the jury comes back out,
Fair.
I'm releasing her from the subpoena.
You can't do that.
For
Law,
your
where's
lack
the
of
lawful law?
cooperation.
Lawful
Where's the lawful law? I have the
This guy
right to
is
You have to
witnesses,
cooperate with this process.
but I
sir.
also have the Sixth Amendment right.
We have a witness available for you to call. I can require
It's
you
not
to
the
call
witness
her
that
right
should have
now.
been called at this
Yeah.
time, Your Honor.
It is based on the list that you provided and
That
in
didn't
the
have a
order.
time. That didn't have a time or
I'm not going
or
to
an
play
order.
this game with you.
It's
sir.
not no game.
It
That's what
was-
you don't
it
seem
is
to
a game
understand.
you. I believe that fully.
I don't care what you believe fully.
All right.
It's not a game.
We
I don't take
I
this as a
asked-
game. That's what
Let me explain
nobody.
this to you
That's what
once
nobody.
again.
You don't got to explain nothing to me.
Do you want?
That's what you.
All right. Well, they are back in, unfortunately. So we're going to go back over. But I've got some videos queued up for you guys. So and they're going to talk about the audio here. So we're going to jump back in. But we have some videos during breaks that are definitely need to watch because, man.
Deputy Kibler, if you could
There we
take
go.
the witness stand, please. Sir, could you please raise your right hand? Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I'm going to remove
Thank
some
you.
of these
Please have a
banners
seat.
because I know some people are having issues hearing, so I want to make sure they can see the
Please
closed
state your
captioning here.
first and last names for the record.
First name is Nicholas, last name is Kibler. First name Nicholas, last name Kibler.
Thank you. And you are a Waukesha County Sheriff's Deputy,
I am,
and have you been assigned to work this case?
I have,
And were you present in courtroom 20 this morning with Mr. Brooks when he was removed from this courtroom to that courtroom?
I was.
And did you make any personal observations regarding the audio and visual setup that we have over there?
Both the audio and visual were working properly. The audio was a lot louder than it has been in the past while we were in that room.
Did you have any difficulty hearing the court?
I did not.
And then, of course, you could see through the cameras from this courtroom into the neighboring courtroom.
I could.
All right, that's the only record I wanted to make. State, have any questions?
Just briefly, Deputy Kibler, the defendant asked many times if he was muted or unmuted. Do you remember that?
Yes,
Can you confirm that even on the occasions when his microphone was muted, the audio in the courtroom continued to work?
it was.
And at any time while Mr. Brooks was muted, or even if you didn't know, at any time did Mr. Brooks ask to be brought back over to this courtroom, sir?
He did not. He is telling us he prefers right now to be in that courtroom. He did not want to come back in here.
All right, thank you. Those are all my questions, Your Honor.
Mr. Brooks, you are unmuted. Do you have any questions for this deputy?
No.
All right, thank you. You may step down. All right, then I'm going to have Zach Tremaine also take the witness stand. Do you have- Can you do a project it, please?
So they keep him in this timeout room because he can't seem to keep his having a little bit of a hiccup here on our video. There we go.
Yes. All right.
Sorry, guys, I'm not sure what's going on here. Let's do this. Keep it the way it is. Give it 2 seconds. It'll be all right.
There is, first of all, sir, stand and raise your right hand. Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth? All right, thank you. Be seated. State your first and last name for the
That man
record.
looks sharp and salmon.
Tremaine, Zachary. Tremaine is Tremane.
All right, and what is your position with the clerk of court's office here in Waukesha?
I'm the IT coordinator for the Waukesha County Circuit Courts.
Boom.
Were you in courtroom 20 this morning following Mr. Brooks being taken to that courtroom?
Only temporarily. I was there when the call started, and then we came back to do a measurement of the BD later.
There's a document or a photograph that's displayed on the monitors throughout this courtroom. Can you tell me what we're looking at?
So my phone is in the photo, overlaid on top of what we call the X panel. It is our AV control panel. So you push buttons on it and actions happen in the courtroom, AV related. At that time of the photo, my phone is registering 67.3 decibels.
Thank you for
in
the
that
shares,
courtroom.
guys.
That was when the judge or the court was talking, and then the sound was coming over the speakers in the other courtroom.
And what, if anything, based on your training and experience, can you tell me 67 decibels means?
It's plenty loud. For comparison, I did a quick reading in the media pooling room, which is CG6 in our courthouse. The meter there was reading between 55 and 65. So it's louder than the audio feed going to the media right now.
All right, thank you. Any question from the state?
Sir, I'm looking at the photo, and Your Honor, for the record, the time is either 9:26 or 9:36 a.m.
On my phone, yes, I believe our AV processor, which is the other time of 9:23, I believe that just needs to be updated, but
Okay,
it is approximately 9:26 when the photo was taken.
those are my questions.
All right, thank you,
Wait,
Mr.
I'm sorry.
Oh, go ahead.
Do you happen to know what the decibels are in this room?
I don't. I'd have to pull the same thing up on my phone while people are talking.
Thank you.
Mr. Brooks, any questions for this witness?
For the record, I don't consent to being called that name. Do you know anything about the hearing when someone has the hearing loss in any of their ears?
There's a muffin in
I
your
do
ear.
not.
So it'd be fair to say you don't know if I can hear everything good from this courtroom.
I can tell you what the readout of the room is. Beyond that, I don't know.
Well, I can't see what photo that everybody else is in there seeing that was supposed to be made an exhibit. I have not viewed that, so I don't know
what's being referred to when you refer to the picture?
I'll have to show you that in a different way. I don't have the Zoom up and running, which would have been the mechanism to allow for an exhibit to be displayed. I can start that and have that up momentarily. Fair enough. So give me a moment. For the moment, we'll print it in black and white so you have it until I can get the Zoom up. Sure.
You are in the meeting now.
They're rocking a Zoom call right now.
I need to get the other courtroom in, so just one moment. Well, I have to stop the Polycom, Zach.
Yep, you have to hang up and then join into the Zoom meeting.
Okay, hold on, please. Can you do that? Stop the call Polycom to Polycom, and then I'm going to call it in through the Zoom so I can share the screen with the exhibit, which will actually help when we do jury instructions.
Man, she judge dialed that in real quick. She said things like
Yep.
Polycom.
Except now both room systems are out, so hold on.
We're both going to play with our technologies right now. See if these are working for us. So I feel like when we go to break, I'm curious where everyone goes to, because I know we pick up like another 50, 60 folks. And then once
You
we
are
come
in
back,
the meeting now.
I think folks are watching somewhere
All
else
right,
maybe
so
for
the
the
record should reflect that
running trial. In the downtime,
I've now
commentary and videos
changed
for
the
CJ.
audio
There you go.
visual from the Polycom unit to the use of Zoom. I've called in both courtrooms, and they can hear from over there. And then I'll do.
I have no idea, Leah.
I just need to get back on so I can get the email. Give me a second. I have to go from double screen to single screen the way I sign in, but that'll take me just a second. And then I'll share screen so the color exhibit can be viewed by the defendant.
Thanks, Kelly. Appreciate it. I don't know anyone. I don't know he was doing the case right now. Right on. Get on it. But again, I'm glad you're here watching with me here. Again, I was in Waukesha the day of the parade attack. I made my way. Well, I was in Kenosha for the
All right, now
Rittenhouse
the
trial.
court is
And then
sharing
the day of the attack,
screen,
we made our way
and
right
the
after the attack, and we were there filming,
images being
talking to folks,
displayed.
doing interviews, while they were still handling the like the aftermath carnage that Darrell was caused when he drove through that
You
crowd.
see it? Okay,
So,
thank you. Any questions regarding
yeah,
that then, sir?
and then we went to we also went to the memorial. So all of this is very personal here at this point. It became very personal, so being a part of that, and having spent so much time out here in in Wisconsin.
You don't know if
And this just hits hard for all of us, I'm sure.
me myself can hear everything you did.
So I'm glad you guys are here watching it with me.
I do not, correct.
If it's personal to you, I'd hope you jump in here with me.
Okay, thank you, sir. I'll stop sharing. Okay, thank you, Zach. You can step down. All right, I just wanted to put that on the record since that was an issue raised by Mr. Brooks previously. Now, I need to get a copy of the jury instructions. They were quite lengthy. The record should reflect that Mr. Brooks was provided with a written copy. It's 107 pages, and the state was
every injury phase is supposed to be closed. How come I haven't been able to present my evidence into the record as I've asked numerous times on the record to be able
declared that you forfeited your right to testify. Specifically as it relates to your trial filing, sir, I would note that all evidence in a trial must be proper, it must be probative, it must be relevant, and it must follow all rules of procedure and all rules of evidence. To the extent that you wrote all of those documents, sir, that would be hearsay. And for that reason, I'm denying your request to make them part of the record.
They were not hearsay, Your Honor. I did what you told me to do. You told me, since I was representing myself pro per, that I had to write everything out and present them to the court.
So that's not what I said. You're misquoting me, but in any event, I'm denying your request. I
So
said,
you're saying that I have no right to present evidence and to have exhibits as the state's been able to do.
Mr. Brooks,
Are
I'm
you
not
denying
going to
me
have a debate about this
Are you
now.
denying me-
I gotta
are you
mute him
denying me
once
your
again.
right?
So, Mr. Brooks, I have muted you because I declared the evidentiary phase of this trial closed. You forfeited your right to present further evidence and testimony previously by refusing to answer the court's questions. I will specifically address the filings. Number one, it is not true that I advised him that any filing would become evidence. That is simply false. Number two, filings, I told him if he wanted to present motions, should be written down and should be based in law and fact and request specific relief. I'm well aware that previously he has referenced he would like his filings made exhibits. I've reviewed those filings. There's nothing relevant, nothing probative, or the information contained therein is hearsay. Mr. Brooks would have needed to testify regarding any statements that he, from himself, testimony. He cannot simply put in an affidavit. That's not proper. That's hearsay. And he hasn't asked in any of those filings that he hasn't put forth any exception to the hearsay rule that would allow this court to admit his written filings. I believe without fail, they are all irrelevant, not probative, and hearsay, and therefore not admissible. So we're moving on to the discussion of jury instructions. When Mr. Brooks wants to abide by the rules of decorum and civility, I will unmute him. He clearly just took the entire packet of jury instructions and put them, I don't know what's under the table, if it's a garbage can or if he just simply put them under the table, but they are no longer in front of him. I will, however, unmute him so that we can get his feedback regarding jury instructions. It's typically a back and forth. We'll go through them. And I'll ask the parties whether there are any instructions they believe should be included, and we'll have a discussion on that. And then we'll talk about whether any of the instructions that are in here need to be modified in any way, taken out, edited, etc.
Beauty.
Right, you're unmuted now, but but you have to not interrupt.
No, you can't, I'm not trying to interrupt, but how can you deny me the chance to put on the adequate defense by saying nothing that you told me to do can be presented into evidence? So you filed them, you filed everything that I gave to you,
Right,
filed.
Mr. Brooks, I'm
And
going
now
to
all of a
mute you
sudden-
because this is not relevant at this
Just
time.
It is.
keep
He's
hitting that mute
raised
button.
tone of voice. He's very animated. He threw the jury instructions on the floor. I understand you're upset, sir. I understand you believe I'm violating your right to present a defense. I've made my rulings. I determine you forfeited your right to testify, which includes the right to present evidence as you would have testified. I closed I closed off your ability to call any other witnesses by finding that you forfeited your right to do so based upon your conduct. I understand you're frustrated. I understand you believe that I'm not without authority to do that. I made specific factual findings. I've referenced the law, and you being upset with the decision is not going to change my mind. He's also taken the headphones off. It's his choice right now whether he participates in this jury instruction.
What a child,
conference.
man.
It is his choice. But if he is going to spout off about
Just a
things that
child.
I've already determined, I will continue to exercise the mute function on the audio equipment. I'll unmute him again, but
He's just
you are advised, sir, you need to be proper. You need to not interrupt, and you need to stay on task, which is we're discussing jury instructions, not other evidence, not subject matter jurisdiction, not your belief that I told you to file things a certain way. We are now discussing jury instructions.
Troy Savage. You
Once
think that
again,
this should be a
I'll unmute him
mistrial?
to see if he can follow these simple rules.
You need to tell me why I can't present evidence.
Mistrial.
How can you deny me the fact? How can you deny me my right to present evidence?
Right,
I
I'll
told
mute
you
him
before
once
this.
again because he wants to continue. And again, I understand he's upset. I understand that.
Troy, have you been
But
watching this whole
he
case?
has
If not,
himself to
then
blame
you
for
you
his
wouldn't know.
conduct this morning and the rulings that I've made. All right, so let's go through these jury instructions. First of all, has the state received a copy of the
Oh,
draft?
Troy. They've been more than
Thank you.
adequate in providing him everything he needs. You obviously, I don't think you've been watching
Mr.
this trial
Brooks, do you acknowledge
Troy,
receipt? I
'cause
believe you did by
they've been
acknowledging it
more than
previously,
thorough
but you acknowledge
on
receipt
giving
of the
him the
draft of the
full
final
amount of
jury
services that
instructions.
he's provided under the
I
letter of the
ain't
law.
acknowledge nothing, and I don't
He is-
acknowledge anything now.
Everything
I
they've done
acknowledge
here is to
anything.
I
maintain
would
some
ask the
decorum in the
bailiff to pick
courtroom.
up the
So,
documents from the
Yeah.
floor and put them in front of him.
And
once
we're,
again.
I'm not presenting it to nothing I don't give my consent to. You can't deny me the right to put on a defense.
Yeah,
How
probably a
can you tell
Troy.
me when I done stated
I'm going to
3
mute
or
him
4
once
times?
again because, again, I understand he's upset.
This case,
If the bailiff could confirm, well, he put him on top, he put him on the floor. That's his right. They're not in front of him, but it's by his own conduct that he's done that. The record should reflect Mr. Brooks is muted because he wants to continue to debate with this court about my prior
Troy.
rulings regarding his
He absolutely is intelligent enough to know what he did.
forfeiture by
100%.
conduct of his right to present further evidence on his behalf.
Yeah, he's getting exactly what he did. The full ramifications of his actions. Troy, whether or not you have been watching or not, I hope you have.
Need to look at. I'm not
this
sure
is
if
exactly
Madam Clerk did this
what
or not. Would be the language
he has
from
created.
the amendment from the amended information on count 70.
He decided, Troy, to be his own attorney. He knows how to conduct himself in a courtroom. He's choosing not to. Anybody in that courtroom, even people sitting behind him that haven't been to court multiple times, know how to sit in the courtroom, pay attention, and follow instructions and be respectful.
The 76.
Because he can't seem to figure that out.
Says
Isn't
near frame part,
isn't
so
his
it is in there,
a
but that
way
was
of
just one question I
him,
had.
his ignorance of how to handle himself, like the judge has said, is not an excuse nor a defense.
So state have any requests as it relates to the jury?
Adam, welcome back from the UK.
I'm just going through each one. I'm on page 50.
No, there's no
7.
standby attorney.
Everything's looking great so far.
Okay. Fair enough. There's 107
Yeah,
pages.
he's going to
I
file
certainly
for an
think
appeal.
the parties some
And
time
Troy,
to
I
continue
pray
to
God
read through
that
them.
they do the same thing they're doing here. And they just go ahead and just this guy. I mean, what a clown. So, Troy, do you feel that he should be let out of prison or jail? Do you feel like, Troy, do you feel that he should be out on the streets? And you guys don't attack Troy in the chat. Everyone's entitled to their opinion. But I'm curious, Troy, do you feel like this person who's doing all of these things is, and then has murdered 6 people, killed 6 people, critically injuring over 60 others, permanently injured, disfigured children? Do you think he belongs on the streets with the
Mr.
ability
Brooks
to continue
is
to do the
requesting
things he's
go
done?
back to his cell at this point. I'm going to deny that request. He can remain in the other courtroom.
Yeah, so he's playing Legos right now, y'all. He's legit playing Legos. And then he tries to talk around it. Like he wants to be able to look at the TV. He's a kid. This is the equivalent of a kid throwing a tantrum. Like, you know, when you catch like a child, like a baby, like crying, and you're like, oh, you look over and you see them watching themselves in the reflection so they can see exactly how they look while they're, and then they get caught in the reflection or they get caught looking at their own reflection. It's one of those like, oh, what do I do moments? That's exactly how he's doing this. He's, man, yeah. Yeah, he's building a box for it. A basic duty box for it. It's just funny. Like you can only, okay, this is, I heard a comedian say once, you know, that's why you never argue with your significant other when you're camping. Because, you know, if you really want to make a statement, you need to slam the door. It's hard to slam a tent flap. All you can do is zip it up really hard. You know, that's where he's at right now. Is he at a point where he can't yell because she's muted him. He can't make enough, antics and gestures because the court TV and, you know, all these televisions are just going to cut away, not show him. So he's being all of his ability to disrupt proceedings and to play the clown
I know
are
he's
being taken
muted,
away
but I
from
can
him.
certainly hear him from this side. He appears to be
So he's yelling loud
yelling
enough for them
at
to
the top of his
hear
lungs.
through the walls
I
is what he's
can't
doing.
decipher what he's yelling.
It's hilarious. Stuart, yeah. Look what I can do. He's just the tantrum on this guy is amazing. Yeah. Troy Buford. Troy's everything has been taken away from them with no need for jury at this point. Just convict him and throw them in jail. Troy, if he appeals, he won't make it to the next trial. Yeah, I mean, so there are people, there are a couple folks in the chat that feel that this potentially has the grounds for a mistrial because of how he's being treated right now. But for those of us that have been watching for the last 13 days, we all are very aware of the fact that this guy is 100% competent to stand trial. He's been reviewed by professionals that have found him competent and sound in mind to stand trial. He made a conscious decision to release his attorneys. He's made a conscious effort
without a
in defending himself
waiver of his right to be
and
present,
has
even
made
if it's
all
from
the effort that he
remote
can to
courtroom.
be put in the
He's
position
going
that
to
he's in
remain
right now,
courtroom.
which is being sequestered to another courtroom because
That
he
would
is
require him
unable to maintain the
follow through.
proper court procedure and decorum because he doesn't like how it's going. Had he been just a witness sitting on the stand or a defendant instead of representing a third party representation of the alleged defendant, had it been him sitting there next to an attorney, if that empty chair was his defense attorney, he would be doing the exact same thing. No questions asked, just as wild, just as animated, just as loud, to the point where even I'm sure his attorney would be telling him to shut up. There's just no questions about it.
Mr. Brooks, I know you are still muted by me, but I know the audio is working, but I would ask you to specifically advise if there are any specific jury instructions that you are asking be read to the jury.
Troy, I really do appreciate you sharing your opinion, and that does that is the essence of why we have the community that we have here, and the amazing amount of adult interactions that we have here. We're allowed to disagree with each other. We're allowed to see things differently. We're allowed to feel differently, and showcasing those views is exactly what the chat is about, which is why I encourage everyone to come over here. With my mods, you guys you always do an amazing job. Work really hard to maintain a healthy chat room, which is one that's going to help share facts and information, opinions, views, thoughts, sentiment. We're never going to allow people to attack each other. We're never going to allow people to spit hate. We're never going to allow people to spit violence. I mean, what we're doing here is exactly what we've been doing for 13 days and we've been doing for the last couple of years, which is building a platform that allows people to have a voice and elevate that voice, whether or not it's one that you yourself would you know, whether or not what they're saying is what you yourself would say. It doesn't matter. We're definitely in a position now where the divide in the country and the divide in the world has been so bad that due to this cancel quiet culture, you know, where we've been trying to shut people down for not agreeing with everything we say or not feeling the same way we feel or not thinking the way we think, has built such
Mr. Brooks,
a
if you
rift
have specific instructions,
if this is a
or
place where we're safe
categories
from
of
that,
instructions that
right,
you believe
left,
this court should consider, I
conservative,
need you to write
liberal,
them down
Dem, Rub,
on a
Republican,
piece of paper.
it doesn't matter.
If you don't have,
You are
I believe I see a
100%
writing
entitled to your
utensil. I'm
thoughts and
not sure if
opinions
I
and
see a
views.
pad of paper. We'll make sure you have that.
And even Tortilla,
Given
the
your
cat,
current demeanor,
has some thoughts. So
which is still seems quite animated and a loud raised voice, I'd ask that you write it down.
yeah. So I thought, man, Adam Deshay, am I saying that right, Adam? Let me know. You're over in the UK right now. He's in a location just similar, close to Bristol, actually, over in the UK in England. And he says, I love the mute button. It made me nervous because I thought you were talking about mine. I'm so notorious for doing the whole diatribe and then looking up and realizing that I've been muted for 10 minutes while I've been talking. So, but Mark, yeah, that was fun. Yeah, I remember that.
How's the state doing on its review? Okay. I just want to make a continuing record that Mr. Brooks hopefully hasn't taken out any numbers. I can figure it out. There are numbers. Well,
I was gonna say there's some like the ones that are all of ours.
yeah. So that's just the easiest because this goes after credibility. And then three 325. Which it's before defendant elects not to testify, and we have to toss up that one. Yeah. Mr. Brooks, I'll advise you once again, if there are any specific requests for either instructions or categories instructions that you want this court to consider, please write a note to pass to the bailiffs who can let me know.
So what I might do here in a second, I'm gonna watch for another minute or two, and then he's Bobby Griffin says he's rapping the video that they played. He was heated about that. I might actually play another video clip while this is going on. So just give me 1 minute here. We'll take a look and we'll see what happens here.
1207.
Thank you. I know upon my review, I noted a few spots that either in the headings, that some information or words that might need to be removed. But why don't you go through and tell me what requests you have starting, and then we'll go page by page and just tell me what page number and what section.
So I think the first concern I have is with regards to the bail jumping. I know that we had charged, there's 2 separate felony cases. The defendant was out on bail. And I do believe it would be assistive to the jury to have the specific case number. So when we first talking about 61 of 107, we start talking about the bail jumping, and then we go specifically on page 63 of 107, and when we talk about count 74 and 75, I think it might be helpful to put the Milwaukee case number, because they are different case numbers, so that they know exactly what they're finding, that he was out on bail and that as conditions of his release. And those bail bonds were entered into evidence.
Let me look at the information.
And then just, because I think this was just well, I guess I'll have you, when we look at the verdict forms on page 102 to 107 for the bail jumpings, there's verdicts for the bail jumpings for 3 separate counts, 74, 75, 76. I don't think there should not be one for 76. I believe that should be the battery.
That would be true.
So yeah, I think they've got a little bit of time they're going to be working on this. So while they are getting into the business here,
My computer's just acting up a bit, so I'm going to search. I'm going to see what the information says.
boy, do I get
And then
that.
I'll ask Mr. Brooks if he has a position on that. Sometimes it's easier if we just list out, I guess, what the changes are requested. I'm going to
Sure.
make some notes and then we'll go through
Sure.
one by one. But so,
And I
first
don't
is
believe it
page-
was spelled out in the amended information.
Say that again.
I don't believe it was spelled out in the amended information.
Right.
So that would be page 63 of 107, whether or not we want to put the specific case numbers.
I can tell you right now, I typically like to follow the information, so I'm probably not inclined to do that, and we can argue that though to the jury. But
Okay.
let's go through the list, and then we'll get
Okay.
the defendant's responses if he's would like to give us those. But we'll go through the whole list. So that's
And
the bail jumping.
Yep, and then with the verdict forms with regard to the bail jumping, just to put on the record, page 102 of 107, I believe there's a count 76, which details it as a bail jumping. I believe that should be the battery.
Right.
I did notice on the motive instruction was incorporated on page 5 of 107. And I know that intent is an element of the battery. I don't believe that was incorporated. I mean, usually it's a standalone instruction. I think the court incorporated it with the first degree intentional homicide because certainly that was
I think that's part of the pattern instruction.
Oh, it is. Okay, then we'd ask for motive. I think that there's a 175 instruction that could be given as a standalone.
I'll look at that. Okay, we'll add that.
And then on page 65 of 107, which is the 70, the preliminary instruction, defendant proceeding pro se. There's the standard paragraph, which is the first paragraph listed under this instruction, and then there's an additional paragraph. We are going to object to that additional paragraph. I think it highlights the defendant's bad behavior. So I'd ask that that be taken out.
All right, I made a note of that. Keep going.
Okay, with regard to page 106 of 107.
I feel like they got a
I
long
believe
day ahead
that
of them.
those
man.
were add-ons at the end that the court wanted to question the parties about.
Yes.
I believe that there was 325 should be given. One of the witnesses for the state did testify. He did have one prior conviction. I believe a witness for the defendant testified that he had a number of convictions. With regard to that same page 106 of 107, instruction 141, where identification of defendant is an issue.
See, Troy, we're on the same page, man. But yeah, we
I don't
we
know if it
definitely
is an
are
issue
seeing
that
things the
wasn't
same way.
raised
So
during the
yeah,
defendant's closing arguments.
all of this
I'm
builds
sorry,
towards the
his
same
opening
result, the
arguments,
same
I would
end,
know that, or
which
note
is going to be
that the defendant would sometimes
guilty.
cross-examine people on if they were able to see
Fill in
the
the
person driving
guilty.
or the
Yes, yeah.
description of the person driving, and he would cross-examine them as to their ability to perceive that. So I guess that would really be up to the defendant if he wishes that to be given. On page 107 of 107, instruction 172, circumstantial evidence, flight, escape, concealment,
Kelly,
the state
yeah,
that was
get yourself into
included in the initial
kickboxing class.
instruction
That'll
that
get your energy
we
out.
requested, and I would continue to request that instruction be included.
It's really just flight, though.
Correct.
What's that number again?
172.
Yeah, I know. It's just not there. I saw it. It's fine. But only as to flight. I made a correction on it. So I'll find it. All right.
And I would say concealment to some extent, because he took off some clothes that would have identified him. But again, his running away, his trying to conceal his identity by removing some clothing that was identified by numerous witnesses as him wearing a hoodie or a light colored top.
I mean, yeah, we're looking at something, Leah, something close. It's got to be, yeah.
Those are all. And do you have any requests as it relates to instructions that are not in the packet that should be?
No, Your Honor.
All right, let me turn to Mr. Brooks just to get whether he has his list. I'm not asking for a response yet, Mr. Brooks. What I'm asking you for is whether you have any requests for jury instructions, or if in your review you think anything needs to be changed, deleted, added, etc. I know I'd ask that if you put in writing, but I'll also give you this opportunity to verbally advise the court and make your requests. Do you have any requests as it relates to the jury instructions, sir? I would note he put 2 boxes right in front of where he's seated, so I can't presently see his face. I see his jacket is off, so I can see the outline of his arms.
Oh,
I see the jacket on the back of
peekaboo, I
his
see
chair.
you. Can't hide
He is
everything.
unmuted.
Yeah, the CC has been
confirmed
entertaining.
previously regarding the audio working, and I will just ask him a second time, sir, do you have any requests
Yep.
as relates to
900 plus
the
years and 6
draft
life sentences.
packet of jury instructions, whether that be any additions, corrections, edits, or deletions.
And Your Honor, would it be possible for the bailiffs to just move the boxes off the table so
Yes,
we
I
can
think
see?
that's fair. I'm going to advise the bailiff to
Oh.
remove the box so I can
Might
see
be a fight.
Mr. Brooks.
See what happens here.
I don't know what he's doing behind there.
He's picking his nose.
He has quieted down. I haven't heard him in a while.
You can only yell so much. Hey, those are my boxes.
If you could move the second one because it can interfere with the microphone as well. And the
Take
third
my
one.
Ford away from me.
Mr. Brooks, I'm going to ask you for a third time. Do you have any requests as it relates to the jury instructions? Any requests for instructions that are included that you believe should be included?
Charlie,
Any
you are right
edits
about that.
or deletions from the packet that has been
Definitely
provided to
holding a
you?
pocket.
Hey, why do you tell them to move my body?
Because
Why
I
are you telling
couldn't
me
see
my
you,
boxes?
sir.
Or what?
I've asked you twice now, and I'll ask you a third time. Do you have any requests as it relates to
It
the
broke
jury
his foot.
instructions? Any additions, deletions, edits, or
Hey,
otherwise?
man, you don't gotta talk to me like that.
Shut up. Talk to like
Do
what?
you have any requests
First of all,
related
First
to the
of all-
jury instructions, sir?
man, yeah, I got requests. It ain't like they gonna be honored though. 'Cause
As it
nothing
relates
out
to
there
the
trying to
jury
get done.
instructions, sir, what are your?
I heard what the hell you said, man.
Mr. Brooks, that was very disrespectful.
That was before the
Don't
defense has
get
my
brazen with me.
Since the beginning of this whole process. So welcome to the club.
Welcome to the club.
Mr. Brooks, do you have any
I'm
requests?
tired of my race being trampled on here too. I'm tired of it too.
Do you have any requests as it relates to the jury instructions?
Ain't nobody understand why I'm frustrated. How you gonna sit up here and make
100% no.
What you think I said when I didn't get consent for you to do any such thing?
So I understand you may be upset, and I really do, but I've made my determination.
You don't know. They didn't take your Ford down. They didn't break your special place.
I'm going to mute him again because he's not answering the questions that I'm
You need to
very
explain it to us,
clearly
Judge.
asking
We
him,
do.
and I've given him 5 opportunities. Mr. Brooks, do you have any requests as it relates to the jury instructions? I'll unmute you for that answer.
I can't hear everything you're saying.
That's because you took your headphones off, you raging hemorrhoid.
Mr. Brooks,
Bro, come on. I
I
mean,
know the audio's turned up. I believe you can hear me.
that's
You've
how he
chosen not to
responded.
put the headphones on. That's your
We're-
choice. My final question to you: do you have any requests as it relates to the jury instructions?
Wow.
I just told you, come on, muted.
I just told you. You responded to her. You.
I just told you, I don't know how many times I can't hear everything you say.
Then you should put the headphones on.
Don't you understand? What about that don't you understand? Do you see headphones? You can see everything. You can see boxes. But do you see headphones?
Have you asked for headphones to be provided, sir?
I should have to ask him. I asked for my boxes.
Enter the headphones.
I believe they took them away previously because you were so agitated. They were perhaps afraid you might break
Yeah,
them.
I'm still agitated. I ain't gonna stop being agitated.
Or do us all a favor and
That ain't gonna stop. You sit up here and do everything you're doing and think God don't see what you're doing.
Okay.
You need Jesus.
You ought to be ashamed of yourself.
Mr. Brooks, do you have any requests as it relates to the jury
Yeah,
instructions?
I can hear what you're saying. I can hear what you're saying.
You just told me you didn't. So which one is
Yeah, I
it?
got the headphones on. You can't see that?
What are your requests as it relates? What are your requests as it relates to the jury instructions, sir?
Man, don't try to come with this whole
Oh, guys,
all this. I'm getting where I'm going.
to
Trying to put on this
hell.
little act like you so worried about what's going on with me. You don't give a damn.
No,
Never did.
no, we really
Mr.
don't.
Brooks, you're being disrespectful.
She cares about
again.
doing her job properly.
You've been being disrespectful.
No one cares about you.
You've been
Your
being
mom does.
disrespectful.
That's one of God's
I
children.
need to know
We
what
all
your
do.
position is regarding the jury instructions.
Say hello when you get a
I
chance
need
to
to
meet
know
him.
it now.
What you mean? Who you talking to?
I'm talking to you. I need to
talking to
know
you.
whether you have any requests as it relates to the jury instructions, sir.
Yeah, first of all, why am I charged with 2 bail jumping when I was already charged in Milwaukee for the same bail jumping? That's double jeopardy.
It's not double jeopardy. Your objection is noted. It's overruled.
That's being,
It is double jeopardy. How you gonna charge me with the same charge that I'm already charged with? You can't do that. The Fifth Amendment says that you can't place somebody in jeopardy of life and limb. Twice. I'm already charged with the same count in Milwaukee. This for the same case. It's the same bail jumping charge. So how am I charged with that here?
Sir, I'm not going to provide a legal explanation other than to say I've reviewed that. Your objection is noted, but the jury will be instructed regarding the bail jumping.
It can't be because that's double jeopardy. Under the law, if two charges are identical in nature, you cannot place me in jeopardy of life and limb twice. Can't do that.
he's talking about the Fifth
What's
Amendment. I
your
just put that in the
next-
comments.
Same case,
What's your next request, sir? I'm noting your objection.
I'm trying to talk.
Is a
Can I get it out?
procedural defense,
You always
primary
want me to
and
not
common, and
interrupt
common
you,
law
but
jurisdiction.
You always find a way to talk over me.
It's following an acquittal or
I
conviction
understand your
in rare
position. I'm saying
cases.
it's overruled.
You always want respect, but don't want to give it. I'm charged with the same bail jumping charge here that I've already been charged with. That is double jeopardy. You can't charge me for the same exact bail jumping that I'm already charged with, that I was charged with before this even came about.
Sir, the bail jumping charges in Waukesha County are based upon your violating your bail while in Waukesha County by driving through the Christmas parade and allegedly killing 6 people and injuring 61 others.
There you go.
That's the distinction.
He said, "Oh, okay.
There is no distinction. It's
Here
the
you
same charge.
you guys can."
It's the same offense. It doesn't mean it's the same factual basis, sir.
He is not charged with bail jumping with the data violation of November 21 in Milwaukee County anywhere. Further, the double jeopardy prohibition would prevent him from being convicted twice, not charged twice.
All right,
There
so
you go, Barry.
we've addressed that, sir. What other requests do you have
Who's
as it
that?
relates to the jury
Tom Ford.
instruction?
I want to know why I'm even charged twice with the same thing.
Just drop the bail jumping. How about that? Make him real happy. Just drop the bail jumping.
That I'm already charged with bail jumping. I'm already charged with bail jumping for that already. So you can't essentially say, oh.
Oh, driving on a suspended as well.
Because you were already on bail.
You're lucky, bud. You slipped through the cracks in that
We're
one.
gonna charge you.
It's a different data violation, sir. The conduct for the bail jumping is related to the allegation that you committed a new crime in Waukesha County while out on bond from the Milwaukee County case.
Yeah, but I'm referring to the first bail jumping count. The first.
Yeah,
I'm
me and
not
Chase
referring
looked
to
at it,
both
so.
of them. I'm referring to one of them.
My understanding, sir, is there's different dates of violations as it relates to that. So I've noted your objection now repeatedly. I understand it. Your request to, I guess, dismiss the bail jumping counts are denied.
I didn't say nothing about counts. I said one.
Whether it's one count or both, it's denied.
Dixie Simmons, I was unaware that how that works. Anyone that wants to chime in on the First Amendment auditor that's helping in the case,
It's two
please let me know.
separate cases, sir. There's two.
Isn't that 971.23? Isn't that the statute that refers to the double?
All right, sir, I'm not going to have an argument. This isn't fruitful. I understand what you're saying. You're saying there shouldn't be 2 counts of bail jumping. You believe it's double jeopardy. I disagree with that. There's
I'm
separate.
already charged with it though.
This is a circular argument, sir.
Exactly. It's just
doesn't
becoming
change the fact that, from my perspective,
cyclical.
the
Lose
two
the
bail
term.
jumping counts are going to proceed forward. There's been sufficient evidence presented to warrant the jury being instructed.
They can't.
What other?
Well, it's crazy to say because they
What
are.
other
So,
requests do you have,
Don't
sir?
talk over me. Don't talk over me.
can the Department of Justice charge him as well, or would that be double jeopardy?
Just like you don't want me to talk over you. Just like you don't want me
Mr.
to
Brooks,
disrespect
what
you.
other
It's a good question
requests
because you can
do
get tried in
you
different
have?
courts.
And I just asked you.
He just asked you.
Talk over me.
Pay attention.
You've been making your record the whole time you've been over there. You had me muted.
Yeah. And now it's your turn to talk. So talk.
I didn't see no request over there. I didn't write nothing to go over there. I let you do what you was doing. No matter how egregious.
You better be drooling and acting like you.
I let you do
Yeah.
what you was doing.
Kelly Bradbury.
Because we both know that what you're doing is not right.
Mr. Brooks, I'm going to refocus your attention to the jury
Yeah, I feel he's
instructions.
very
All of
intelligent.
your objections are noted. I understand that.
There
If you
you go.
can't answer my question, I'm going to move on.
So state and federal jurisdictions are different and not considered double jeopardy.
All right, I'm going to mute him once again. He
So him being
refuses to
sovereign, I think
answer
one of the sovereign
simple
beliefs is that the
questions
federal courts have
regarding
jurisdiction over
if
them,
he
but
has
not
any
state. So if the
requests.
state's trying him
He
right
just
now,
made an argument
he
regarding
wants to
the
go ahead
bail
and claim that they don't
jumping,
have
so
any
clearly
grounds.
he
Well, then if they
has
go
an
federal,
understanding
good
about
luck.
the law as it relates to that.
Fed
It
time,
may be a
straight time. You get no good behavior. Nothing but
misunderstanding
good behavior
about
for
the
900
law
years
and
6
double
months.
jeopardy, but he made an argument. I've denied it. I'd like to know if he has any other requests. If he can stay on topic, I'll I will unmute him again, and he can tell me the list, just like the state went through a list. I need to get through their list. I'm asking you to list out all your requests, and then I will take each one up in turn. So here is your opportunity to give me your other requests, not debate with me about prior rulings. Go ahead, Mr. Brooks.
Don't sit up here and try to play no game talking about you giving somebody an opportunity that you haven't gave me an opportunity to properly defend myself and put evidence, put stuff into evidence, which I've asked you repeatedly to do before we even got to this trial. You told me we wasn't in the evidentiary phase.
Mr. Brooks, do you have any other requests as it relates to the jury instructions? This is probably the 10th or so time I've asked you this question.
No, it's not. No, it's not. So please stop being incorrect, Your Honor. Please stop.
Do you have any additional requests as it relates to the jury instructions?
Yeah.
Oh.
That first count 74 bail jumping needs to be dismissed. You can't charge me with two things. You can't charge me with the same charge twice.
All right, I've made a note of that. What's the next issue?
Either one company gonna charge me with it or y'all, but it can't be both. It's the same, it's pursuant to the same exact thing that I was on bail for. The same exact thing, the same exact case. So why are we giving the jury instructions on two cases from another county?
I've made a note of that. What other requests do you have?
Man, this is ridiculous. So I'm not even able to adequately defend myself, present evidence, do anything, because everything I say is gonna be found a reason for it not to be valid. What are we doing here, Your Honor? What is the
Mr. Brooks.
Well, we're trying you for
I've
6
made a
counts of
note your
murder
request
and
as to count
61
74.
counts
Do you have
of
any other
assault.
requests as it relates to the jury instructions?
Why are we even having jury instructions? Why do I have to even sit here in the courtroom at this point?
Because you're the defense.
Because everything you've been doing.
Your attorneys could do.
you've been
Oh,
doing
wait.
without my consent anyway. So you're gonna find a way to do this without my consent. So why do I need to be here for?
Your objection for lack of consent is noted for the record.
Okay, yeah.
Any other requests, sir?
You talking big game to save yourself another second. But everything I put up has no merit in your court. None.
Right, I've asked him many
And they mute him.
times. I've advised him, and I'll advise him once again. If he fails to answer the question, I'm moving on. Do you have any other requests as it relates to the jury instructions, sir?
You can't move on because I haven't given you consent to.
All right, he did not answer.
He just wants to
I'm
be able to
meeting him
tell
again.
her what to do.
The
I
only
didn't tell you you're
request
allowed to
that
do
he
anything,
has
so you
made
can't.
as it relates to the jury instructions, as he pounded his fist once again, raised his voice. I understand, I really do, that he's upset with my decision to cut off his ability
Yeah,
to
Tanya,
present a
he
defense.
doesn't
but
like that a
that
woman is
decision
not
was
scared of him.
made
We're not
based on
bowing
his
down.
conduct and his conduct alone, as I've outlined already on the record. So the only request that he made was as it relates to the bail jumping counts. I'm denying those requests, whether it be to dismiss one count or to dismiss both on double jeopardy, or to just not instruct the jury. However way I interpret it, I'm denying that. All right, let me go through the state's.
Your Honor, can I add one more?
Sure.
I'm sorry. 154 summary of evidence. I believe we had a map, actually 2 maps that summarize the, we had 3 maps. I think the one was summarized his route, the path that he took. The other one summarized the victims who were struck in the specific locations. And the other one summarized the positions of the law enforcement officers at the various intersections and throughout the parade routes.
I'll make a note of that. I don't believe I saw the jury view instruction either. I mean, that was given to them at the time. I don't know that it needs to be reread, but I think we need to consider that as well. And that was my version of 152. All right, so let me go through the list from the state.
Real fast, I want to give a shout out to the viewers that popped in from A1 Media
61.
and Skinny Jeans Media. Big thank you for hopping in, and I appreciate you guys.
The request by the
all the
state.
positive support. Thank you very much.
I am going to rely on what information they
So again,
put in the
A1
charging
and Skinny Jeans
document.
Media,
I'm going to
shout
deny
out,
the
man.
request
Much love.
to
Go check them out.
include the specific case numbers. There's evidence, of course,
Back to
that
building
was
a fort.
received regarding the 2 separate cases out of Milwaukee County that form the basis for both of the bail jumping counts. It will be up to the jury to review the evidence and make a determination as to the verdict forms, though, that were referenced previously, at least the description of them in the jury instructions, that obviously the third account of bail jumping is incorrect. That needs to be battery, and that change will be made. I'm also having Madam Clerk include all of the numbers for the jury instructions when they go back, so it's very clear. Some of them did not have them on, just frankly from prior cases that she and I have worked on, but in this case, I want to be very clear with all of the numbers. So I think I've addressed the first 2 bullet points. As far as the motive instruction as a standalone, I believe that is appropriate. And I'll instruct Madam Clerk to include that.
You are not wrong, Julie. She says, I feel bad for the bailiffs that are in the other courtroom with him. Can you imagine the garbage language and emotional outbursts they're
Any
doing?
instructions that we add should just be in the numerical order, unless there's a other request that's made.
He's got 4 counts on this trial
And the
that don't
state
have to
also
do
made a
with,
request
that
as it
weren't
relates to jury instructions
directly
70
related to him driving the car through. There were 2 counts of battery and 2 counts of bail
found
jumping.
on page 65. So as it relates to this, the state is asking that I simply
Abel was a real one.
instruct the jury based on the pattern instruction and not include that second paragraph. I had previously advised the jury with another paragraph that I was contemplating including, even if I took out that big paragraph that just said, at times Mr. Brooks has appeared from another courtroom. This must not influence your verdict in any manner. What's the state's position on including that, but taking out the paragraph you request to be taken out?
It's fine.
Mr. Brooks, do you have any position on that? Which is, so jury instruction 70 has to do with the defendant proceeding pro se. The pattern instruction would be basically the first paragraph. I need the bailiffs to move the boxes away from his face. I need to be able to see him. He can keep them on the table, but they need to be moved off to the side. And if he does it one more time, Then I will instruct the bailiffs to take the boxes away. Those are trial prep materials. If there's something in those materials related to jury instructions, he should take those out now. Otherwise, they need to be moved away from the microphones and away from blocking his face.
I'm not putting them there, I'm putting them there for a reason. And nothing to do with her, and they can see.
Mr. Brooks, do you
And
have
now
any
he's losing
position
his
on
sport.
the verbiage of jury instructions
Don't ask me-
70
don't
on
ask me
page
no question.
65?
Don't ask me no question. Are you my accuser? Are you my accuser, Your Honor?
Or he's
This guy.
choosing not to answer, so I'll mute him again. It's unfortunate that he's deciding not to participate in this. I agree with the state. I don't need to highlight that second paragraph. I will take that out, but I will include in the paragraph that reads, at times, comma, Mr. Brooks has appeared from another courtroom, period. This must not influence your verdict in any manner. Inclusion of the instructions that were put on the last couple of pages include 325 impeachment of witness. Its prior conviction, the part about juvenile adjudication, should be struck from the heading. And it should read, evidence has been received that one or more witness in this trial has been convicted of a crime. There were 2 witnesses that was applicable to. The remainder will be as is. And that was 1 witness for the state, 1 witness for the defense. I just will add that if Mr. Brooks has any position about these requests, he should, he is currently muted. He can raise his hand and I'll unmute. Otherwise, he can pass a note to the bailiff or simply tell the bailiff, who can then tell me and I can unmute him. But unless he tells me, then I'm going to assume he's made a decision not to provide further comment based upon the last statement he made to me. Then 141, I believe that's appropriate given the evidence that has been received. That's on identification of defendant is in issue. That I will instruct the jury accordingly unless there's a request from Mr. Brooks to take that out. Is there a request from you, sir, to take 141 out? I'll unmute for that purpose. It's found on page 106 because it's at the end of the instructions. This is the instruction on identification of the defendant and where it's at issue in a case. I believe it's appropriate given the testimony in this case. Do you have any position on that, sir? You are unmuted, so you can simply answer yes or no. No response. Then 172, circumstantial evidence, flight, concealment, I believe is appropriate given the evidence that has been received during this case. Yes, sir?
Am I unmuted?
You have been.
Am I unmuted?
You are.
So how long before you mute? As soon as I say something?
Depends on what you say, how you say it, and if it's responsive to what we're doing.
Why do I have to be responsive to what you guys are doing? Nothing I say even matters at this point. So what's the point
Mute.
of me being responsive?
Mute.
You can't
Just
make
mute.
decisions for me.
Mr. Brooks, I'm going to mute you
Disgruntled
unless
11B.
you can
Thank you for that super
participate in
sticker.
what we're doing, which is discussing the jury instructions.
I'm gonna tell the jury the truth. That's what I'm gonna do. I'm gonna tell them what hasn't been told to me.
Okay. I'm pretty sure that
Mr.
your
Brooks,
entire defense is what you were
I'm
trying
going
to
to mute you
accomplish.
because we're trying to discuss the jury instructions, not what you're going to say during your closing argument. I will get to that later. In terms of instruction 172, I'll instruct Madam Clerk to take out of the heading the word escape. Should just say flight concealment. And then I've reviewed 154. I believe that's appropriate. I'm gonna pull it up just as a draft. I'm not sure if there's anything that needs to be. So the pattern instruction talks about a chart. Is there any request from the state as to just keep that or modify that in any way based upon the evidence that was presented? Because you actually submitted maps and things were received. I don't know that summary.
I think that there was a summary of the victims and the associated counts. I believe that that was exhibit 140.
Hey guys, sorry, I realized that we just hit a little bit of a snag, but yeah, it was unavoidable. We'll say that, unavoidable. So bear with me for 2 seconds here while I pull this back up. But there's going to be a lot of proceedings that are going to take some time. So I appreciate you guys bearing with us on all of it because it's a process. But okay. There we go. We're back in here.
Grannies is 54. 54 would be the dancing grannies,
Okay.
and 33 is the extreme dance team.
So 54, 141, and 33.
Yes.
Do you think the use of the word chart is correct, or should that be?
I would say diagram and maps. The court has allowed the use of diagrams and maps to organize the evidence.
The maps were evidence, though. What this instruction says is the court has allowed the use of a chart to organize the evidence and to assist you in understanding it. The chart itself is not evidence. It is a summary of some of the evidence that was permitted or presented. However, it is the evidence that controls. You should rely on the chart only to the extent that you believe it accurately and properly summarizes the evidence.
Then we think 154 should not be given
That's what I was wondering.
because
So
they were all admitted.
they were all admitted based upon how they were presented and the
I apologize.
testimony regarding them. Typically, where that comes in is for use in openings and closings solely that are based upon evidence, and we anticipate those things coming in, not when there's been an actual document that's been admitted. So I don't think 154 is needed, and I'll deny that request. What about 152 regarding the view?
Your Honor, as I read that, that was given prior to the view, and I think that was appropriately given at that time. I don't believe it goes into the closing or the final instructions.
That
would
was
be position.
my inclination, but I wanted to get the party's position on that. I'll once again unmute Mr. Brooks and just ask him if he has any position regarding any of these last issues that we've discussed with, as it relates to the jury instructions. Anything from you, sir, on the jury
How do we think
instructions?
that's going to go?
He's not responding to the question.
It made me nervous. Steady
I believe
looking over my
that covers
shoulder.
all of the issues that were raised by the parties then.
Almost appropriately, so will he.
You are. I'll give you one final opportunity to tell me if you have any requests as it relates to the jury instructions, sir.
I didn't think nothing that this all been talking about, and I say y'all because I haven't been participating in none of that.
I understand,
You've
sir.
chosen
Your
not to
objection's noted.
participate, you raging
Your lack of
asshat.
consent is noted.
Okay, I don't see what's going on in there. So how the decisions being made
You
without.
can't put me in
being
time out because I closed my ears and shut
Sir,
my
you
eyes.
forfeited
I
your
didn't know you
right to
said
be
that.
present in this courtroom by your conduct, and you have not
Well,
requested to come back.
Actually,
Actually. Break. So let's make sure the record is correct.
let's make sure of that.
10-minute break,
I did.
at which time I was brought back into this courtroom.
I was advised you wanted to stay, sir.
Okay, and you've been forcing me to come over here from the get-go. Why couldn't you force me to come back over here where I'm supposed to
We
be?
can't force you to come over and disrupt court.
Sir, my understanding is you requested to stay in the other courtroom. I thought I put that on the record at the
Very.
beginning. If I did not, I'll make that part of the record now. I was advised by the bailiffs that you were requesting to stay in that courtroom. I certainly advised you prior to that if there was a time you wanted to come back in, all you needed
Big
to
moves,
do was
Barry.
ask. You've done that previously.
Big moves.
Yeah, but
And
see you there,
even during this time though, you've been incredibly disruptive
I can't say
during, I mean, at one point you were muted for an extended period of time and you were yelling so loud, sir. We
Love you,
could
Barry.
hear you in this courtroom. I couldn't decipher
Don't
what you
tell
were
him that.
saying.
Ugh.
And I was also made aware that another branch could hear you. So you continued your
that's
disruptive behavior.
That's fine, because at the end of the day, I should be heard. I have the First Amendment right to be heard. So if I'm gonna be constantly muted, the only way for me to be heard is for me to raise my voice.
Mr. Brooks, one final time, do you have any requests as it relates to the jury instructions? Otherwise, I'm going to approve them. I'm going to take a break and then we'll come back in the afternoon to go over verdict forms.
I didn't answer yes or no, so how do you consent to anything without me answering the question?
Are you going to answer the question, sir?
But you can't force me to do it. You can't just say, I'm gonna do this. Because
Sir, but you also can't stall the proceedings by failing to answer.
I didn't try to start the proceedings. You the one that held me in contempt.
I never held you in contempt. All right, I'm going to mute him once again because he refuses to answer a very simple question about whether he has any requests as it relates to the jury instructions.
object to being muted.
I will work on making all the changes with
Funny, 'cause I
Madam
was just
Clerk,
muted. And
finalizing the order, print them off again. She has been working on the verdict forms, which are of course separate, which need to be approved by this court. So those will be printed off.
Griffin,
A
tell
set
everyone
will
I
be
said hi.
provided to the state. A set will be provided to Mr. Brooks. We'll take I'll do a 90-minute lunch break. So it's 11:27. So we'll come back at 1 o'clock to finalize the verdicts and the jury instructions.
And Your Honor, with regard to sequestration of the jurors and the alternates and those issues, did you want to address those this afternoon?
Yes.
Okay.
We can do that.
Thank you.
I can put on the record that I had the civilian jury bailiffs provide the parties. We have a letter regarding sequestration. There's an emergency contact form. So all of the jurors were made aware of that. They know that. Of course, once the case is, all of the instructions are read and the parties make their arguments, and then there's some final instructions at the end. and the case
Touche.
goes to the jury, obviously only 12 of the 15 will be deliberating.
That's it. No
But we
witnesses.
can make a more full record of that this afternoon.
Thank you.
All right, we are in recess until 1 o'clock. I'm just instructing the parties to stay until the handout of the verdicts, and then you can leave for lunch. Thank you.
So we'll see if they have anything else to say here. They're going to be, there's still some jurisdictions. So as it says here, it's giving a 90-minute lunch break and then back at 1 o'clock Central Standard Time, which is 90 minutes from now. She's making the jury instructions, then closing statements after jury instructions are read. Then final instructions are read after closing. So we have a few other court procedures that we have to go through here. But while we've got a few minutes of time, let's go ahead and check out a couple more videos of just how wild and ridiculous Darrell Brooks can possibly be. So that always excites me. I'm always looking forward to reminding myself of what just an intolerable POS this guy really is. So let's jump down that rabbit hole, shall we? And here's one for you. That'll be fun. This is when he flips out on the prosecution for revealing that he's a sex offender. And, you know, what a horrible, horrible thing for them to do. This is when this is what I was talking about earlier, when he was trying to basically showcase that his Erica Patterson, that his ex-girlfriend was a bad mom, was what he was going for. So this was that exchange.
State has the ability to question you about that
Let's go.
without having that letter.
So this is
So
because he wouldn't bring in the letter from Erica Patterson when he was showing those pictures that he said were from Erica Patterson, but he still wouldn't bring in the letters even after the break when they said, you can go back to your cell and grab those letters and prove to us that she wrote that letter, those letters to you. But of course, he was unable to provide said letters. So
the ability to question you about that, or question this witness, and to look at the veracity of what your claims are here. So when I may take an early lunch. If that's in your cell, then you can go get it and bring it. But without that letter, I'm not allowing this line of questioning. Do you have the letter with you in court?
I just said no. How many
Okay.
times I got to say the same thing?
but she's saying, go ahead and go grab it.
You know, sometimes, sir, I don't hear what you say because you interrupt me so much or you answer quietly. And I'm taking notes and I'm focused on probably a dozen things at the same time.
But if I say something under my breath, everybody seems to hear it. Everybody seems to hear
In
that
a
just
quiet
fine.
courtroom,
And
yes,
everybody
we can hear it very
and
clearly.
everybody assumes that it has to be disparaging. or-
Once again, you're doing this tactic
because
to try to
it's
go
not a tactic,
off
it's
of what we're
facts.
talking
It's
about
facts.
to some other reason.
It's facts. Because
some
I
other
find
thing.
it hard to believe that
I'm going to
all
let
of
the
a sudden
state.
nobody hears what I say.
I'm going to let the
Come on,
state
man,
make a
stop.
record of why they
Stop.
believe it's objectionable because I haven't let them do that. I've given you multiple
Chad, I
opportunities
will.
to tell me why you
So
believe
I
it's.
didn't get these pictures from nobody else. Why was
The
somebody
record will
else
reflect you have two pictures that you believe were from this witness.
that I know is from
No, that you believe.
that I know?
All right, I'll ask the state their position on all of this.
My position, Your Honor, is that these pictures, first of all, should not be admissible. One, because of a discovery violation. We've never seen them before. Two, because we have reason to believe that he did not get them from Erica Patterson. He is on a jail phone call talking to his mother, Dawn Woods,
Oops.
about Dawn Woods sending these photographs to him. Now,
That's a lie. I object to
Let the
that.
state make their argument without interruption, sir.
That's a lie, though.
three, I believe that these photographs are designed to make a suggestion to the jury that Erica Patterson is a bad mom. I think that is what the defendant is trying to do. And if we're going to go down that road, then we would be forced to counter that claim. First of all, it doesn't make her an incredible witness, if it's even true. And second of all, if we go down that road, we would be forced to counter that claim by pointing out that not only does the defendant not live with the child in question, he doesn't live with any of the other children that he has. He impregnated Erica Patterson when she was a minor in Nevada. And for doing so, he was convicted of statutory sexual seduction, pled guilty in March of 2007 to that felony offense, and is a sex offender on the registry as a result. So if there's any causation that would lead to Erica Patterson being a bad mom, Mr. Brooks has a direct role in that causation.
And that's
Furthermore,
I object to that
I'm not
because
done.
that's a lie.
Let
Because
him
at the end
finish.
of the day,
Let
if
him
we
finish,
don't open the door
Mr.
on that, no,
Brooks.
since he want to make a record and not be accurate, so let's be accurate all on the record since you think you know so much.
Once
So
again,
we can
Mr.
open the
Brooks
door
is
on.
being
We can open the door on how old she told me she was when we met.
interrupting.
We can ask
He's-
that
he
question
is
too. Then
over the
did you
top,
ask that?
animated
Do you
right
know
now.
that?
Mr. Brooks, I'm ordering you to sit down and to let the
No,
state finish.
I'm not going to sit here and let somebody be inaccurate on the record and lie on the record.
Right. Under Illinois versus Allen, I've warned him repeatedly. He's being removed from the courtroom. And you know what? Let me dial that back. We're just going to take an early lunch, 1 hour. We'll be back. And unless he brings that letter and he can show it is inadmissible,
Which he doesn't
will
bring.
not be questioned.
No letter
and under
presented.
906.11, I will declare the cross-examination closed.
Closed.
Thank you. We're in recess 1 hour.
Get your facts straight. So let's open the door on all of it again so we can get all of it on the
I was
record.
not present for
Since
this.
you think you know so much. Did you know she said she was 18 when I met her? Did you know that?
Now we're at the end of the third week of trial. These are your witnesses. I presume that you
So
are
many-
prepared in whatever
so
way
many
that is.
videos,
You're
guys.
not
How
going to
can I be
hold it up.
careful?
I have the video queued
so
up with the
witnesses
officer.
is just supposed to get up there and just, I'm just like,
I'm
yeah.
not going to have this commentary. Okay, I'm done. The jury's coming out. Be prepared to call
So
one
that's
of the
a
three.
rush to judgment.
That is not a rush to judgment.
It is a rush
Again,
to
I'm done.
judgment.
This is okay.
It's clearly a rush to judgment.
This I'm sure we were watching this a little bit earlier, but this is when he was basically telling the judge, "How am I supposed to? Let's okay, we'll watch this for a minute or two. But there's a couple of that I feel like are, yeah, that are good. But we got to keep watching these. They just keep getting better.
Judgment. If I'm telling
More
you that I
horrific
don't
and-
have the
No,
file,
in my
how am I
opinion,
supposed?
you're attempting to delay. So
No,
let's
I'm not.
keep
I'm
going.
not attempting to delay nothing. You want to come check the boxes yourself?
As the jury's walking in, of course.
You always trying to pull some fast maneuvers.
Mr. Brooks,
And Miss Judge, Your Honor,
Mr. Brooks, the jury's coming in.
yeah,
Show
and
respect to
they
the
deserve
jury.
to know this too. It's still issues that need to get addressed. We didn't even address
Mr.
everything.
Brooks, I addressed all of the issues.
No, I
You
still
know it.
had another one that didn't have nothing to do with nothing we just talked about.
All
There
right.
was a whole nother issue that needed to be addressed that I needed to
And we'll
bring on
address
the
it
record to
later.
your attention.
We'll address it later.
It needs to get addressed now before we go any further because it's an important matter. Just like the subject matter jurisdiction is important, that hasn't been proven on the record.
Ladies and gentlemen of the jury,
Just
this
like
is
the
not
rush to
the
judgment.
time for evidence to be presented or arguments to be made by the
I
parties.
can't
The
even
jury
present
will
any evidence. You won't let me even put
disregard
any evidence in the record.
all of these
Which
statements
is a
made
rush to
by
judgment.
Mr. Brooks
That's
at this
unfair.
time. All right.
That's unfair what
The
you're
court
doing.
will address legal matters outside the
Then we
presence.
need to
Everyone
address
can
the
be
legal
seated.
matter that I was trying to get to before
And
you
you
rush
may call your
everything
next
out.
witness, sir.
I'm not calling any witness until I get an answer, Your Honor. You're a public servant. You're
Mr. Brooks,
supposed to be able to answer simple questions.
Mr. Brooks,
If I'm saying I have to bring
call
it to
your
your
next
attention,
witness, please. That's the stage that
I have
we
to
are
bring
at.
it to your attention, Your Honor.
Mr.
I'm
Brooks,
merely seeking
please
to bring
stop.
an issue to your
I'm
attention.
telling you to please, I'm asking you to please
And I'm
stop
asking you,
because
can
we
we
have the
address?
jury present
I'm asking
and
you.
we need to continue with the evidentiary phase of this trial. Call your next
I'm
witness.
asking you to address a legal matter, as you said that those have to be taken up outside of the jury.
I will
There
do
was
that
a
at the
legal
next
matter.
break.
There was a legal matter that needed to be addressed beforehand,
I
so
will
we
do
don't
it.
have to take up time,
I will do
valuable
it at the
time
next break.
afterwards to address something that needs to be addressed now. That way,
Mr.
the
Brooks,
court and you
For the
yourself
third
are on
time,
notice.
I will address it at the next break. Call your next witness, please.
Are you asking me,
I'm directing you to call your next witness.
Your Honor? We're not going to move past this, seeing as how you took an oath to protect the Constitution. I have your oath. I have a copy of your oath right here. The oath that you took, Your Honor.
Mr. Brooks, I'd like to continue with testimony.
Sir.
We have witnesses waiting for you. Please call your next witness.
The oath that you swore to protect the Constitution, which you are now not doing.
Mr. Brooks,
So you're going
call your
against
next
your
witness,
sworn
please.
oath. You're going against your sworn oath
Mr. Brooks, call your next
As you,
witness.
as you notify the jury every time when there's legal matters, we take them outside of their presence.
And we're going
I
to take
didn't-
testimony right now. Call your next
I merely
witness.
seek to put you on notice on the record for something that needs to be brought to your attention and
And
to
I
the
will-
court's attention.
And I will address it at
That's
the
what
next
I'm
break.
merely seeking to do. It's something that shouldn't have to wait because it'll take a valuable time later. At least if I notify you right from the onset, you'll already know what we're looking at, and we can nip it in the bud before everything starts to roll. And
Mr.
then
Brooks,
it gets
I will
overlooked.
address it at the next break. If you want to write something down, that's fine, and give it to my clerk. I have nothing in writing. I know there's witnesses available and ready to go. Call your next witness.
Your Honor, Your Honor, you have to answer this question. You're
Mr.
making a
Brooks,
judicial determination.
Call
to
your
rush
next
me to
witness,
judgment.
please.
You're rushing me to judgment, Your Honor.
There's no rush to judgment
There is
here,
a rush
sir.
to judgment. If you won't address a legal issue that I informed you that I had some legal issues that needed to be addressed before you just run right past that, Your Honor. You're a public
Mr.
servant.
Brooks,
Are you not a
it is
public servant?
9:37. Call
It is
your,
8:37.
sorry, 8:37. You're right. Call your next witness.
Your Honor, you're rushing me to judgment.
There's no rush to judgment. Call your next witness,
We had
please.
a legal matter that needed to be addressed, and I'm merely trying to
And I'm
notify the court.
telling you
at
I'm
the
denying the
onset-
request to address it at this moment. Call your next witness.
You said what?
I'm denying your request to address it at this moment. Please
How
call.
can you deny
please-
something that we're supposed to do before
Mr.
the jury
Brooks.
even comes out?
Call your
I'm
witness.
not seeking to be disruptive. I'm just seeking to understand why we do this
Everyone
every day.
is in the courtroom waiting for you. Please call your
Your
next
Honor,
witness.
we do this every single day. We've done it every single day. So I'm simply trying to make sure that the court is notified of
Put it
things
in
that need to
writing,
be
hand it to the
discussed.
bailiff, and if I deem it important enough to interrupt the witness, I will, but call your next witness.
How can I call a witness and write something down and do
You
do
can
both?
take a minute
This
to
is the
write down what it is.
This
I'm
is
not
the
asking
reason
you
why
to,
it needed to be addressed beforehand.
Mr. Brooks,
That way
the
it
jury
doesn't
is
become an
remaining in
issue.
this courtroom. Call your next witness, please.
Your Honor, you're rushing me to judgment.
There's no rush to judgment, sir.
Are you not a public servant, Your Honor?
Mr. Brooks.
Do I not have your oath of office?
Under 90611, this court has the authority, as you know.
Do I not have,
Call-
is this not a copy, or I asked for certified copies that you said on record that you would not provide for no good reason, that these are three
Sir,
of your
you are
oaths.
doing this,
right
and I've
here.
repeatedly told you, you can see the jury's here.
You're
You're
doing-
doing this.
Listen, Your
We
Honor,
need to go
I'm
forward.
not attempting to delay the proceedings. I'm not attempting to be disruptive. I'm merely trying to notify Your Honor in the court for the record beforehand. That way, everyone's at least on notice of the issues that need to be taken up, instead of waiting until a break or a lunch and things of that nature, which
In
kills
my
valuable
discretion,
time.
it's my authority. It's the courtroom that I'm
Your Honor.
presiding over. I'm not going to address
Is
that
this-
at this
Is
moment.
this not your
And
oath?
I'm not going to answer
Did you not
questions.
swear as a public servant that you will protect the
Mr.
United
Brooks,
States Constitution?
Call
Did you not do that?
your
3
witness.
times. I have all of them here. Your oath, Your Honor, as a public servant. And
Mr.
now you're
Brooks,
rushing me to judgment
there's no
when
rush
I'm
to
doing
judgment.
things lawfully by trying to notify you and notify the court of issues that need to be addressed
Mr. Brooks,
beforehand.
We are in
These
the
were issues-
evidentiary phase of this trial.
Your Honor, you're
Call
rushing
your
me to
next
judgment.
witness.
You're rushing me to judgment, Your Honor. And I object
I'm
to
aware
that.
of 3 witnesses
I
who are
object-
here.
I object
Call
to
one
that.
of them, please.
Your Honor, I object to that.
Your objection's noted.
And
for the
I
record.
want a legal reconsideration of your ruling. If not, I reject that ruling and take exception to that ruling.
I understand.
I request a legal or factual basis for your ruling, a written judicial finding of fact and conclusion of law for your ruling. And if not that, an interlocutory declaratory appeal for this matter. And if not, these need to be stayed until this matter is before a adjudicated court of competent jurisdiction, because we have not proven jurisdiction in this court as of yet. Subject matter jurisdiction has not even been proven on the record, Your Honor. I don't even know the true nature and cause of the
Mr.
charges
Brooks,
against me. I don't even understand that part
I
of it.
understand
I haven't
your
been
request.
provided a complaint. I haven't, Your Honor, there's so many issues.
Mr.
and
Brooks, we will take,
I'm not attempting to
Mr.
be
Brooks,
disrespectful in any way.
we
I'm
need
not
to
attempting
continue.
to delay the proceedings.
Your
in any
requests
way.
are denied.
Your Honor, I
And I'm going to
respectfully
instruct the
object
jury
that.
at this point to
I
disregard
respectfully
and not
object to
consider
that, Your
any
Honor.
of what has just happened since you walked in, it should not be held against Mr. Brooks in any way. These are legal issues that this court may or may not need to address, but they do not bear in any way on ultimately the issues that you as jurors will have to. For the record, I have received exhibits 1, 3, and 5. With that, the state may call its next witness.
Thank you. The state calls Erica Patterson.
All right, guys, I'm gonna.
Good morning, Ms. Patterson.
Actually, I think I'm gonna give you guys a
Thank
different
you.
video here. This was from day 5. Now, mind you, that was the first time that she was put on the stand. He recalls her as a witness for the defense, which was when all of the last things happened where they said, hey, present the letter. He couldn't do it. There was a back and forth about that. There is the, sorry, if we go back here, I've got 1 second. I'll show you guys. This was the officer that shot at Darrell Brooks when he was driving through the parade. I'm going to give you guys that one real fast here. And apologize for the camera here real fast. I'm just having a mess with something. But here, I'm going to give you this video. And boom, here we go. It's a whole process, guys.
Approximately a minute or so later, I believe I started hearing radio traffic on both channel 3 and channel 1. I believe either a reserve officer or a community service officer on channel 3 requested an ambulance somewhere on the eastern portion of the parade route. I remember it was sort of towards the beginning of the parade. They were asking for an ambulance because someone had been hit.
Then what happened?
I believed that it was something stemming from the domestic or the fight, because during that fight, someone had fled on scene and someone had been flagged down who had reported this incident. So I believed that the hit was something to do with the physical altercation that had happened. Moments later, this was all sort of spun out of control very quickly. Radio traffic became more and more difficult as channel 1 and channel 3. So as officers on the road and officers and community service officers and reserved officers were working the parade, everyone was starting to get on the radio, and more people started calling for ambulances. And then I could tell as people were calling for them, it was moving westbound on the parade route.
What did you do as a result of hearing that information on the radio?
It was tough to piece all together. I didn't know exactly what was going on. I knew something was happening, but I didn't know exactly what. I have a collar mic, so my microphone was approximately right about here on my chest. I don't have an earpiece. That's just what I use. So between trying to listen to the radio microphone and the parade, it was sort of hard to piece together. But after a few minutes, I realized something was happening. I began walking away from my post, and I walked past my barricade sort of into the parade route. And as I did that, I was looking more to like northeast. I couldn't see that much of the parade because where West Main Street ends right there, it's got a hard turn to go southbound to Wisconsin. So I could only see approximately, I don't even know, maybe 100 yards or less of the parade route. And at that point, that is when I started hearing more screams. And this time it wasn't just screams on my radio. It was screams like in my vicinity that I could hear. And at that moment, I saw a red blur come past the Wisconsin house westbound and make a very hard braking maneuver to navigate the left-hand turn on West Main Street to go
there, and let's put
southbound.
exhibit 1. Sorry, let's put exhibit 1 back up, please.
As you're putting Exhibit 1 back up, I just want to make a record of the hand gesture he made previously when testifying about, I believe it was his radio microphone. He used his right hand, I would say about heart height, to indicate his, I believe he called it a lapel mic or something to do with his radio and where he would hear from. Go ahead.
Objection. I don't think he said lapel. I think he referred to the microphone just being here and not using the earpiece. That's just.
Your objection is noted. The state can seek clarification, but the fact, I did my best to describe the action of the officer on the stand.
He obviously
Go
knows
ahead.
the typical outfit
Can
of
we
a
zoom in on
officer
the
of
bottom
the
left
law.
corner of this map? You mentioned the Wisconsin house. Can you describe for us where that is?
The Wisconsin house is actually this building right here that is tan. It's the farthest building right before, I guess, on the left portion.
You just put a little dot there.
That should be the Wisconsin house.
Okay, so the right as the Main Street curves to the left there.
Correct. It is I believe it's the last building sort of on West Main Street right before the left turn.
So if you were standing in the intersection of Wisconsin and Main, the Wisconsin house is the building that would obstruct your view further east up Main Street?
Correct. There's a parking lot to the left as you look at the screen, and the vehicle's parked there. So I can't even see pretty much anything in front of the Wisconsin house on Main Street from my location.
We can take that back down, please. What happened as the red blur rounded the corner?
I realized what was happening at that point. I recognized it was a red SUV and there was extreme vehicle damage to it on the front. The hood was smashed up towards the windshield, the front portion, the front bumpers, the fenders, everything was, it was extreme vehicle damage, like vehicle damage that you would see at a traffic crash between two vehicles. At that point, between all the screaming I heard, everyone calling for ambulances and help, and then realizing people hit, I knew it was now people hit by a vehicle, and I knew that those initial requests were so far eastbound on the parade, and now I'm at towards the end of the parade, or at least the end of the portion of Main Street. I knew that this vehicle had likely, and based on the speed of the vehicle, that the vehicle had ran through the entire parade route and likely severely injured people or killed people. And at that point, I thought it was a terror attack at the parade.
What happened as the SUV continued southbound?
As the vehicle navigated its turn to go southbound, it accelerated towards me. That is when I knew I had to use deadly force to stop the threat. And as the vehicle was approaching me, I remembered making the decision that the easiest shot likely would have been through the windshield. However, I remembered the entire backdrop were just surrounded with kids and people. So I waited for the vehicle to pass me and tried to direct my rounds as most southern as I could because there were less people in that direction.
Which is crazy.
Standing in the intersection as the vehicle passed you.
At this point,
there's so many people there that you couldn't even like fire shots. But
northbound.
It's wild that he's able to get me off
slightly. So I was, I believe, just out of the intersection at West in Wisconsin. So I was on, I believe my shots, I was technically on Main Street at the time when I began shooting.
Using cardinal directions, can you describe for us which side of you the SUV passed?
Objection. What is cardinal?
Overruled. The witness may answer.
The vehicle passed to the east of me.
What direction were you facing as it first started to pass you?
I was facing north.
So that would have been on the vehicle would have passed you on your right.
Correct.
Okay. How close did you come to the vehicle as it passed you?
It was very close. I believe at the time, I remember stepping to my left. It was so close, I felt like I could touch the side of the vehicle.
Could you see into the vehicle?
Yes, I could.
How many people could you see inside of the vehicle?
I saw one person.
Where was that person in the vehicle?
That person was the driver's seat of the vehicle.
Did you get a good look at the driver?
Yes, I did.
Do you see the driver in the courtroom today?
Yes, I do.
Your Honor, I'd ask Mr. Brooks please remove his mask for a moment.
Thank you for doing that, Mr. Brooks. His mask is off.
Can you identify the driver in the courtroom if you see him?
Yes, the driver is seated at the defense wearing a blue tie and blue shirt underneath his suit jacket.
Does the record reflect that the witness has identified the defendant?
The record will reflect the witness has identified the defendant as the driver of the vehicle he saw on November 21.
So, excuse me. I apologize. There's a ton of videos here that really showcase. Well, these are some of the ones that. This is okay. So the full testimony is pretty wild. Here's one. Who is? Yeah, here's one little. This I love this guy. So someone asked earlier, like, how tall is Darrell Brooks? And this is probably the best answer I've seen to anything. The best answer to that question you could possibly give.
Thank you, sir. I don't have any other questions.
All right, sir. Mr. Brooks, do you have any questions for this witness?
And this is the guy who had Darrell
Yes, I
Brooks
do.
in his
And I
yard
object
after
to
the
it. You
attack.
called that name for the record. Do you recall giving a statement to Officer Probst?
I don't know his name, but I've talked to an officer.
And you did talk to an officer that night?
I talked to an officer on the phone. I did not talk to an officer that night. I mean, on the phone I did, but not in person.
So it was a conversation on the non-emergency line. Would that be fair to say?
It was on the non-emergency line. I actually confirmed it after I called to make sure I was on the non-emergency line.
Do you recall the description that you gave at that time?
I do. Well, my best of my knowledge was that you were either Black, Latino,
Who's you?
or mixed.
Who's you?
Hold on, you have to let him answer the question first before you interrupt him with another one. Go ahead with the
Who
description
is
you
you?
provided that night.
I said that the individual was either Black, mixed, or Latino.
So it'd be fair to say you didn't know at the time.
I was giving a general description.
So it'd be fair to say that you weren't sure.
I was positive that it was you.
Who is you?
You. I'm looking at you.
Well, I don't like that. I object to you saying that.
And how did you come to that conclusion, the you conclusion?
I'm looking at you.
How did you come to that conclusion? Did you?
What conclusion? Can you restate the question?
You're saying that you gave a description on the non-emergency phone line, correct?
It was on a non-emergency line.
So it would be fair to say at that time you had no name or knowledge of who the person was in your backyard. Would that be fair to say?
I had no idea who you were.
And so how can you say how can you say you then if you had no idea?
I'm looking at you. You were the guy.
And how did you come to that conclusion?
You and I were standing in the same yard looking at each other.
Oh, man.
So is it possible you saw something on the news?
No, I had no idea who you were.
I object to being called you.
Interesting. Do you recall giving a description of approximately 5'9" and 160 pounds?
This is the best. This is the best.
Yeah, something like that.
Something like that, or would that be accurate?
I didn't have a tape measure out. It was just a guesstimate.
Would it be fair to say that since you keep identifying me as you, would it be fair to say that I'm not 5'9" nor 160 pounds?
Do you have your shoes on or off right now?
Would it be fair to say that I'm not 5'9", 160 pounds?
If you take your shoes off and step out of them, they could have a better.
Well, I'm not going to have
better.
them do that, but if you're able to answer the question.
Take your shoes off.
I'd have to be standing next to him. That's what I made my judgment from. We were about 2 feet from each other.
Does it look like I'm 5'9"?
I don't know. We were a lot closer.
Does it look like I'm 160 pounds?
Objections.
Grounds.
140 soaking wet,
His
man.
appearance today, just like his hair isn't in dreadlocks today.
Sustained.
Objection.
Question.
Grounds for the.
Who is you? Excuse me. It's the best. It's the best. And then say, oh, well, your shoes on or off? I said, well, kick those shoes off. I'll take a look, man. But as it is right now, I don't know. You have to take your shoes off. So people have asked some questions about Darrell Brooks representing himself in trial. There was a video that was a defense attorney that I saw that this is from about 4 weeks ago when he first made the request, and then there was an attorney that was that explains a little bit about what that's all about and how he was being permitted to represent himself. So let me show you guys this real quick.
Driving through Waukesha's Christmas Parade and killing 6 people, now says he wants to represent himself in his upcoming trial, which is scheduled to start in less than 2 weeks. The move could delay the trial, and people in Waukesha are upset.
Just going to drag things on for all these people and keep the wounds that are already massive open for much longer than they have to be.
The judge in the case is expected to decide next Tuesday whether Brooks will be allowed to represent himself. Now, Darrell Brooks has already been found competent to stand trial, but there's a higher standard for determining whether a defendant is competent to represent themselves. Ben Jordan goes in depth with a legal expert about the likelihood of the judge allowing Brooks to be his own lawyer.
A local defense attorney says it's not only possible, it's likely that Brooks will be found competent to represent himself at trial. Wisconsin law says a defendant should only be denied that constitutional right if a disability is identified that would prevent them from offering a meaningful defense. Just 10 days before jury selection is set to begin.
It's always shocking when a defendant wants to represent themselves.
Darrell Brooks wants to fire his public defenders and represent himself at trial.
This is a big development in this case.
Jonathan Lavoie is a defense attorney who isn't involved in the case.
I think he's making a huge mistake.
Lavoie says the judge presiding over the trial will determine next week whether Brooks is mentally competent enough to go it alone. But first, she will likely try to talk him out of it.
Do you believe he will be found competent to represent himself in trial?
Well, we haven't heard too much from him in most of the court hearings. He's had some erratic behavior. I believe if he answers basic questions about being able to follow the rules, that he is able to understand the severity of the charges, that he understands the pros and cons of his decision. If he's able to cohesively answer the judge's questions, I think he will be found competent to be his own attorney.
A couple weeks ago, Brooks withdrew his insanity plea. Instead, he's pleading not guilty to killing 6 people and injuring dozens of others in the Waukesha Christmas Parade tragedy. Lavoie says if Brooks is allowed to represent himself, he would be assigned what's called standby counsel, which is an attorney there to advise a defendant but not actively participate in the trial.
What are the pros and cons of a defendant representing themselves in a murder trial?
But it's almost all cons. A person like Mr. Brooks does not have the knowledge of what happens in court, doesn't have access to computers, legal research, doesn't know what motions to file. So a person like Mr. Brooks who's representing themselves typically makes a mockery of their case and oftentimes hurts their defense dramatically.
Lavoie says not only would Brooks's decision to represent himself make the trial more difficult for him, but also for victims and witnesses who are subpoenaed to testify.
A defendant has the right to cross-examine and confront their accusers and it has to be done in open court. So they would be required to answer questions of Mr. Brooks. And that's probably going to be the most challenging part of this trial if he is allowed to represent himself.
Lavoie says if Brooks is allowed to represent himself, it would prolong the trial, but he does not think it would be postponed just because of this request. Ben Jordan, TMJ4 News.
As we near the trial and the anniversary of the tragedy, a reminder for the first time, TMJ4 is offering live coverage of this year's Waukesha Christmas Parade. It's set for Sunday, December 4th at 4.
So that's an explanation a little bit about being pro se. This is this is what it looks like when you represent yourself. When you're an asshat, like Darrell Brooks here. This guy. Here we go. This is listen to the first question he asked it. So this is one of the witnesses that that he's asking questions to. This is one of, mind you, one of his witnesses. This isn't one of the prosecution's witnesses. This is one of his witnesses. And this is how he handles his witness. It's too much, man. It's too much.
How are some of these answers allowed to pass when they're coming straight from reports made by the people on the stand? Very curious.
I don't understand your question. I'm not sure what you're asking me.
What I'm asking is, reading from the report that the people on the stand are giving, the report that they gave to law enforcement.
If you're asking me whether there's a mechanism in the rules of evidence and how to establish that before the jury, the answer to that is yes. If you're asking me how you do that, I'm not going to answer that.
All right.
And that's because
Argument on your part, sir. It is pure, completely speculative on
trial, obviously.
I skipped
and how to establish that before.
But one of the things that she's doing there, and this is important because she's been doing this throughout the trial, is she's telling him that yes, this is everything to avoid any kind of mistrial, also to avoid any access to any grit in the appeal process. What she's saying is, yeah, there is a way to ask these questions when you have the jury, when you're asking this so the jury can hear the questions being asked properly. Am I going to tell you how that is? No, you got to figure that out. And this is when you represent yourself. Due process procedure, the acts of accountability are laying solely upon your shoulders. You have nobody else. I mean, here's the thing. Had he been represented by an attorney, he might have had more grounds for a mistrial had they not asked certain questions. He could have been taking notes, thinking of all the objections that weren't given, all the things. Like, he might have been able to pull that and then be like, you know what? I don't feel like I was properly represented by the state appointed attorneys. I would like to move for a mistrial, like the motion for the appeal, because I feel like I was improperly represented. Then he could have done this whole process all over again, self-represented. But what he's talking about with this witness is he's saying that the witness isn't giving the same answers that she gave in the testimony in the report she gave to the police a year ago. And the issue they have in this is a lot of hearsay law, right? So the police have already testified that the report that they took is a summary of the events that took place per the witnesses that they investigated. So, as it's been pointed out that it's a summary that they're looking at, that he's going off right now, it's not a word for word document that this witness said, right? So if there was an actual, like the court stenographer type thing, or if there's an audio recording they can go off of, that'd be different. But because it's an interpretive format, he's asking her to fill in the blanks. And what she's saying is, I don't really remember. Or maybe it's different than, I can't quite recall, or what she says might not line up exactly with how it was interpreted in the report by the officer who took her statement a year ago. Mind you, so there's multiple steps of process that take place here. So this whole thing is leading to him being pissed off because he feels right now that the witness, well, you'll see. This is his, watch Darrell Brooks go into his Darrell Brooks mode, as we've all seen it. So
before the jury, the answer to that is yes. If you're asking me how you do that, I'm not going to answer that.
I didn't ask how. I just, to be blunt, which I've been since the beginning of this trial, obviously. I see the whole strategy here by the prosecution. I see right through it.
He thinks he's so smart.
Don't have any cross-examination, mainly because you've already schooled the people getting on the stand on how to answer certain things.
Well, that is completely speculative on your part without
It's
any
obvious.
basis in law or
It's
fact.
obvious.
Sir, you could ask questions that establish that. You can ask them if they've met with anyone. You haven't done that. So for you to say that right now is without basis. If you want to,
It's clear.
if you are looking to
Maybe to
elicit
you.
what they said in the report, there is a way under the rules of evidence based upon the way the witnesses have answered to clarify that. But that requires you to call certain witnesses. I'm not going to give you any more legal advice further than that.
I don't think I have to
So
call any other witnesses. That's
if you're asking me to strike their testimony based on your
I didn't say
perceived,
anything
then that's
about that.
all right. Then I'm going to bring the jury back out and you're going to call your next witness. So I'm
So
not
is you-
hearing a request from you at this time. You said you wanted to raise a legal issue. What's the legal issue?
The legal issue is how is the state allowed to coach the
You're
people getting on the
assuming they
stand?
spoke to them and coached them.
It's obvious. I'm not stupid.
Well, I disagree with that, sir. Again, you could ask
All of a
questions to
sudden-
lay a foundation
All of a sudden, the
with
state
these
don't got.
witnesses.
All of a sudden, for the first time in trial, all of a sudden now they don't got no cross. That's clearly a rush to try to get through the case. Hurry up. We just gonna let these people go.
Well, this is
And not-
argument.
Come on, man.
This is argument on your part,
I
sir.
see
It
through
is
it.
pure
I just
commentary
want
at this
that on the
point.
record.
He said, I'm not stupid. She said,
And
well,
your
I disagree with
through-
that.
But I see through it.
Has absolutely no basis in
Yeah,
fact.
I know that's what's being done.
You
Come
could
on, man.
ask
I'm-
these questions. You could
Come on,
ask
man.
these
Got the right
witnesses
one.
certain questions, and you're
far,
not.
far from an idiot.
They're your witnesses, sir. If you believe,
So I'm gonna start.
Let me go ahead and say this as well. Earlier today, there was some discussion about him not being intelligent enough or know enough to properly defend himself. The conversation was interesting. It was very respectful and very courteous. You guys did a good job in the chat of, asking questions and clarifying. But he himself is saying repeatedly, I'm not dumb. I'm no idiot. I see what's happening. I understand the strategy at play. I understand, the games that are being played. He's talking past the, basic computation, if you will. He's looking at it from the, from the macro view is what he's trying to say. He has this oversight of it. This is not him claiming ignorant. What he's saying is he sees things for more than what they are. And for someone who's ignorant, they're ignorant of what's happening here. They wouldn't even think that was something that would happen. But he knows far too much for anyone to claim that he wasn't competent enough to stand trial. And when he decided to go pro se, when he decided to defend himself, there's a video I'll show you of that as well, when he argued with the judge and was saying how we wanted to be, and they fought it. They were like, no, we really don't want that. We don't think it's the best thing for you. We don't want, all these things. They finally let it happen. They had him evaluated, and they found him competent to stand trial, that he's not, insane. So the insanity plea is not going to ride. And apparently he does have a First Amendment, standby First Amendment, I don't want to say coach, but somebody who is basically keeping tabs and helping him understand better his First Amendment rights. So just want to let you guys know.
Asking every witness up here that they seem just to mysteriously now not have any cross for, have they been coached to answer the way they answer? Because
well, you can't ask that, but you can ask them if they've met with anyone ahead of their testimony here today, which you've done with other witnesses.
I find it very funny that these are their reports, and now all of a sudden you can, I saw the person in the car. Oh, but
Mr. Brooks,
I
this
saw
is
them
an
reach
attempt
for
by
something.
you
Oh,
to
I don't,
delay these
I don't recall what they had on.
Mr. Brooks,
You can
there's
recall
no
seeing
purpose
somebody
for you
reach for
saying this
something
right
and
now.
don't know what they had on. I find that
All right,
very.
I'm having the jury
Come on,
brought
man.
out. I'm instructing you to
Come on,
avoid
man.
the commentary when the jury comes out, or you will
I didn't
forfeit
say-
your right to be
I didn't say
present.
nothing.
There's an issue that we do need to take up potential as to a witness by the name of Abel Lescano. He has prior criminal history.
Thank you.
So as long as the jury's out, we should probably discuss that. I would like to provide the defendant and the court with a copy.
So that had to
of
be
the-
said. So it's the defendant.
That's not how it was said.
That was how I
completely
said. You want to run the
disagree.
record back?
Mr. Brooks,
So I'm the only one. I got one. I
Mr.
got one
Brooks.
ear that work, and I heard that.
this
Come on,
is
man.
to benefit
Come on, man.
you so
No,
that
it's
you
not.
understand
Ain't none of
your
this to benefit me.
witness
So let's
has
be
a
clear about
prior
that.
record.
Your Honor, when I leave the table, I'm away from the courtroom and I have to elevate my voice. This is the
So she had to
alleged
elevate her
record of
voice
Abel
just for
Lescano.
that.
Stop talking.
Come on, man. Like, I don't know who y'all be thinking y'all fooling. I accept the value in return for value this document.
One more interruption and you're going to be removed to the next courtroom.
That's what you want to do anyway.
It's not what I want to do. Do not interrupt Attorney Opper.
So can
Your
you
Honor,
tell?
I
can you
believe he
explain-
has 7 prior criminal convictions via OWI 2nd from 1997, and OWI 3rd from 1997, and OWI 4th from 2003, criminal trespass to dwelling from 2006.
All right, I need to take a break. This man right now is having a stare down with me. It's very disrespectful. He pounded his fist. Frankly, it makes me scared. And we're taking a break.
Another fine example of Darrell Brooks. He shot Judge the snake eyes, the nastiness of it all. Here's another one right here. At one point, he asked. Well, here I'll let you watch this one, but then I'll pull that one up in a second. But it was. This is the detective on the 10th that apparently gave Rittenhouse, or not Rittenhouse, sorry, something just popped on the side I read. Gives him a little bit of a burn, which we all love to see.
Which you can recall?
Do I remember if I can recall?
Do you remember the disturbance you recall?
Yes, I do.
He's like the
Would you
kind of
state what
questions
that
that?
is? What that was, rather?
I heard a horn beeping, and then a Ford Escape came through the parade route, and you drove past me and wouldn't stop, and you continued driving into the parade route.
Who is you?
Darrell Brooks, the defendant, seated at the table.
Let the record reflect that I do not identify by that name,
You're
nor
welcome,
do I know
Kathy.
anybody by that name.
Funny, because we all know you by that name.
Your objection is noted.
So you heard a horn beeping.
Yes.
Was it coming from the vehicle that you tried to stop?
I believe that it was.
You stated that you've been in law enforcement for 25 years. That's a long time. So it would be fair to say that you operate a motor vehicle pretty much every day. Would that be fair to say?
Yes, I operate a motor vehicle almost every day.
And would it be also fair to say that you would only beep your horn in a motor vehicle if you were trying to alert someone to your presence?
I think that could be a fair statement.
Would it be also fair that you would beep your horn to avoid any danger?
There could be many reasons why a person is beeping their horn.
Would one of those reasons be to avoid danger?
It could be, yes.
Do you recall if you were able to see who was operating the vehicle you attempted to stop?
Yes, I was.
And can you recall a description of the operator of the vehicle you attempted to stop?
He was light skinned, black male, got some light facial hair.
Is that all you recall?
That is what I recall.
Do you recall what they were wearing?
No, I do not.
So you were able to get a description of how the operator of the vehicle looked, but not what they were wearing?
That is correct.
Do you recall how fast the vehicle was going at the time you attempted to stop it?
I believe the vehicle was going about 3 to 5 miles an hour when I tried to stop the vehicle, and it continued on past me.
Would it be fair to say that 3 to 5 miles an hour is not very fast?
I think it's very fast when you're in a parade route, when there's hundreds of people marching in the road and a police officer is standing in front of your car, pounding on the hood, trying to get the vehicle to stop. I'd say that that's too fast. Any speed is too fast on a parade route when you have all those people in the roadway. A car should not have been there.
That wasn't the question, but thanks for the commentary.
Detective Casey, please just answer his questions. Attorney Opera will have an opportunity to redirect if necessary.
Would it be fair to say that that's not a very fast speed?
Objection, asked and answered.
Sustained.
Again, my mic's muted. I feel like I'm pulling the judge card, but I'm muting my own mic. Yeah, so I really was going to play, I might still play, but some of the witnesses' testimonies that the one that pulled up was the mother that he called towards the end of the day yesterday. And man, it was just heartbreaking. Listen to her talk about how 4 of her children were struck. And like I said before, there was near fatal injuries, compound exposed fractures to the femur, broken tibia, fibia, facial scarring, broken teeth, broken arm, just cracked, broken tailbones. It's just terrible, man. The things that, and then when she was being cross-examined by the prosecution, the fact that he was objecting to her statements and was calling hearsay and argumentative and leading, and he was over talking her answers about her children, and she's crying on stand about how she didn't even get to see a couple of her children, 2 of her children, for a couple of days because they were in the ICU, and there was a touch and go situation. So, I mean, man, they'll be back at 1 p.m. Central Standard Time, so about 27 minutes they'll be back. So I'm going to play this one for you. These are some of the numerous objections, and I hope that this one comes in, but there's a couple quick clips that I'm going to show you guys. So this is one of them. And we're just going to keep doing video clips here to keep you guys an idea of moving forward of things, that have happened leading up to where we're at. So and there we go.
When did your part of the investigation start?
After he drove the SUV through the parade, I was called at home to come in and help the departments with the investigation.
You're welcome, Mo.
And just so we clear for the record, is the jury asking you questions or me?
I'm sorry, I did not hear the question. Repeat your question.
Yeah, Destiny. I don't know what the hope was in
referring
him
to
calling
when I asked a question,
the victims.
he turns towards the jury as if they're the ones asking the question.
He doesn't like who he looks at when he answers the questions.
It is a question.
You did ask a question about.
Excuse me.
Yes.
Sorry, guys.
I think you're asking why does he do that? To that extent, the witness may answer.
I'm here to present the case to the jury.
So I follow that fundamentally. But for the sake of making sure you hear the questions right, wouldn't it be fair to say that you should pay attention to the questions being answered, or being asked, rather?
Assumes fact, not evidence.
Sustained as to the form of the question. Please rephrase.
Wouldn't it make sense to focus on the questions so you can hear them clearly?
Objection argumentative still assumes fact, not evidence.
Sustained.
You made reference to you being here to present the case to the jury. So is that the reason why you decided to testify?
Objection to the relevance.
Grounds?
Overruled. The witness may answer.
I don't understand your question.
Were you able to hear my question clearly?
I don't understand your question.
Were you able to hear my question clearly?
Objection argumentative, Your Honor.
Sustained. Next question, please. Or rephrase the previous question to the one that was asked just now.
What was not understood about the question that you were asked?
Objection argumentative.
Grounds?
Sustained as to the form of the question. Please rephrase.
What wasn't clear about what I was asking?
Same objection, Your Honor.
Grounds?
It's the objection is sustained. Let's go back and ask the question that he says he didn't understand and rephrase it, please, or move on. Your choice.
Was your sole reason for testifying here today?
Objection relevance.
Okay, let's let Mr. Brooks get the question out. Go ahead.
Apologize, I thought that was it.
Are you testifying today strictly to prove your case to the jury?
Objection misstatement of his testimony.
Grounds that that's what he said.
Sustained as to the form of the question misstates the prior testimony.
That's what he said. So why did you decide to testify here today?
Objection, that's a legally inaccurate question, Your Honor.
Please rephrase the question. I'm sustaining the question asked as to the form of the question.
I don't know how I'm supposed to rephrase that.
Yeah, this is a
Without
witness from the other day.
having the same form of the question.
Yeah,
That helps.
It doesn't help because it's
I'll rule if there's an objection, but ask a question, please.
yeah. This video is from Friday. Sorry.
Did you seek to testify here today in this matter?
No.
So how did you ultimately come to that decision?
No, his mother was
Objection, that's a
never.
misstatement, Your Honor. It was not his decision.
Sustained as to the form of the question assumes a fact, not an evidence.
Were you subpoenaed?
No,
Yes.
this was
Do you recall by whom you were subpoenaed to testify?
this was one of this. So this wasn't Friday. This was
District Attorney Sue Opper from the Waukesha County District Attorney's Office.
it's from last week. In the
And
middle
at
of
that time you were subpoenaed, you decided to testify.
This was a state called prosecution's called witness.
I don't believe it's my decision.
Overruled. The witness may answer.
Okay, so we've got. Let me do this for you guys.
So is that standard procedure to not tell a person why they're being detained?
Well, we did not tell you. That's incorrect, and it's misleading to the court. You were informed you were being detained for prowling, loitering, disorderly conduct of that nature.
Is that the same as?
Can I finish, please? I just didn't bring up the parade part of it.
Why not?
That was money.
As I stated in earlier testimony, it was very fluid and chaotic, and a lot of information wasn't yet known. So I was waiting to receive more information.
Did you state in your early testimony if that was standard procedure or not?
It's standard.
So with every detainee that you've ever detained during your career, 18 years, right?
Yes.
It's standard procedure to not tell someone being detained what they're detained for.
As I had stated in my earlier testimony, Mr. Brooks, I explained to you were detained for prowling and loitering and disorderly conduct. Based on the lack of information on the parade, that was not brought up. So what I can clarify for the court at this point is that in situations where so limited information exists early on, it is standard not to convey that information to suspects.
And what do you mean by it's standard?
It's normal.
I mean that I don't tell them because I don't have all the facts yet, and I'm not looking to necessarily accuse them before I know the nature of what they did or didn't do exactly pertaining to that incident.
So this one we saw, this is when the judge says that she felt scared.
Thing worth noting is the testimony.
So this was the DA finally snaps. She said, I'm tired with it. I've put up with enough of your nonsense. And Opera finally, like, she hops off, which is great.
Of Detective Casey that this video was obtained from the defendant's own Facebook account as well. The court is well aware.
He said social media.
Nothing that.
He didn't say what it was.
Sir, stop interrupting. We have to make a record of it. You've interrupted multiple times. I've been abundantly patient with you. Again, another interruption. So you need to be quiet and let the state make a record. Stop gesturing at me. Stop rolling your eyes at me. Stop mumbling.
I'm looking right at you. I'm not rolling my eyes.
No, you have throughout. I've seen it and I've made note of it.
I'm looking at you. Okay, so are you asking me to be quiet or are you telling me to be quiet?
Go ahead, Attorney Opper.
Thank you, Your Honor.
Take that
and
as
just
asking.
to indicate, Your Honor, this court has been abundantly patient with Mr. Brooks. He challenges the court's authority repeatedly. This court absolutely has the ability to tell him to sit down and be quiet. And you haven't done that. And I know why you haven't done that, Your
See,
Honor.
there you go.
And we appreciate
that. And that's an important point to keep in mind. In that moment, Opera is saying, we know why you haven't. It's because he's going to go for mistreatment. He's going to go for you guys, I'm sure this is what he did. Had somebody Google, how can I get a mistrial? And if I'm representing myself, in every single thing they said, I guarantee that's all he studied was that. He hasn't been paying any attention to try to find any outs for any of this when it comes to his defense. He's not looking to pull angles with the witnesses. He's not trying to, go for a defense that's going to get him the possibility of a jury seeing it his way. That's not it. The only thing he's been studying is how to get a mistrial, how he can best set himself up for an appeal. That's it. And so all of you guys, and it's funny because we know now, and any of you guys have been watching with us, on show for the last, 2 weeks, we know what he's doing. But if you just jumped in, what he's been trying to accomplish is to get a mistrial, which isn't going to happen, or get himself set up for an appeal. So he's pushing for things like being held in contempt, which he hasn't done. And he keeps saying, why do you keep holding me in contempt? And she's had to remind him, I haven't held you in contempt. I'm just putting you in timeout because you're a raging asshat. So everything he's doing is geared towards that, which is why whenever he questions the witnesses, all he does is read from the report and ask them questions about the report. It's not about how that pivots into the next witness and then the next witness and how that, they call it building a case, right? Well, he's supposed to have been building a defense, which he hasn't done. He's absolutely done nothing to build his defense. And if there was all the time in the day, I would show you guys every witness that he's called, of which I believe on stand, if I'm not mistaken, we got down to, I think Catrice Babiaz was the last witness he called, and that was his 12th witness. And mind you, one of his witnesses that he called was the state of Wisconsin, and the judge denied that, obviously. She said, yeah, we're not doing that. But so there's no defense. It's just a matter of propping himself up for the best round two. You know what I mean? Like, you're throwing a bouncing ball, like one of the little rubber balls. You throw it, and it bounces, and then, you know, it goes. What you want to do is make sure you catch it before it hits the ground, because if you don't, once it hits the ground, it's picking up all that force, all that momentum, all of that, you know, all that extra speed. I was making a reference to when Darrell Brooks earlier had to have Newton's laws explained to him. And so once it hits that second bounce, it takes off. You know, it's a skyrocket. And I remember so many times as a kid playing with those and just never thinking about it. And you take that second shot and turbocharge square into the face. Pow, you know. Thank you for the stars, Leah. So that's where we're at right now. The first bounce is this trial. They're trying to do everything they can to catch it before it hits the ground, so they don't have to deal with a supercharged version of Darrell Brooks. Like, if you can imagine, like a Hulk version of Darrell Brooks, when he has a chance now to, like, all right, now I'm in my groove, I'm in my appealant process. I mean, it's slim to none the possibility of that going through. The mistrial, whatever. Brianna, you're welcome. Thanks for being here and joining us. Thank you, everybody, for being in here. I know we still have a couple hundred folks in here that are watching across the channels while they're on lunch. They got about 25 minutes left. But this is the DA finally, like, cracking off and saying, listen, man, we've had enough. But she commends the judge, but also kind of reprimands the judge. You know, she says, hey, you know, like.
And you haven't done that. This court absolutely has the ability to tell him, sit down and be quiet. And you haven't done that. And I know why you haven't done that, Your Honor. And we appreciate that. He is not in control of this courtroom. You are. And he needs to respect that. This video was relevant based on his questioning of Detective Casey, as you just indicated, challenging his ability to identify the person who had their back turned to the camera in the still shot of State's Exhibit 175. Trials are fluid. When he opened the door to that, we came up with the video, which Detective.
Sorry, guys. Just had a little bit of a hiccup on the. We'll get it sorted out. Yeah, let's. All right. Anytime now. Buffering, am I right? Sheesh. Well, while that's trying to figure out how to work. No, Brianna, the jury has been, anytime these back and forths go on with Darrell Brooks, the jury's always been removed from the courtroom. So, which is good because, you know, it's honestly, it's for his own protection.
Thing worth noting is the testimony of Detective Casey that this video was obtained from the defendant's own Facebook account as well. The court is well aware. There's nothing that.
Hold on, sir. Stop interrupting. We have to make a record of it. You've interrupted multiple times. I've been abundantly patient with you. Again, another interruption. So you need to be quiet and let the state make a record. Stop gesturing at me. Stop rolling your eyes at me. Stop mumbling.
I'm looking right at you. I'm not rolling my eyes.
No, you have throughout. I've seen it and I've made note of it.
I'm looking at you. Okay, so are you asking me to be quiet or are you telling me to be quiet?
Because nobody tells me what to do.
Thank you, Your Honor. And just to indicate, Your Honor, this court has been abundantly patient with Mr. Brooks. He challenges the court's authority repeatedly. This court absolutely has the ability to tell him, sit down and be quiet. And you haven't done that. And I know why you haven't done that, Your Honor. And we appreciate that. He is not in control of this courtroom. You are. And he needs to respect that. This video was relevant based on his questioning of Detective Casey, as you just indicated, challenging his ability to identify the person who had their back turned to the camera in the still shot of State's Exhibit 175. Trials are fluid. When he opened the door to that, we came up with the video, which Detective Casey testified repeatedly on direct examination and cross-examination as to how he knew that was Mr. Brooks, because he had seen the rest of the video. He would not accept that. He pushed it and pushed it and pushed it until we played the video.
I got a little.
The lyrics of that video probably would have been prejudicial. Originally, I wasn't going to ask for volume. Then I did, because he pushed it again, and his voice and his mannerism of speech, I thought, would have assisted the jury in identifying Mr. Brooks as the person in the video with the red SUV. However, you smartly asked me to play it without the audio, and I did that, and then I never went back to that.
Nobody needs
This
to go
is
back to that.
all to the benefit of this defendant, who continues to suggest and impugn the integrity of this court and this prosecution without basis. He doesn't like it because the evidence is stacking up and stacking up.
Right.
And whenever it does, his
You hear
response
him laughing?
is to accuse you, the court, or the prosecutors of being unethical and hiding things. There is nothing in law that prevents me from pulling something out of my briefcase right now and making it an exhibit if it's relevant. You decide what's relevant, what's admissible, not Mr. Brooks. There is no law, he can cite to no law, no authority whatsoever that says I can't make an exhibit essentially on the fly if it's called for, and that's exactly what just happened here. So I apologize for my tone with the court. I don't mean to direct this at the
I'm
court.
sorry that I'm yelling.
It's very
I'm very
frustrating.
upset.
The court has demonstrated much more patience than I have with Mr. Brooks, because again, I do not appreciate his impugning the integrity of these proceedings, of Your Honor's efforts to run a fair trial, and of our efforts to run a fair trial. We have ethical obligations as well to be fair in this courtroom. We have respected that entirely. The reason I was laughing 30 seconds ago was because the exhibit was mislabeled. There was an extra Y and it said Exhibity, EXHIBITY. And I turned around to the paralegal and pointed that out, and we laughed over it, the word exhibity. That was it. There has been no disrespect directed at Mr. Brooks directly in any fashion. So
Not that you'd be
he can
faulted for
object all he wants, and he has made that clear. He will continue to object and obstruct the court and obstruct these proceedings every last chance he gets. But legally, everything has been above board and proper, and this exhibit is no exception. I apologize for my tone, Judge.
Thank you. I appreciate
I'm
that.
sorry I'm
additional,
yelling. I'm very upset. If I
record
stop yelling, I mean, I
being
lost the argument.
I object
So I'm
to
going to
that.
go away.
My
I love you all.
previous ruling doesn't
Sorry
change
that I'm
in
yelling.
any way that the exhibit is relevant. I indicated I would take it up because, and I'm taking what the state's saying as withdrawing the request to play the lyrics.
That is correct.
All right.
So they're talking about his
I have not
horrible
heard them, but I'll
rap
certainly
song
take the state
that he
at its word as an officer of the court
that they brought in as a
it would be prejudicial based upon the lyrics that are in that video, but my decision to admit the video without audio stands.
Aside from his, with all due respect, wait for him to say it. So keep in mind now, we've seen the outburst. Now, this is more outburst. We watched a little bit of this one earlier, but we didn't get a chance to finish it. So, but it's just funny the getting a chance. It didn't turn out high though. But every once in a while, I get a chance. I've been able to drop some little video clips on you guys.
For truthfulness or untruthfulness. It's not specific instances of conduct. It's character evidence, which frankly wouldn't even come from the witness.
He says, with all due respect, Your Honor, it doesn't give you carte blanche to say whatever the hell you want.
With all due respect, did the state have to put their witnesses in order and tell me?
It's irrelevant what the state did.
Did they have to do that?
They didn't need your assistance to do that.
Did they have to do it?
No, they did
I
not
didn't have to be
do it.
provided with, we're gonna call this witness at this time,
But they're
and this witness
able
at this
to
time.
contact
They
their
didn't have to do that, so
witnesses
why should I have
and
to do that?
accommodate their schedules. This is not about you. It's not about the state. It's about the witnesses'
It's about what's fair.
availability.
It's about what's fair.
No, frankly, sir, it's about you trying to control what's happening in this court.
How am I controlling what's happening? I'm the one shackled to the table with
So here's the
with a shock
situation.
device
It is
on my ankles.
9:52.
So how's I'm trying to control anything?
I'm
I
having
just
to-
want this
I'm
to be
going
fair,
to-
and it hasn't been fair.
Mr. Brooks, it's fair.
No, it's not. If I have to do something that they don't have to do, how's that fair?
It's fair.
Explain to
because
me how
of
that's
the
fair.
process that it has been set up to frankly help you. get
No,
the
it's not
witnesses
helping me by
to
it's helping
court.
the state
And no,
by being able to say, if we know the time and we know
You
the
did
person
not-
and
I
we know
asked
this,
you-
then we can be prepared. So we'll already be ready.
Mr. Brooks,
That was
I
the
asked
whole
you
aim of that.
yesterday, and I would have had her come in later. You didn't want to answer that question.
There was no
And
question. There was no question to answer.
That's not
I
true.
did what you asked me to do, Your Honor. You
No, you
said
didn't.
yes, you did. You did. You asked me to give them my witness
Mr.
list.
Brooks,
I gave them my witness list. It's not my fault. It's not my fault they weren't gonna be prepared to
Mr.
do
Brooks,
their
here's the
to
deal.
do
The
their
jury's
cross.
coming out, and I'm gonna stand my ground on this.
I'm gonna
Okay,
stand my
it
ground
is-
too, but I'm
if
not
you
gonna
don't call
be
her-
disrespectful or disruptive.
If you
I'm just
don't
stating I
call
want it to be
her
fair.
When the jury comes back out, I'm releasing her from the subpoena.
You can't do that.
For your
Where's
lack
the
of
lawful law?
cooperation.
Where's the lawful law? I have
Where's
the
the
right
lawful
to
law,
witness
he
it,
says.
Cooperate with this process.
but I
sir.
also have the Sixth Amendment
Well,
right.
We have a witness available for you to call. I can require
It's
you
not
to
the
call
witness
her
that
right
should have
now.
been called at this time, Your Honor.
It is based on the list that you provided and
That
in
didn't
the
have a
order.
time. That didn't have a time or of
I'm not going to
or an
play
order.
this game with you,
It's
sir.
not no game.
It
That's what
was-
you don't
it
seem
is
to
a game
understand.
you. I believe that fully.
I don't care what you believe fully.
All right.
It's not a game.
We.
I don't take
I
this as a
asked-
game. That's what
Let me explain
nobody.
this to you
That's what
once
nobody. You
again.
don't got to explain nothing to me.
Do you want?
That's what you don't understand. You think
you
that
want
this
the
is a whole
opportunity
game
to
to me.
question?
This is not a game to me, Your Honor. Nothing about this is a joke.
I never
That's
said
what
it
y'all
was a
don't
joke.
understand.
But there's
And it's
some things in the
unfair.
ship
It's
that's going on.
unfair and it's disrespectful to me that you think I would come in here purposely and treat this like a joke or a game.
I never said it was a
What
joke.
type of statement is that? Your life is not on the line. Mine is. And you think that I think this is funny?
I don't think it's funny whatsoever.
We all think
So,
it's
so I think, Your Honor, with all due respect, I think you should show
we're
some
gonna take
respect.
a 5-minute break, and when we come
So
back,
with all
the
due
jury's
respect,
coming out,
you need to show respect.
and you need to call your next witness. Thank you. We are in
No,
recess.
you're not rushing me to judgment. I don't care which.
Now we're at the end of the 3rd week of trial.
So-
These are your witnesses. I presume that you are prepared in whatever way that is.
How
We're not
can I
gonna
be
hold it
prepared
up.
for? I'm not. So the witness is just supposed to get up
So
there.
we
and just-
see we watched this one earlier. But we tried getting through it. Let's we'll skip through it a little bit. But yeah, so many of these. They just don't stop, you guys. Thank you for the stars on Facebook and for the super chats over on YouTube, you guys. Thanks so much. Helping keep this running and keep things functional. Keep the like I said, keep the lights on. Yeah, let's we'll keep pulling them up. It's funny because I could pull these clips like all day, it feels like. Let me see here. What's next on the list? There was a couple here that where Darrell Brooks gets emotional, but this is I'm gonna show you a little clip of his business video. This is Darrell Brooks Jr. times BLAS business. And we're not going to give any more time than we need to, but this is the video that they were watching, I believe, or one of them at least. And we're going to skip through it, just so you know. We're going to sit here and watch his whole music video because I don't feel like giving it plays. But this is the one that they were talking about here.
what's the business? What's the business? Phone jumping off the chain like what's the business? I'ma pull up with the yay like what's the business? Eating lunch with the blood like what's the business? AR double drum like what's the business? 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 Catch me sliding to the trap. What's the business? All my niggas on the chase. You a walking stain. What's the business? We be running through a block like what's the business? Phone jumping.
We're just gonna keep skipping. It says what's the business a lot.
What's the business? What's the business? Need them pounds. What's the business?
I think Jason Mraz is pissed right now of his misuse of a fedora. Just really running to look into the ground. Poor Jason Mraz.
Hit my line when I'm in town like what's.
But I have heard it said that Darrell Brooks is basically the rap version of Jason Mraz. Really heartfelt singer-songwriter. Sorry, I can't.
I'm bring them round the mouth like what's the business?
This is while he was in Vegas. I'm guessing back in 2006 when he was arrested and charged with statutory rape of a minor. And that minor happens to be Erica Patterson, whom he impregnated. And fast forward to current day where he ran her over, beat her up a few times, and then called her to testify as if that was going to help. And then the judge released her. Oh, we're not done yet. No, Sarah. We're gonna run this one through. We've committed.
Killing the business. Galley out the door was the business. Stupid link on the cane was the bit. Pouring money, that's my lane. Was the phone jumping off the chain like was eating lunch with the blood like what's the business? What's the business? The business.
What is the business? I really am curious what the business is. Darrell Brooks Jr., the business. Well, I feel like we're all stupider for that, and you're welcome. I did that to you. Boys in prison gonna give him the business. Yeah. So, Darrell Brooks, man. Just the best of the worst, man, or the worst of the best. No, definitely the best of the worst. We got to say that. It's amazing to me that he is so confident in the swag that he puts out in court, as if to think that, making a garbage rap video and then jumping through the courts for 17 years makes you someone of substance, you know what I mean? Or makes you an entity that needs to be respected. You know what I mean? Like they say all the time, respect's earned, not given. So I don't think he has ever done anything that I've seen at all to earn anyone's respect. Definitely not the people of Waukesha, the community in which he, devastated with his acts and his, he's a professional criminal. Lindsay, you got it right. Yeah, he's been amazing at being a criminal. He's really good at breaking the law and sliding away without much conviction. So in some way, shape, or form, good job. But, but in the grand scheme of it all, he's hit the limit. We're at that point where he doesn't have any more runway, and he's cooked. He's cooked, and he knows it. So he's trying to basically drag this out as long as possible. But this is, and as Marie mentioned, this is a quick recap they did, back in last year of Darrell Brooks. So let's take a look at that real quick.
The suspect, Darrell Brooks, is no stranger to police, a man with a violent history.
CBS 2 investigator Dave Savini is live in the newsroom. Dave, it appears Brooks slipped through the system not once, but twice.
Yeah, Erica, we are learning at this hour police may have received a complaint about Darrell Brooks involving some other kind of domestic dispute shortly before that vehicle plowed into all those people. And while we're still trying to hammer out those details, one thing is clear. Our CBS 2 investigators found Brooks has been in and out of a criminal court system for more than half of his life. We've also uncovered new information that he's been wanted by police in Nevada for years for a child sex offender registry violation.
Darrell Brooks has a criminal history that spans more than 2 decades, with arrests and convictions often for violent crimes. We've now uncovered he is also a child sex offender who has been wanted for years for failing to register, but has managed to elude police for 15 years. We obtained his mugshot from 2006, where a much younger Brooks can be seen with the same tattoo on his neck compared to his recent police photos. Police in Nevada now confirmed to CBS he is the same man accused of plowing into all those innocent people during the Wisconsin parade. According to law enforcement sources, Nevada authorities investigating his sex offender registry failure never could track him down, and no one is quite sure who dropped the ball.
Let's yeah.
Because his arrest record since shows he's been in and out of police custody in Wisconsin.
Let's I'm going to read this to you actually, guys. I feel like you get a bit more excuse me, understanding of what is going on with him if you're able to actually hear it, as it's, the charges as they've been, set. So where are we at here? Okay. In 1999, when Brooks was 17, he got charged with substantial battery with intent to inflict substantial bodily harm. Class E felony, punishable by 15 years in prison. He pled guilty, though. The judge at the time sentenced Brooks to 3 years of probation and just 6 months in the House of Correction because he was 17. Of course, they're going to give some leniency because he's not quite an adult yet. They don't know what they're doing. While still on probation, he was convicted with his second offense of possession of drugs, and he got another 50 days in the House of Corrections. Almost as soon as he was released, he was convicted of resisting arrest, which is a Class A misdemeanor, punishable by up to 9 months in jail. Despite the drug conviction just months earlier and the fact that he was still on probation, keep in mind as I'm reading these this rap sheet, these are all things that are still compounded and looming. None of these have gone away. He hasn't finished his sentencing. By that I mean probation. Sorry, I got a tickle there. So they should be compounding, right? These are things that the judge at any other court should be taken into consideration. I'll fire through this so we can get back to court when it comes back up. So almost as soon as he was released, yada, 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 he, a Class A misdemeanor for resisting arrest, convictions from months earlier, and the fact that he was still on probation for substantial battery. The judge sentenced him to just 20 days in jail. Apparently he was emboldened by his repeated lack of consequences for his life of crime. But when he was still in a young age, apparently he was charged with resisting or obstructing an officer, resisting arrest in 2005, this time in Manitowoc County. After his arrest, there was a commissioner who freed him on a $300 signature bond. And of course he failed to show up for the hearing. There was a bench warrant issued, but he'd already took off. He went to Nevada, where we saw him in this video. This terrible business video in which he just makes a mockery of Jason Mraz's style. And this is where he was convicted of statutory sexual seduction, basically statutory rape of a minor, in 2016. He not only raped Erica Patterson, but got her pregnant. And then you saw what he did in court when they brought that up. He flipped out and said, I didn't know how old she was. Get all the facts, whatever you want to say. He was sentenced to just 3 years probation. Oh, wait, sorry. I skipped down. My bad. Remarkably, he only served 14 months in prison and was released in 2008. Apparently, he pled guilty to that. Now, had she been 14, it was a 30-year sentence. So he skipped from, 14 months, which could have been 30 plus years or 25 plus years. So the following year, he returned to Wisconsin and was back in Manitowoc County Court in 2005 on that resisting charge, even though Brooks had fled the state and gotten himself convicted of a serious child sex crime The commissioner at the time inexplicably set bail at just $100. He predictably posted and then failed to show up for another hearing. So another bench warrant was issued. And after Brooks was convicted, Judge Patrick Willis sentenced Brooks to just 2 days in jail and ordered him to pay a fine, of which, of course, he never did. In 2010, he was charged in Wood County with felony, strangulation, and suffocation. Now, mind you, he had a previous conviction and a misdemeanor counts of battery and criminal damage to property. After a no contest plea, the judge sentenced Brooks, who was facing at the time more than a decade in prison, to just 3 years probation and 3 months in jail. The following year, Brooks was for the third time charged with resisting arrest in Milwaukee County, and in a terrifying bit of foreshadowing, guess what he did? Turned his car on the officer, shifted it in drive, and tried to run him over. Prompted that officer to believe Brooks would try to run him over. Now, mind you, when this goes to court, I gotta give you guys, this guy some juice here. Now, this is crazy. Although he was still on probation in Wood County case and had several prior convictions for resisting arrest, he also had several times failed to appear for prior criminal charges. The court commissioner freed Brooks for just $1,000 signature bond, which he was eventually convicted after a plea deal. When he was eventually convicted after a plea deal, the judge sentenced Brooks to just 37 days in jail. Mind you, he skipped out of 10 years already on this, and only then 14 months on statutory rape of a minor. The conviction did prompt the authorities in Wood County. They did revoke his probation, but Brooks was sentenced to just 11 months in jail for the strangulation with prior convictions. In 2016, Brooks was charged with failing to comply with Nevada sex offender registry for 8 years. He initially posted bail, but then failed to appear to court, and at some point skipped town and moved back to Wisconsin. And though the state law there also requires him to register as a sex offender, he never did. So, and he had to do that within 10 days, is what the state law says in Wisconsin. Never happened. So, all told, between the ages of 17 and 34, he was convicted of more than a dozen crimes, including several serious felonies such as child sexual assault, but served less than 3 years behind bars, including his time in county, in jail, not prison. In July 2020, Brooks was charged with 2 felony counts of second-degree recklessly endangering safety through the use of a firearm, and 1 count of felony possession of a firearm by a felon after he allegedly fired a gun at his nephew and some friends at a party they were at. The bail was set at $10,000, but 2 weeks later, Brooks filed for a speedy trial. Now, this is during COVID, mind you. So the trial's back on. So the Milwaukee County Circuit Court, anyway, went from $10,000, $7,500 to $500, posted bail at $500, and then he was back in court for a child support case in 2000. That dated back to 2004. He refused to pay child support. He did, and then the judge stayed the 120-day jail sentence and just told him to pay your fine, man. Just pay it. We'll be all good. We'll just pay your fine. 2 months later, on the 27th of 2021, he was arrested in Georgia on another domestic violence charge after a man heard him beating a woman in a hotel room. He was released on a signature bond, fled the state, came back to Wisconsin. And then that November, just 16 days before the massacre, Brooks was charged with running over his girlfriend in the car, got out on $1,000 cash bail, which his mom set. And then, of course, we go to just 5 days before the killing spree. He got out, and on the 16th, and the same day he appeared with Waukesha County Court Commissioner for child support payment. Prosecutor demands that Brooks he immediately be jailed, but Herring issued a stay of release at Brooks on his own recognizance, meaning he didn't have to pay anything. Let him out of jail, didn't have to pay a dime. Fast forward, and now we're sitting here with what he did. So we're gonna go back to court. Let's jump back in, shall we? And I think we'll go live over here on
this courtroom prior to the, I understand your objections noted. If you would like to go back to the other courtroom, sir, You may, but that is a choice that you would be making. I am not requiring you. I'm not forcing you at this time.
So you're not holding me in contempt.
Sir, I am not requiring you or forcing you to go into the other courtroom. It is a new part of the day. I thought it appropriate to have you brought here.
Why?
And only if you forfeit your right by conduct will I put you back in the other room.
So you going to address subject matter jurisdiction for the record, or are you going to state it on the record?
I'm declining to address that on the record for the reasons I've previously provided to you, not the least of which is I have addressed that by way of a written decision.
And it hasn't been proven for the record. You
Your
have to state
objection
it
is
on the
noted.
record. Can I go back in the other courtroom? Because I'm not going to do this with you. I'm not.
Mr. Brooks, I do want to go over
We don't
the
have.
jury instructions.
I don't understand the
verdict.
jury
Boot him.
instructions.
Kick him
I
out.
don't understand
He wants to leave. Let him go.
in these proceedings, and I'm not going to participate in something that I don't understand.
That's
See ya.
your choice, sir.
May I please go back into the other
Nope.
courtroom?
Don't let him go.
You can, based upon your choice.
Don't let him
your
leave, man.
request,
Make him stay there.
I'll make a finding that he's forfeiting his right to be present in this
I didn't forfeit
courtroom.
anything. I asked.
I understand you've
So I
asked,
didn't-
but
I
I
didn't
feel it's
forfeit
important to
anything.
also make a finding based upon your conduct.
You don't need to correct your vernacular
Based
to
upon
better
what
appease
kind of
him.
Me asking.
Oh, jeez.
Are you willing to expressly waive that right on the record right now?
I'm not gonna expressively waive anything.
Are you willing to
I'm making it.
engage in
Make
a
him stay.
colloquy regarding your right to be present
I
and
do
a
not.
knowing and intelligent and voluntary waiver of that right?
I am not going to consent to anything that I don't understand, and I will not answer any questions that I don't understand. I'm merely making a
I would
request
assume you don't
to
understand a
not
lot.
be present in these proceedings.
You
And to
can't
be in the
not be
other
present
courtroom.
in the proceedings.
Again, as I've stated numerous times now for the record, I will not answer or comply with anything I do not understand.
He doesn't understand a lot.
I'm not making a voluntary waivery of anything.
Are you willing to be, let me rephrase that. If I have you stay in this courtroom, are you willing to follow the rules of
He doesn't.
decorum
He
and
won't.
courtesy?
No, he wants to leave. He's
I
not
do
going to
not
stay.
understand the question you are asking.
Are you willing to not interrupt the proceedings with disruptive behavior?
No,
I do not
He can't agree to
understand the questions that you are asking.
Well, given that he won't answer the questions directly, for now, he is to remain in this courtroom.
I'm requesting to not be. in
Too
this
bad,
courtroom.
buddy. You're in
But
court
you
on
won't go
trial.
through, you won't answer my questions regarding that,
I
sir.
did.
It's
I-
a murder
I told you I
trial.
don't
You should have to
understand.
stay in court.
That's
You
not
go through the
answering
whole
the
process. You don't get to
questions.
go to
Ask me a question.
your own
I
little
answered it. I don't
fort building
understand.
timeout.
How can I answer something that I do not understand, Your Honor?
All right, let me start with the jury
You
instruction.
gonna
There
start
is
with,
one I
you gonna
would
start
like
with subject
to.
matter jurisdiction?
No, I've declined that already, sir. I'm not gonna address
Under
that
what
further.
law, under what lawful law?
Sir, please do not interrupt me again with the topic of subject matter jurisdiction, or you run the risk of forfeiting your right to be present in this courtroom.
Then let me go in the other courtroom then.
Are you willing to engage in a discussion about that, sir? I need to make
I
an
just-
appropriate record.
I just told you that I don't understand the questions you're asking. What do you want me to do? I can't
Stop
answer
giving him
something I don't
options. Tell him
understand.
what he's going to do.
I believe you're choosing not to answer them,
You can
sir.
believe what you want to believe. I believe that you hiding stuff from the jury. I believe you haven't been impartial or fair. You haven't let me even enter anything into evidence, which is my right to do so.
Your
But it
rights
doesn't
are
matter
not
Somebody
what
else
you
not the
believe,
sheriff right
Your
behind
Honor.
him right now.
I'm merely stating a request to not be present for these proceedings. I cannot answer the
Sir,
questions you are asking me because I
seems to
don't
me
understand them.
You understand your right to be present in the courtroom. Are you telling me you
I don't understand
that right?
anything. Nope. I don't understand. Nope.
Then you're gonna stay here for now.
And under what lawful law? You can't
Laws you broke.
force me to stay somewhere that I'm making a request not to.
Yes, you can. Absolutely.
You can't make me understand You can't make me. You can't force me to understand what I don't
You
understand.
cannot agree to being in jail. They can force
Can't
you to
force
stay.
that.
I need to address one of the jury instructions, number 315.
So, Your Honor, I'm trying to make a request to not be present in these matters without disrupting the courtroom, as you say that I do, and over talking you, as you state that I do. I'm making a request merely to not be present for these proceedings. Obviously, I'm not needed because every decision that's been made here today has been made without my consent. That's clearly telling me that I'm not needed. I have never consented to anything that's going on here today. I haven't even been allowed to present any evidence, which is something that I stated weeks ago.
I don't think this is that part of the trial,
Weeks.
bud.
You already knew, Your Honor, that I wanted things to present into evidence. I've asked numerous times for that and have been denied. And I don't understand why I'm not being able to adequately defend myself.
Well, if you had a better understanding of the law, you would know that.
In your words, you're not being allowed to adequately defend yourself based upon your conduct in this courtroom and throughout these proceedings, and your unwillingness to follow the simple rules of decorum, courtesy, procedure, rules of evidence. You refused to answer a variety of questions this morning when this court went through the or attempted to go through the colloquy with you regarding your right to testify and your right not to testify. And because of that, and based on the case law that I cited this morning, I made a finding that you forfeited your right to present further testimony and evidence through other witnesses, and then you forfeited your right to testify in your behalf. I'm not going to revisit those, sir.
I'm not asking you to revisit them, but I'm just they weren't correct.
I understand you will
Because
disagree
I
with
never
that.
consented to it and I never answered something.
I understand
And
you
I
did
just
not
stated
consent
the
to
reason why I didn't answer, because I don't understand. You cannot force me to understand what you're asking me.
Sir, I could not even get through the advisement. You wouldn't even listen. You talked over me repeatedly.
Was that from the other courtroom or in here? Because I've been over there all morning.
Throwing a fit.
To the place that you are requesting to go back to, right?
You sent me into the other courtroom.
You're right.
She's asking if that's where you're requesting to go.
So I've been over there all morning.
With an adequate audio and visual system
I mean,
connecting the two courtrooms.
Your
A functional equivalent of
to
being
your
present in
equivalent
this
to
courtroom.
your equivalent is adequate, but to mine it's not. Seeing as how you always state Illinois versus Allen, you always state that, but it never refers to a fourth option that you refer to. It never
Mr. Brooks,
refers
I'm not
to
going
that.
to debate this with you. If you continue to bring up subject matter jurisdiction, Illinois
I didn't
versus
bring
Allen,
up subject
the
matter
decisions that I
jurisdiction.
made earlier,
I'm trying to figure out why I'm being
you
held in
are
contempt.
frustrating the purposes of this
I'm
hearing
trying to
right
figure out
now,
why I'm being held
which
in
is to
contempt.
finalize the
And
jury
then when
instruction and the verdict form.
Your Honor,
He's
I'm
hoping
merely
she's
trying to understand why when you hold me in contempt.
Never held me in contempt.
You've never attempted to hold me in contempt.
No, sir. I'm not going to revisit all of these issues.
When I asked you where you hold
Are
me in
you
contempt,
going
you
to
said civil.
respect the decisions that I've made
They're
by
not
not interrupting
they're
me?
not correct decisions, Your Honor.
I understand that.
I can't answer. You asked me questions. I didn't answer them based on my understanding. How can you force me to understand what
Look
you're
at that
asking me
sheriff
if I
in the
don't?
picture in the corner. They're
And
just,
then
that is
you
a
still
grown
make a
version of
finding
him.
based on that. How is that lawful law?
Mr. Brooks, I stand behind the record that I've made today.
And that's fine. I'm not
And I'm advising you
arguing
that
with
if
you
you
about what you
continue
rude.
to talk
I'm saying,
over
how
me,
can you do that without my
if
consent?
you continue to raise issues that I've
That's
already
a violation
addressed,
of my civil rights.
if you continue
Someone needs a
to raise
timeout.
these issues,
Someone's
sir,
had a
and thwart the purpose of
didn't get
this
enough
court,
sleep.
which is to finalize the jury instruction and the verdict forms, you will forfeit your right to be present in the courtroom, and you will appear from the other courtroom.
He needs a nap.
Absent you, I know
And
you've requested to
I
be
just
there.
made a request the moment we walked in here to not be present for these proceedings, but yet
But you
still,
also won't have a dialogue with me about your understanding
because
of
it's
what that means.
my Fifth Amendment right. I'm exercising my rights that I reserved from the moment we walked in here this morning. You can't force that. You can't force me to do anything, actually.
No, you're right, but I can make certain findings that you forfeit rights
You
that
can't.
you have based upon your
Based on
conduct.
what lawful law, Your Honor?
I've cited the law this morning. All right, I am moving
Illinois
on.
versus Allen, right?
I am moving
That I can
on.
be present from another courtroom
I need
if I
to
forfeit
discuss
my right.
instruction 315.
Your Honor,
because
I don't
believe some
understand.
language needs to be modified based upon the court's earlier ruling today.
I don't understand. I don't understand the proceedings. And I think that should be stated for the record. If I'm telling you repeatedly, Your Honor, that I don't understand. You can't force me to understand. That's a violation of my constitutional rights to try to force something upon me. That's coercion, Your Honor.
Mr. Brooks, I completely disagree with your characterization of the proceedings this morning. While it is true that you did not provide consent, you were entirely uncooperative with court this morning.
That's because I didn't
and
understand. I'm explaining why, Your Honor. I'm
And
not
the court
trying to
gave
leave
you
it where it
ample
was at. I'm
opportunity
attempting
to
to
answer the questions.
I'm attempting to
So I'm going to go.
explain myself of why I did not answer. It was because the way that you're making it seem is that I intentionally didn't want to answer, and that's
Mr.
not
Brooks,
fair.
I'm moving on to instruction 315.
And I still don't understand. So how can we even proceed?
Mr. Brooks,
if I'm telling you I don't understand
what that I'm asking you to be
No,
quiet?
I don't. No, I
Mr.
don't.
Brooks, please stop
And
interrupting
for the
me.
record, I don't consent to being called that name,
You
Your Honor.
clearly hear me, sir, because if you didn't hear me, then you wouldn't make that statement. So I
Hearing
know
and
you can hear
understanding
me.
is two different things.
I know you can hear me, sir. I'm asking
Hearing
you
and
to
understanding
stop
is two different
interrupting
things.
me.
I'm not trying to interrupt you, but you're gonna at some point you're gonna ask me my opinion of what's going on, and then when I tell you I don't understand, it's gonna be taken as me trying to delay or trying
If
to do
you
this or
stop
trying to do
talking,
that.
I will explain why I'm bringing up instruction 315.
And I'm not gonna understand your explanation.
Well, you can't say that if you haven't heard what I have to say.
Didn't you try to do this earlier before lunch?
But I need to clarify something because 315, which is the instruction that has it's titled Defendant Elects Not to Testify. I had it in there. However, that instruction should really only be given if requested by the defendant. There has been no request made.
No, his mom never took the stand.
And obviously this court made a finding that he forfeited his right to testify. And absent Mr. Brooks requesting that instruction to be in, I believe
Yeah,
it
this
would not
is-
be proper
he's-
for this court to include 315.
They've allowed so
in
much.
the instructions to the jury.
Kick him
Does
out
the state have any
or make him
position
stay,
on that?
but don't
Your
talk
Honor,
to him
I
about
did
it
look
anymore.
at the notes that are associated with instruction 315, and I would agree.
Mr. Brooks, do you have any position on whether this court should include instruction 315 in the jury instructions to the jury?
I don't even understand what 315 jury instruction is.
It's
I don't
entitled Defendant Elects Not to Testify. I'll read it for you. It's my notes, meaning my materials, my jury instruction book says to be given only if requested by defendant, and it reads as follows. This is the actual language of the instruction. A defendant in a criminal case has the absolute constitutional right not to testify. The defendant's decision not to testify must not be considered by you in any way and must not influence your verdict in any manner. So my question is, do you want this instruction read or modified in any way?
You just said I got a constitutional right
dog is tired
not
of
to
his
testify
nonsense.
or to testify. I didn't make either one of those decisions, so I don't understand
The
what
jury
you're asking.
instruction is typically read
Precisely.
when a defendant does not testify.
He chose to
In
represent himself.
every other case that I've had, the decision on whether to testify was a decision made by the defendant personally. In this case, the court found that you forfeited your right to testify based upon your conduct.
That's the Darrell Brooks
That is
sound.
the ruling I made this morning.
How did I make that decision though? I didn't.
My
I didn't
question
never
to
say
you
yes or no.
is,
I never
do
say
you
yes or no.
want the jury instructed that your
I'm giving him the
silence
goat-
must not be
the goat
considered by them in any way and must not influence their verdict in any manner?
What do you mean my silence? My Fifth Amendment right?
Correct. I'm not hearing a request from you to have the jury
Because
given this
I
instruction.
don't understand why you're asking me the question, Your Honor. I never decided to or not to testify. I never
understand
decided
that,
either
sir.
way.
You lost your
I
right.
understand that.
So how can I answer that? I don't understand why. I don't understand.
we are now at the moment where we are discussing whether the jury should receive
Playing
an
with this light
instruction
here.
specifically on you not testifying, irrespective of the reason for that. I believe I could modify this instruction to simply say a defendant's silence or a defendant not testifying should not be considered by the jury in any way and must not influence their verdict in any manner.
I mean, you could say
And
however you
making
want to say it,
such a
but he's
request
making
for
the choices he's
modified
making and
instruction.
getting the
I
results he's
don't
getting.
understand the question because I never decided to or not to testify.
I
Never
understand.
said.
I understand what you're saying, sir. I
never
really
said.
do. But in light of the court's
She would be
decision
the
that
only
you
one.
forfeited your right to testify,
How did I
do
forfeit
you
something I
want
never
the
said?
jury to be instructed something to the effect of they cannot use your silence, meaning they cannot use you not testifying against you in any way?
I don't understand because I never made a decision not to or to testify.
I'll ask you one more time, and if you do not answer with a yes or no, I will take your answer of not answering as you are not making a request for a modified instruction.
How can you do that?
Do
Your
you
Honor?
want this
Yeah,
court,
let's
sir,
see,
to
pre-dog.
instruct the jury in
Making
any
a decision
way
not to make a
regarding
decision is still
you not
making a decision.
testifying in this case?
I don't understand the question.
Like,
All right, then based
I don't
upon
you're
there's
you're
not
going
been an
skydiving
express
and you're out the edge of the plane.
request
You either
made
choose
by
to jump
Mr.
out
Brooks
or you
give
choose to stay in the
either
plane.
315
But by
as
not
it's
choosing to
in
jump,
the,
you've chosen to stay in the plane. You
standard
didn't
or
just
pattern jury instruction or a
didn't choose
modification,
something.
as this court
you
has
know?
suggested. 315 is to be taken out of the jury instructions.
Amazing.
How are all these decisions being made without me understanding?
He chose to represent himself, you
Then
guys.
I have
Remember
looked
this.
over the verdict forms, and other than really what I would describe as some consistency
Intelligibly
in how phrases
chose and
whether
has
it's
been
all
representing
caps,
himself.
not all caps, but
All caps.
what we call the sentence
Like the name that was
capitalization
on
for
there,
the
all
charges. For example, I want to be
It's just you,
consistent with
Brianna.
how I spell out first degree intentional
I
homicide
know.
or first degree recklessly endangering safety. There was just sometimes it was capitalized, sometimes it wasn't. So we're looking through all of that to be consistent. I want to make sure the word information is capitalized since that's the charging document, things of that nature. It is my practice, and you should be aware, Mr. Brooks, that I always put the not guilty verdicts on top
I mean, is
when
anybody
I
else
hand
getting
all
kicked
the
out
verdict
periodically?
forms to
Could be my data
the
connection.
jury.
also.
And by
I
that,
know.
I mean it's by charge. So they're collated, if you will. So the not guilty followed by the guilty for counts 1 through 76.
You said it's collated. What do that mean?
So I put the not guilty, then the guilty for count 1, followed by the not guilty and the guilty for count 2, and so on and so forth, all the way through the remainder of the counts that are alleged in this case, which in this case total 76.
I don't understand. So how?
Of that, we are all
I looked at
very
the,
aware.
Special questions
Will you
that
answer
are
that, Your
on the
Honor?
guilty verdicts only. They did appear to be proper. Again, just some grammatical things, but I believe those are all accurate.
Can I
I'll
go to
turn
the other courtroom
state.
since you don't have to answer?
That's
any
like saying,
questions
I just want to go
have
take a
answered,
nap, man. Can I just go take a nap? I just want to take a nap. No,
This time.
Why not?
because you don't just get to go to your own special courtroom.
I keep telling you I don't understand these proceedings, and you just keep running right over my rights, like
You're
you
not.
don't
You
even
don't have the
say
right to
anything.
just not get it. Tough shit, dude.
Attorney Basie, are you handling the verdict forms? Go ahead.
Can I go to the other courtroom, please?
The answer is no.
Are you waiving your right to be present in this courtroom?
I'm not waiving anything.
Then the answer is no.
I'm making a
Thank you.
request.
Then the answer is no.
Then how's it? So
Yeah,
what?
What's the lawful
You
law on
gonna
that
try
one?
to force me to interrupt and do all this so you can
I'm
make
No one's
the
forcing
record
you to
I'd like
interrupt.
make
you
it
to be
seem like
here.
I forfeited something that I came in here as soon as we got on the record and made a request to not be present for these proceedings. But when I'm making a request to avoid the drama and all that,
Sir, the only one with the drama is you.
it's you too. You're the big contributor to the whole thing.
Mr. Brooks, I have to preside over this case. I
Yeah,
have
and
to
you haven't
make
been
determinations.
impartial or fair yet.
Mr. Brooks, I have a question to the state. I ask that you not interrupt, and then I'll
It's
turn
it's
to
not
you
about
for
me
a response.
interrupting. It's about me attempting to understand. I've been saying that since we came in here.
Mr. Brooks, I
You
will
can't force
respond
me to
as follows to
understand.
that. You waived your right to counsel.
I didn't waive my right to no counsel. I
You
gave you the
waived your
contract.
rights.
I did not. And you won't sit here and say that for the record, because that is not
No,
what happened.
you are
No.
incorrect.
So we don't have the, do we have the
Your-
paperwork? Because I believe that I gave you the paperwork back that you,
Mr. Brooks, you very
I gave it to you, altered,
clearly
and did not waive it.
have been presenting a nuanced argument regarding
That
the
is
right
not
to
true, Your Honor.
counsel
That is not
versus
true.
the right to assistance of counsel.
That is not true.
That's a pretty sophisticated argument. That's why I believe you fully understand what's
I
going
don't.
on in this courtroom.
I don't fully understand.
I
Suddenly he
disagree
doesn't know
with
what's
your
happening.
I
characterization
disagree with your
of the
characteristic.
right to counsel.
You know that you accepted
You
the way that I
waived
gave it to
the
you.
entirety.
So you shouldn't have did that if you had questions of me not understanding.
I don't have any questions
You
whatsoever.
definitely
Exactly.
do, because I'm telling you right now, I don't
Exactly.
understand, and you still won't even acknowledge the fact that I'm saying in open court on the record that I don't understand something. I haven't waived anything. You made decisions today that I didn't consent to, that I explained I did not answer because I didn't understand, which is my right to say that.
Right, Mr. Brooks,
It
you
is
are
also my Fifth
interfering
Amendment
with
right
the
to be
proper and
silent.
orderly administration of these proceedings. I understand that you disagree with the decisions that I have made, but you aren't respectful of the decisions. You keep wanting to debate them and argue them. That is not the proper.
This is
legal
just,
recourse
it's
at this
amazing,
time.
man. It's wild.
I
It
have
really
asked
is.
you if you're willing to waive your right to be present. You indicated you're not.
Because
And
of
yet
the way
you
you
continue
put it.
to
You said
interrupt.
waive. I'm not waiving anything.
Then that's why you're here until I make a finding that you, by your conduct, are forfeiting your right to be present.
Well, make the finding and kick me out. Make the
We're
finding.
working on it, but you won't shut up so we can make the finding, man.
Which
Shut
you waiting
up.
to do anyway. That's why that courtroom is set up the way it has for the whole time, because at some point it's anticipated that I will be over there,
Yep.
which is not impartial and which is biased. It's judicial misconduct.
I stated from the beginning, sir, that the goals of this trial.
So you reading from
Are
the paper, or
threefold.
are you reading, or are you just citing what you
Number
know?
one, sir, is during the evidentiary phase of this was to
Oh,
control
wow.
the presentation of evidence so as to ensure fairness and reliability
This guy's
of
amazing,
the criminal
man.
trial process.
And I offered
That
evidence that you
includes
didn't allow.
developing relevant facts upon which
I love that he's just saying words
can be made.
while she says
What is
words
sometimes referred to in the
that
case law as the
have no bearing on
ascertainment.
anything, just
There's
words.
an equal but secondary purpose related to
Darrell Brooks.
efficiency and
Yesterday,
effectiveness.
trees. I
That has
snorkel.
been
We
my
swim. I don't
use of
know
906
for
11,
route when I do my
is
cherry pie.
what that would fall under.
It's basically
There's
exactly
a
what he's doing
third
right now.
goal of everything that I've
sense.
done here, and that is
Chad Rose,
the
same.
courtesy and decorum in this courtroom. What I've
Sorry to
sometimes
talk
referred
over,
as
but it seems
civility.
to be par for the
Of course,
course.
there are other goals as well, including protecting your rights, protecting the record, protecting the jurors.
How have my rights been protected, Your Honor, if I can't even?
Because they're
present
keeping you in
evidence?
isolation for 23 hours. If they
The
didn't,
decisions,
you wouldn't be
sir,
doing so well.
Yeah, but
They're protecting you
how can-
there.
How can I defend myself if I can't even present evidence?
But sir, you have not been willing to follow the rules of civility
But
and
that doesn't
decorum
have
in
anything
trial.
to do with my
It
evidence.
has
I could have did that from the other courtroom too, correct?
Sir, you.
If I
by
can be
your
present from the
conduct-
other courtroom, I should be able to present evidence from the other courtroom as well.
And you, by your conduct this morning, sir,
Hmm.
are
I'm
not
saying-
willing to
I'm
answer
saying-
the
I'm
most
saying
basic of
totality.
questions
The
about
totality.
whether
Totality,
you
my guy.
had
Have
a
I not
witness
asked?
available.
Have I not asked? In fairness, have I not asked to admit evidence? Have I not asked more than once?
Cam, you should have your
Mr.
sister
Brooks,
get a hold of me,
you have
man.
not asked to present any evidence.
Yes, I
in a
have.
legally
You
No,
told me we weren't at the
Can't imagine the
evidentiary
lawyer.
phase.
manner.
No.
How would I know that if you didn't answer
And
answer
you,
the question?
as your own attorney, you
As your own
proceed
attorney. There you
at
go.
your own peril sometimes.
That
Whether
has
you
No,
have
I
a
don't believe
full
the jury's in
understanding
this
of the
one.
rules of
Evidence.
procedure and rules of evidence or not. And
That
I
has
made that
nothing to do with me
abundantly
being able to
clear.
present evidence.
So,
Oh,
Mr. Brooks,
absolutely.
This is your
Nothing I
final
presented
100%.
have been able to be admitted into
I am turning
evidence.
to the state
This would
for
be a running
discussion
comedy skit if it
of
wasn't
the
so
verdict
horrific. Yeah.
forms. If you interrupt me or them again, then I will make a finding that you forfeited your
Make
right
the
to
finding.
be present.
Make the finding.
And
Sorry,
you will
Brandon.
appear from the neighboring courtroom.
You want me to appear from the neighboring courtroom? Let's
I don't.
just let me go.
Attorney
Get
Basie
up, please
told
get
me
up and start walking, dude, so he can get shackled,
I
shot,
felt that all the
because he's
verdict
shackled
forms
and
looked,
hooked up to a
good.
taser.
I did ask your clerk.
All right, he's interrupted. He's forfeited his right to be here. He's chosen to, you know, despite the warning from the court, will be
Off-
in
There wasn't
recess
no
until
warning.
Off to build a fort.
over.
So let's
To the other
make the record
courtroom,
correct.
and we
I'm
have
the one
the
that asked
audio
when we came in here, Your Honor.
and video working appropriately.
I asked when we came in here to
Madam
be
Clerk,
present
we'll
for the
have
other
to do
court.
it by Zoom because we may have to utilize the share screen in order.
We don't have to utilize no serious screen because I'm not going to participate in no proceedings that I don't
The
understand.
documents.
I told you I don't understand
We're
a
in
million
recess until
times.
we get the courtroom set up.
No, we don't have to be in recess. I don't agree to it.
I tell you what we're gonna do here. While they're doing that, I'm gonna give a comparative video watch of of how basically exactly how I feel we're all viewing Darrell Brooks at this point, which is, oh man, the best of the worst. We'll do this one right here, and actually, let's yeah. God, this guy, man. So I'm just gonna go ahead and put this up. These are kids having tantrums. We're gonna just watch this for a few minutes to appreciate the comparative between Darrell Brooks and what children do when they're having tantrums, because there's, I mean, I feel they're about one and the same at this point.
That's why you're such a silly man.
Hey guys, and welcome back to Spacebound. Today we'll be swinging through the stores post Black Friday to see up first at number 10, throwing around the B word towards his own mother.
Don't. Jaden, stop!
Jaden continues to let out limbs fly while the mom tries calming her son down, and when taking him over to the couch doesn't work, she literally takes him down to the ground on the spot they were just standing.
Sitting on the couch.
Yes, we are. Stop hitting and kicking.
That kid's got some good karate. Oh, rear naked choke. Rear naked choke.
I'm not doing this all day, buddy. Stop! Then stop.
You gotta appreciate it. Some kids.
Jaden immediately starts wailing as his mother keeps him still, arms even stuck behind his back at multiple points, and it all because poor little Jaden wanted to bring a soccer ball into the department store. Jaden, buddy, you've got one hell of a long life to go.
Stop it! Stop doing it! I'm just giving you a hug, buddy. I'm not gonna let you keep pulling the store apart and hurting me.
All right.
No, I'm just gonna stay like this for right now.
This kid, man, that's unfortunate. But there's obviously not the best one. Let's see, this one might be better. Mind you, I don't mind watching these because anything's better than watching Darrell Brooks get put in timeout. But when he gets put in timeout, it is pretty amazing. I don't understand anything. Man, these are babies.
Okay, can mommy get the cartilage from you though, please?
Give me something good here. I need a grown child.
You want to go to the pub? Pub shut.
Kid just wants to go to the
It
club.
does match. No, it does not. Baby, it matches just fine. No, it does not. Why does it not match? There's only tiny bit of blue in here. Honey, that's all you need is a tiny bit of blue. Mommy, I need something that really does match, Mom. Baby, it matches just fine. Go put it on. It's different kind of blue, Mom. It's a fine. It's a different kind of blue, Mom. All right, go get in the car. Your sister's putting hers on. You need to go get yours on.
So you want to cry by yourself?
Yeah.
Can I cry?
No.
So you just want to cry by yourself?
Yeah.
Okay, but I'm gonna cry. So
remember what I was saying earlier about how Darrell Brooks basically is like a kid.
Wait, hang on. It's my turn. It's my turn. Georgia.
Like throwing a fit in a mirror. Like, you know, once they see themselves in the mirror, they're like, oh, this is what I look like when I'm throwing a fit. So they like act to themselves. That's where we're at. Yeah, man. I think we all like to go to the pub at this point. But unfortunately, we're pulled into this day 13 of Darrell Brooks trial. Part 1, mind you, we will have to cut this at some point. We'll go out, we'll come back in because we have an 8 hour and 30-second window. So we are about let's see where we're at. About 5 hours in. So it's easy to say, guys, that this trial has been it's been interesting. You know, we've seen some pretty hilarious antics from, you know, basically Darrell Brooks, or this grown child that he is. We've also had a chance to see some really deep impacted individuals that have and not to switch gears on you so quick, but again, I deal with the severity of this case by laughing. You know, that's just how I operate. It's how I handle. But it's tough because we get to a place where we end up having to find a way to deal with the reality of what, you know, of what we're seeing and what we've witnessed, which is a horrific act that this guy committed. There's no two ways around it. He knows he's guilty. We know he's guilty. It's just at a point now where we want as much to stick as possible. Now, I'm going to put up the charges for you guys real quick so you can see what we're looking at. So right now we're looking at 6 counts of first-degree intentional homicide right here. Each one of those carries up to a life sentence, all right? 61 counts of recklessly endangering safety. Each one of those carries up to 12 and a half years, right? That's 700 plus years. 6 counts of hit and run involving death. I believe each one of those carries 25 years. So that's another 150 years. 2 counts felony rail jumping, 2 counts of battery. Those are basically inconsequential when it comes down to the grand focal point of life in prison, which is what, if that doesn't happen, I would feel that it's a pre-apocalyptic sign. I think that at that point we'd all be nervous, bunker down, kiss your loved ones, start buying up more toilet paper, get some canned goods, dig a hole, and bunker up because you know the earth's going to split open and there's going to be a holy war. Just saying. But we're going to go right back in here. So
I was incorrect. Mr. Brooks handed the headphones to the bailiff, saying he didn't want to break them.
that was very responsible of him.
All right, so we are discussing the verdict forms.
Cam Miller, go ahead.
Go ahead, Attorney Basie, you can complete your record.
All the verdict forms look good. I did notice, I think there's actually.
Yep. Brooks is in another timeout.
Count 15, I have a not guilty verdict. I did not have a guilty verdict, but the way that it was on the paper made me believe that something happened. And I think you probably have it with your packet. It just didn't get printed off for me.
We'll make sure that that's there. Any misspellings of any names?
I did not see any.
All right. All right, I did, when we started up the video conference, Mr. Brooks has been muted. I am going to unmute him right now. And I should state again for the record, all of the verdict forms, or at least the drafts, were provided to him prior to the lunch break. So he would have had an opportunity to review them should he have chosen to do that. Do you have any position on the verdict form, sir?
I wasn't provided with anything. If I was, I accepted and returned it for value. And since I'm now in another courtroom, are we going to address subject matter jurisdiction? You have yet to prove it for the record.
Mr. Brooks, you were provided with the verdict forms. What you did with them, I don't know.
Again, I haven't been provided with anything.
Mm-hmm.
They were provided to you prior to lunch, the lunch
I
break.
haven't been provided with anything.
Teresa, you had the large packet of verdict forms. What were they, how were they given to Mr. Brooks prior to the lunch break?
By hand to the bailiff and the bailiff to him.
To be
Yep.
And
No
the
boxes to
bailiffs
build
are
a fort with.
confirming that
Well,
that the
they're on a
verdict forms
tray,
were provided to him
or
on his table.
a cart behind him.
I will remind you once again that I do, it is my practice to put all of the not guilty verdicts on top of the guilty verdicts in a collated fashion. Again, I saw a couple of just cleaning up, I would say, not with the words themselves, but just capitalization of various words within the verdict forms, and I'll make sure that's done. The appropriate counts had and have the appropriate special verdict questions. Those special verdict questions are only as they relate to guilty verdicts related to the use of a dangerous weapon for counts 1 through 6, the homicide counts, and then 61 through, I believe 60.
It would be 7 through.
7 through 67 have that special verdict, and then the hit and run counts have the special question related to, did each of the counts involve the death of a person, and it names the person alleged to have been killed. So those look to be all in order. I've already addressed, going back to the jury instructions 315.
I mean, yeah, I enjoy spending time with you guys, but
rearranging some
like,
of the
I'm
order,
so
but
ready
the
for
content
this
is there.
to be.
It is my practice to
I'm so excited to see this get handed.
read through all of the instructions up until the point of closing arguments. And then I stop. Parties are given their opportunity to argue the case to the jury. And then following that, there are what I like to call the closing instructions, or which are still quite lengthy in this case, given that they go through the verdict forms specifically. And then, of course, the alternate jurors would be selected. But given
No, the jury hasn't been. No,
So I got a question about
the verdict has not been handed out yet. The jury hasn't even been handed the ballot. Or the,
how is that being charged? Is that under 939.632?
it is in the charging document, sir.
How is that being charged? From my understanding, that the statute reads, the increased penalty provided in this section does not apply if possessing, using, or threatening to use a dangerous weapon is an essential element of the crime charge. Without the vehicle, there is no crime. So that would apply. So how am I charged with?
State want to is your argument only as it relates to counts 1 through 6 or others?
Whichever count has the enhancement penalty for use of a dangerous weapon.
Well, that would be all of the intentional homicide charges and all of the first degree recklessly endangering safety charges. So counts 1 through 67.
So 1 through 67.
Correct. I can have the state respond to that.
Yeah. How is the alleged defendant being charged?
So are you asking how are you making a specific request as it relates to the special verdict question?
I would say both. Seeing as how I don't understand how, that's why there's the question. Reading the statute.
And which part of this, I'm sorry, which part of the statute are you referring to again?
I believe it's 939.632.
And your specific argument is what again?
How is that enhancement? How is the alleged defendant charged with that enhancement when reading the statute it says it? Well, I just read it, so.
I believe you're referring to sub 2, which states the increased penalty provided in this section does not apply if possessing, using, or threatening to use a dangerous weapon is an essential element of the crime charge.
Right, that's what I just read.
Well, what's the state's response?
Using, possessing, or threatening to use a dangerous weapon is not an essential element of either first-degree intentional homicide or first-degree recklessly endangering safety. If it were, it would be one of the elements in the standard jury instructions, and the defendant can see it is not. This is different from a situation like armed robbery, which does require the use or threatened use of a dangerous weapon. So the penalty enhancer is correctly charged for those two types of crimes.
Any final argument on that, sir?
Yes, that's not what the statute is clearly saying. It's clearly stated it does not apply if possessing, using, or threatening to use a dangerous weapon is an essential element of the crime charge. If there's no vehicle involved, where is the crime? It has to be an essential part of it to even be a crime. The alleged defendant is charged with using a vehicle to commit these crimes.
It cracks me that he's telling them what the statutes and rules are.
So it has to be an essential element of the crime. Otherwise, there's no crime. I think it's the essential element. If you read in the statute,
If the glove don't fit, you must acquit.
You can't just walk up to someone and quote unquote run them over. There has to be something used in order for this
The car that they've
alleged crime to transpire.
exhaustively showed in great detail that you were driving.
Mean the quote unquote dangerous weapon. So without the quote unquote dangerous weapon, where's the crime? So how can it be charged when it is the
Got you, Judge. What's up
of
now?
the crime charge?
Boom. Take that. Lawful law
Sir, I've
now.
listened to your argument.
Yeah.
I've read the statute. I've
And you're
looked at
right.
the
Case
elements
dismissed.
for intentional
That was all wrong.
homicide and first degree recklessly
Man.
endangering safety. Neither one of those crimes have as an element in it use of a vehicle. There are certainly many different ways that both of those statutes can be violated. While it's true that in this particular case, the use of the vehicle is the mechanism or instrumentality that's being alleged to have been used, but it's not the same as being an essential element of the crime. I think the armed robbery
Yes. So you mean
crime
the red
is a
Ford
good
Focus Mr. Brooks was
example
driving?
of when you could not face an enhancer for use of a dangerous weapon because you can't have the crime of armed robbery without the threat or use of a dangerous weapon. And
That's
so
the same argument in this, Your Honor. You can't have this alleged crime without the use of the vehicle. It's the same thing.
it's not an essential element of either first degree intentional homicide or first degree recklessly endangering safety. So
I love that
I'll
he's so
deny the request to strike the
absolute
enhancer
that he's coaching them on what's
for those reasons.
what the code
and
is
find that
here.
it is properly before the jury for their determination.
Oh gosh, this guy.
I respectfully object to that, Your Honor.
I respectfully
Understood.
object
Do
to
you
that.
have any other challenges to the verdicts you'd like to raise at this time?
Yeah,
For
that
truthfulness
be-
or
my
untruthfulness?
objection, that be noted for the record.
It is
Now request a legal reconsideration of your ruling, Your Honor.
denied.
May I request a written finding of fact for your ruling, Your Honor?
Denied.
Denied. Sounds like a very, very
Just for the record, it's my understanding
Poppy,
that the verdict forms were
Siri
put
voice.
in the garbage by Mr. Brooks, and they remain in there. That was provided to me by the bailiffs.
May I respectfully request a written judicial finding of facts and conclusion of law for this issue, Your Honor?
You may request it. The request is denied.
Also, I object. It's not a garbage can. That's my special secret box in my fort. So
For interlocutory declaratory appeal on this matter?
This is not the proper court to grant such relief.
For the record, may I move to stay these proceedings until this instant matter is adjudicated by a court of competent jurisdiction?
Your request is denied.
Based on what law or fact?
Your request is not based in law or fact, sir.
or in reality, or in human scope of understanding.
I just read a statute that it came from.
Yeah, well,
My
don't fit,
argument was
dude.
based on a statute.
I'd also like to state John Jacob Jingle Heimer-Schmidt. That's
Your
not
request
my name
is
too,
noted.
but it could be.
Your objection to the court's finding
Also,
and
whenever I go
determination
out,
is noted. I decline to issue any type
people
of
always shout.
written decision or stay
Guess what?
pending appeal.
There goes John
Knowing
Jacob
there is
Heimer-Schmidt.
no appeal that has been filed.
May I make the record show that this court will not allow the accused to adequately defend themselves in this matter?
Are you saying you're the accused? I thought you were
Court's
representing the
already
accused
made
party.
its findings regarding the forfeiture of right to testify and the forfeiture
Man,
of the
so
right to
late in the
present
game. That's his
additional
file cabinet.
evidence and testimony. I'm not going to revisit the same.
That's it. It's not a garbage can.
I
It's
never
his file
stated that I
cabinet. That's
did
it.
or did not
Understand.
testify.
I understand.
So how can that decision be made on my behalf when I didn't say either way?
On my behalf or on your defendant, on the defendant's
What I said
behalf?
was I didn't understand the questions being answered.
Sir, do you have any other
All of a sudden, he's
questions
he,
or
not
issues regarding the
the guy
verdict
formerly
forms?
known as Darrell Brooks.
Your Honor, are you
Sorry, I
making
know I'm
a
talking to
judicial
myself.
determination that you don't have to answer any questions?
I'm not answering those questions, sir, other than how
Is
I've
that-
already answered them.
Is that a judicial determination?
Sir, every decision I make is a determination. by
Thank
this
you,
court.
because I'm a judge, you dumb bastard.
Sir, I will
Every
ask you once
decision I
more.
make is
Do you have
judicial.
any other issues
And I will
to
say you
raise?
once more, I
with-
don't understand the questions that you are asking.
Sir, do
So
you
I
have
would-
any other issues to raise with respect to the verdict forms?
I do not understand the questions that you are
He
asking.
has now
I don't
twice
understand.
not answered the question. I'll ask one last time and specifically advise him that his failure to answer the question will be taken by this court as a no. Sir, do you have any
what law or
additional?
fact? Under what law or fact can you say no? when I'm
Sir,
telling
do you
I
have
don't
any
understand?
additional issues to raise with respect to the verdict forms?
I do not understand the questions that you are asking.
All right, he
I
has
don't
chosen
understand.
not to answer other than by saying he does not understand the questions. He did not specifically answer with a yes or no. Therefore, this court takes that as he does not have any additional issues
That
to
is-
raise with
that is
respect
incorrect.
to the
That is
verdict
incorrect.
forms.
That is
Touche,
incorrect.
Your
I
Honor.
stated I don't understand. You can't force me to understand something, Your Honor.
Right. Did the
God,
state have
just
any
all
other?
It is my
I'm
my
going to mute him
constitutional right.
momentarily.
It's
Mr.
my
Brooks, I'm muting you
constitutional
because
right.
I'm moving on to another topic.
Also,
I
you're an
understand
idiot,
you
so-
disagree with the court's rulings, but you need to respect the rulings with proper etiquette in this courtroom, which you are demonstrating once again you're not willing to follow. So I exercised my ability to press mute. Does the state have any other requests as it relates to the jury instructions? I want to kind of full circle back to that because I do need to approve of them.
We do not.
Yes.
All right,
we
Mr.
do.
Brooks, I'll ask you the same question.
Yeah, he doesn't
I will
understand 'cause he's not
unmute. Do you
getting his
have any additional requests as it relates to the jury instructions?
Should have kept your
Yeah, I
counsel.
have
Thank you,
questions
Ken.
related to all of them because I don't understand any of this.
My
I don't
question
know what's
was, not,
happening.
do you have questions, but do
And
you have
my
any
answer
requests?
was I don't understand. And I've made several requests.
Yeah. Yeah.
The requests are not related to the jury instructions, which is the phase of this hearing that this court is attempting to conduct with you and give you the opportunity to fully participate. Mr. Brooks is choosing not to answer my questions. I'm going to mute him momentarily, sir. I will ask you one more
It's
time.
what you do with kids,
If you have
man.
any requests as it relates to the jury instructions, I then will ask you if you approve of the jury instructions. If you do not answer those questions as it relates to the question, do you have any requests as relate to jury instructions? I will interpret that as a no. And if you do not specifically answer the question about the jury instructions, I will interpret that as your approval.
Carrie, same.
So first question to you is, do you have any, and you're unmuted, do you have any requests at this point
Muted,
as it
gotcha.
relates to the jury instructions?
That's my business.
And I just
Ah,
said
Brandon.
before, I said I do. I said I don't understand the question. Of course I have questions if
What's
I
the
don't
business?
understand.
So do you have any
That's common
requests
sense.
for any additional instructions that are
Yeah,
not included, or to remove any that are included?
Yeah, remove them all until I understand, or add the jury instructions that I have myself.
What jury instructions do you have, sir?
She's been asking you to give those to her for a
So
minute.
now you don't know I had jury instructions, and I told you this weeks ago.
What filing are you referring to, sir? If I've overlooked that, I will certainly reconsider, but I'm not
You
aware of a
overlook
specific jury instruction.
It seems like you overlook a lot, Your Honor.
Can you point me to a specific filing?
Yeah,
So you
Jim.
have all my filings on file?
What's your legal law for that?
Are you saying that you have my filings and they haven't been admitted into evidence?
Someone made a point that Brooks in the movie Shawshank also
Not a computer that way.
was one that sadly took his own life. Just an observation about a movie.
Sir, please direct me to the specific
Tim
filing
Robbins
that you're
is
referring
amazing.
to that has a request
But Brooks in
related to
said
jury
movie
instruction.
couldn't do life on the outside. Just
You
curious
just
if he
said
can do life on the
you just
inside.
said you was referring to the filings, right? Did you just say that?
That's not what I said.
Didn't you just say what filings are referring to jury instructions? Did you or did you not just say that?
I said, do you have a specific filing you can refer the court to that relates to jury instructions?
So is your computer working or is it not working?
It's being a little temperamental, but I have,
You know, she knows all about
I
dealing with
just can't
temperamental.
use my search function. So if you can direct me to a filing, that would be great.
Yeah, go ahead, bud. Give her your direction,
It would also be great for those filings to be admitted into evidence.
wouldn't it? If they were there.
Sir, simply filing something with the court does not make it evidence during the evidentiary phase of a trial. There are rules of procedure and rules of evidence that govern that.
Exactly.
And you told me to make all my filings in writing.
Sir, I said if you had a motion, it needed to be put in
All those
writing.
were motions. All those were motions.
Sir, what
He doesn't
filing
understand
are
what
you
motions
referring
are.
the court to?
This is wild.
Look through all my motions.
Sir, it's not my job to advocate on your behalf. If you have
I didn't
something in
ask you to advocate
particular,
on my behalf.
Sir-
I asked you to do your job.
sir, if you have something, a specific request,
she's
now
gone
is the
above and
time to
beyond.
make it.
On her job.
Well, how about this? I don't accept none of those jury instructions. I don't accept any of them. Any of them. And again, I'll tell you, I don't understand. Why do I have to keep saying this
Because it's a lie?
when it's clear that I don't understand?
It's very clear you do.
Your Honor, I can inform the court that jury instructions were due, I believe, on August 30th. The state submitted their proposed jury instructions as well as the substantive
I
instructions.
second that
And the defense
emotion.
indicated that they agreed with our filing. So I don't believe that there's ever been a request for any different jury instructions than what have been filed with the court.
So what jury instructions are you referring to, or what document is being referred to on the alleged defendant's behalf? Because as we all know, I didn't obtain the discovery in full until the end of September. So there was documents that I didn't even know.
Yeah, you did. Your legal team did.
Mr. Brooks, one final time. Do you have any specific requests as it relates to the jury instructions other than your request that they all be struck?
And I'm telling you, Your Honor, I don't understand the question. I can't.
All right, then I will take his response that he does not understand, that he does not have any additional requests.
I didn't say
And
that.
they will be
I said I don't
approved.
understand.
They will be
You can't-
approved and are,
No.
I'm gonna have to mute
No.
him.
No.
They are approved as
I don't like that.
been drafted by the court and modified during the jury instruction conference on the record this morning and this afternoon. I will once again review all of them just for grammar, just to make sure all of that is correct. And provide a written printout of the final draft for the parties before we break for the day today. I am also approving of the verdict forms that have been previously submitted
No
to the
sound?
parties. Just
Is that what I'm
knowing there's
hearing?
just a few grammatical things that need to be corrected, but the content and substance are there, and I've already addressed on the record any requests by the parties this afternoon.
I got sound on my side. Are you guys having issues with sound on your side?
No, Your Honor. I believe that the final copy that we've been working off of is appropriate.
You look good. Everything looks good on my end.
Any comment about that, Mr. Brooks, or any statement?
I don't consider being called that name, and I just told you I don't understand these jury questions. I'm not going
Okay.
to.
Yeah. If you don't have sound, maybe reset.
How they allow it to pass just because you feel that they should.
Do
When I'm
a
telling you I
refresh.
don't understand them.
Okay. Thanks, guys.
I would note
None
that
of those,
his
one of those jury instructions came from me. Not one. How's that fair?
Mr. Brooks, this court gave you the draft
didn't
of
give
the
me
jury
anything.
instructions.
You didn't
I
give me
need to
anything.
mute you because once again, he's debating about things that I think are very clear on the
Mhm.
record. This court
Okay.
provided both the state
I'll leave it alone
and
then.
Mr. Brooks with a
The other mic might be a
written
little lower, but
printout, 107 pages long of the jury instructions it was considering in this case. We had a discussion this morning. We continued that discussion this afternoon. Prior to breaking for the lunch hour, all of the verdict forms were printed off and provided to both the state and to Mr. Brooks.
ooh,
It is
Gail,
also
good
true
looking out.
that
Thank you
when
very
he was
much.
previously represented by counsel, the court had some specific deadlines related to jury instruction proposals. And the state reminded me that there essentially was not an objection raised regarding the proposal and the filing from the state. I had a brief opportunity to look through the record of the inmate communication forms that have been sent during this trial that are on file. I haven't seen anything that references jury instructions. I'm well aware that he has other filings, but I could not find anything related to jury instructions and any specific requests that he is making or made during this case. So for the record, I am approving of the verdicts. I am approving of the jury instructions. And once again, before we break for the day, I will make sure to provide the parties with written printouts of both of the documents as they now stand. Then there are a few other issues we need to go through. Attorney Basie, I think you brought these up prior to the break. Maybe it was Attorney Opper in terms of scheduling and what I would consider other housekeeping issues, but go ahead and remind me once again of the issues you wanted to bring up. I think it was the alternate sequestration, and there might have been a third.
Yes, Your Honor. The
Griffin, you're cool,
question
man.
is to
You've been
the
killing it.
sequestration of the jurors once they are excused for deliberations, and should the timing require that, an overnight stay or something along those lines. We wanted to discuss that. We wanted to discuss what the court intended to do with the three alternates once they have been selected. It would be our request, the position that they should remain in a secure location separate and apart from anyone else unless and until full deliberations are complete by the 12 selected to decide the case, so that if needed, and in light of the brief COVID history we have on this record, if needed, one of the alternates could slide into position of one of the 12 who are deliberating if that became necessary. So we wanted to address that, and then we just wanted to address timing generally for closing arguments, verdict returned by the jury, and then the court's intentions as to the rest of the week, should there be guilty verdicts returned.
Sure. Before I address all of those, are there any of those final type of issues, sir, that you would want the court to address? You have been unmuted, so you can answer that. Mr. Brooks, do you have any of those final type of questions or issues that you want the court to address? You are unmuted. I am.
I just told you since nothing I say even matters at this point, I'm just gonna tell the jury what they need to know. I'm just gonna tell them the truth.
Mr. Brooks, you are aware that your closing arguments have to be based on law and fact, correct?
They're gonna be based on whatever I'll base them on.
Well, I trust the state will object when appropriate,
Well,
if appropriate.
It's gonna be a whole lot of objection then, because I'm gonna tell the truth. You haven't allowed. You just been making all the decisions for me, even though you know I told you repeatedly that I don't understand, and you still make decisions based on my behalf without my consent, without me. I'm telling you I don't understand, and you still make a decision determining my life.
Are you telling me, sir, that you will refuse to follow the simple rules of decorum, courtesy, civility, the rules of evidence, and
don't try to come
the
with
rules
your
of
slick
procedure?
words. Don't try to come with your slick words, and don't put words in my mouth.
Sir, I am not being slick. I'm trying to preserve the integrity.
You've been slick. You've been slick.
All right. I'm going to mute you, sir, since what you are saying is not productive. It is not courteous. It is disrespectful. I need to go over these. All right, I'm muting him because I need to go over these important issues that have been raised by the state. So as far as the alternates, I do think it is important to keep the alternates who in a secure location, even if that means an overnight, unless and until verdicts are reached in this matter. And I will so instruct the clerk of courts to make those arrangements. We have been doing that all along in any event. As far as selecting the alternates, obviously each of our jurors have a number. I intend to have pieces of equal size pieces of paper made, folded up with each of their numbers, put them in the same turnstile bin that we utilized for the selection of jury preemptory strikes by lot, and to simply pull out 3 names. Those will be the alternates, and then or should say not names, the numbers, and then the numbers that are remaining would be those 12 who will deliberate. And so I'll make sure that that's out here for the appropriate time. As I indicated this morning, all of the jurors were provided with some information regarding sequestration. It is the practice of that I've approved in this case that the jurors provide us with certain emergency contact information so that we are able to get a hold of families should there be the need. They're given information regarding sequestration, the purpose of it. If I have not made that a part of the record, I will make sure to get a copy of that filed in this case so that both sides know what was provided to the jurors today before they left. And then I'll also make sure that when the 12 are deliberating, that the 3 who are not are taken to a different jury room with a bailiff, and again, kept in a secure location, but separate from the other 12. In the event one would be needed, we would then take up that issue at that time, but I think it's good practice to have them available if that becomes an issue. As far as timing, I'll first address, I have instructed the jurors to be back at 9 a.m. That's because typically we have a few things to finalize in the morning, so we'll start at 8:30 tomorrow morning. It will also give the parties one final opportunity to read through the many, many pages of jury instructions and verdict forms to just make sure there aren't any other issues that jump off the page or that need to be addressed first thing tomorrow morning. But then I do intend to start with instructing the jury. This case will require a very lengthy time of the court reading off the jury instructions. I do believe it will require me to take some regular breaks, probably every 2 hours, until the jury instructions are read, with perhaps a longer break at the lunch hour. And my best guess is that it'll take between 5 and 6 hours to fully instruct the jury. That's based on the 107 pages. Now, some of those pages, though, are after argument. And so that really kind of begs the question is, will the parties get to their closing arguments tomorrow, or will that be done Wednesday morning? I certainly would like to have the parties make their arguments. Madam Clerk, can I see the instructions that we have thus far? The packet? It should be done. Okay, thank you. Single side. So the instructions that I read prior to the parties giving their closing arguments finishes on page 73. So given that, I believe that the parties will be able to give their closing arguments tomorrow. It just may be, depending on where that takes us, whether the final instructions are given the following morning, because that's another 30 pages. I'd like to be able to do it. It just really depends on how late of an evening. I'm not opposed to going late, but letting the jurors go to the hotel and then starting their deliberations in the morning, if that's what needs to be done.
Understood, and we'll be ready. I think from our recollection, it took you about 2.5 hours to read the preliminary instructions, which was 69 pages in length. So if that holds, I think, we reasonably could do closings in the afternoon, and it'd probably take you about an hour, hour and a half to read those remaining 30 pages. And we may still be able to wrap up by 4 or 5 o'clock in the courtroom.
I think that's a reasonable time frame. Do you have any estimation on the length of your closing? I'm contemplating maybe putting a time restriction for both parties. I mean, we had a solid 15 days of testimony, so I'm mindful that this is not a 30-minute closing.
Well, actually, I'm trying to keep it in the 30 to 45-minute range, just out of courtesy to the jury, and to highlight the important points.
Do you think it would be reasonable to give the parties each an hour total? That would reserve whatever's left from your initial for any rebuttal?
Yes.
All right, Mr. Brooks, do you have any position on that? I am unmuting you. I would note he takes the headphones on and off throughout. He doesn't have them on. He's looking at a book.
I wish you would stop saying, look, I'm looking at the Bible. Thank you. not just a book, it's the book.
Can't disagree with you there, sir.
Yeah. How many people actually live by it though? Anyway.
Sir, I'm contemplating putting an hour time limit on closing arguments.
I ain't doing no closing argument tomorrow.
The closing arguments will most likely be tomorrow.
I'm not doing it tomorrow.
Then you'll forfeit your right to give one, sir, because as we have.
You can't force me not. What type of court is this where you can say you're gonna force somebody not to be able to give a closing argument? How's that lawful law?
If you choose not to give one,
how's that lawful law?
Sir, if you choose not to give one, you're not letting me finish, and you're mocking me right now, which is incredibly disrespectful once again.
Okay,
you didn't even let me get my sentence out.
You always want to make an incorrect record. Go ahead. Make your incorrect record. Go ahead.
I'll mute him once again because clearly he just wants to be disruptive this afternoon. But as we have been talking about over the course of the last, 10, 15 minutes, talking about the timing of everything tomorrow, even though I have 107 pages of jury instructions, the first 73, I think, deal with what is read prior to closing arguments. That means the parties should be prepared to give their closing arguments tomorrow afternoon. I will do my very best with just one mid-morning break to get through all of these, the first part of the instructions. Then the state will give its closing argument. I'm giving the parties 1 hour each. I think that's reasonable under the circumstances. Whatever the state doesn't use in its initial time of closing arguments, it can reserve for rebuttal. But then following the state, we may need to take a break of some sorts, probably before the defendant goes, just for the jury's sake and the party's sake. We will need a comfort break. But you should be prepared to go tomorrow afternoon. Then the state, if they have any rebuttal, will get up within that time limit. I will myself, and I'll have my clerk make sure we accurately time that. I will read the final instructions, and I'll really leave it in the jury's hands. If they want to start deliberating, that's fine. If it's 7 o'clock at night, I'll probably tell them we're going to break for the night. They'll be sequestered, but they will come back and begin deliberations in the morning. That'll be Wednesday morning. But now that I really kind of laid that out and thought about the break I will have for closing arguments with even my 107 pages, we can get this done tomorrow. And so that's my expectation. So, Mr. Brooks, I'll unmute you, but that is the expectation of the court, that closing arguments
I would be able to put on
will be done
a speed
tomorrow.
read, like 3 times speed.
You can't rush me to judgment, or you can't practice law from the bench and tell me when I can do something and when I can't.
She
Mr.
just
Brooks,
did, didn't
I
she?
actually can, under all of the rules of procedure. It is my job to make sure there's effective and efficient administration of this trial.
Exactly.
I should be allowed to, and if that's the case, then I should be allowed to tell the jury what they need to know, which is the truth, that they have the power. They have the power.
You've been in front of the jury for how many days now?
You are absolutely not allowed to tell the jury that. There's a jury instruction that I will have ready to go if you even attempt to raise the issue of jury nullification, sir. You have absolutely no right to raise that. That is clear under the law.
I can raise what I want to raise.
No, you can't.
And you can't. So
You're just raising my
at the last meeting.
my blood pressure.
You should have never approved them from the get-go because I never approved them. I told you I didn't understand them at all whatsoever, and you still passed it.
Sir, if you understand jury nullification, you understand jury instructions. It's clear to me you've done your homework.
What you talking about? I don't care what you're talking about. I'm going to let them know that they can nullify any law they don't agree with, which is my right.
It is not your right to do that.
Say that it's not.
It is not your right to raise jury nullification.
Show me lawful law then. Show me.
All right. I'm going to mute him once again. He's starting to raise his voice. He's starting to hit his hands on the table. It's very clear to this court that it's going to be a challenge tomorrow during his closing arguments. He does not have an unfettered right to say whatever he wants or how he wants. If he is going to be adamant about defying the court's rules, which I will tell him in part what they are today, and I will work on that as we break and have a very clear advisement for him tomorrow morning. He may run the risk of being put in the other courtroom because he'll forfeit by his conduct his right to be present here.
His choice.
And I will be able then to exercise the mute function. I have to balance, frankly, the fact that he's in custody, that it takes time for this jury to be excused. They have to walk an entire hallway behind me. I frankly don't want him to look worse than what he's looked, frankly, in front of this court when they haven't been in this courtroom. I need to preserve how he looks to this jury. And I will need a very clear pledge by him that he will follow the rulings that I make as it relates to the closing arguments. He cannot raise jury nullification. He cannot raise facts that are not part of the record. He cannot raise subject matter jurisdiction. He needs to argue the facts based upon his theory, based upon the evidence that's been presented. And those are the bounds. If he's going to, I can only imagine there may be some objections by the state. If there is an objection, I expect that he will stop and wait for this court to rule on the objection. I expect that if I sustain an objection, that he will honor it. And if he can't pledge to follow these very simple rules of courtesy and decorum that are consistent with the rules of procedure and the rules of evidence, then he will be in that other courtroom for his closing argument, so that I can exercise mute,
Yeah, just look, I was
frankly,
definitely hearing
to
commotion.
protect how he looks to that jury. Because that is the balancing that I am tasked with tomorrow, is to ensure that this jury makes a determination based upon the evidence and the law. You do not have a right to talk about sympathy. That's very clear in the case law, whether it's evidence or arguments. The juries, if you read through the jury instructions, sir, you will see they are specifically told they will not be swayed by sympathy, by prejudice, or passion. They are not to be concerned themselves with any penalties. You can't argue penalties. You can't argue jury nullification. You can't argue legal issues that aren't relevant to the elements and the other law that's in these jury instructions. And those are the very clear rules that you will need to follow. And like any other time in this trial, if you don't do that, you will forfeit your right to argue your case to the jury, or forfeit your right to be present in this courtroom and appear from the other courtroom. And you are squarely put on notice of that here today, sir. With that, I think I've addressed all of the issues the state has asked me to address. Oh, one other issue, verdict timing. I know we have some time on this. I realize that there are many, many victims who may still be watching the proceedings remotely. There may be news media, in fact, that may want to cover the verdicts. And that this jury will take some time due to the sheer volume of
I don't think it will.
counts in this case. When this court is advised that verdicts have been reached, I'm contemplating between 30 and 60 minutes before bringing everyone back into the courtroom for the verdicts to be read in open court. And if parties believe I need to wait longer, then let me know. But I think some of it will depend on is it late at night? Is it during the day? Are we dealing with any kind of traffic issues? I realize Mr. Brooks has family in Milwaukee area that may want to be here as well. Even if I consider kind of, the outlying areas of Waukesha, you could be as much as 30 minutes away. So that's my initial thought on that. Any statement from the state on that?
Not on that issue directly, sir. Oh, I'm sorry, Your Honor.
It's okay.
I apologize.
Any other issues?
Yes, my other issue as to verdicts was seating, if you intended to maintain the designated benches for the reasons you just said?
I would intend to keep the seating as is.
Okay, with the
The
reserve.
entire side behind the stake for victims.
Okay, and the other side
Public.
reserved for the first 5 minutes, or is that open seating over there? Or do you
My
wanna think
previous or my rule throughout has been 15 minutes. What I would say is any open seating will open the courtroom. It'll still be open the whole time because we're waiting, right? So it has to be. So any seat that's left open within 15 minutes, victims could also sit on the other side.
Okay.
If that's what you're asking me.
Yes.
All right. Mr. Brooks, any further topics by you?
Am I muted?
What do you
No,
think?
you're unmuted.
So, again, I don't understand nothing you just said, but
No, we've been in trial for 13 days now.
I don't. How can you deprive me of my constitutional rights?
They're going to do
How can you trample on my
jury. They're going to break down things for the jury, and then they go to jury deliberation.
Sir, you can forfeit a
They
number
do
of
final
constitutional
statements,
rights by
and then-
misconduct on your part.
Not if I reserve my rights. You can't let me reserve my rights and then take them from me.
Sir, I direct your attention to Chambers versus Mississippi,
I'm not
Rock
gonna
versus
hear none of that
Arkansas, State
because-
versus Anthony, Illinois
If they
versus
reserve their
Allen,
rights, if they reserve their rights,
the
Did
Beneby
any of those
decision. There's a host
Did
of
they-
case
did they-
law, sir.
did they reserve their rights?
All right, sir, you are simply mistaken on that. So I'm muting him once again. He's not giving me any other issues to address. We are in recess.
Oh, I'm sorry, I had a few
Go
other.
ahead.
I'm
You
sorry.
do. I'm
Yeah.
sorry. Go ahead.
I just wanted the record to reflect that at about 2:04 p.m., your clerk had provided the final version of jury instructions to both the state and to the defense. I watched on video as Deputy Wittig left this courtroom, went over to the other courtroom, handed the final jury instructions to Mr. Brooks, and he immediately turned and dropped them to his left off the side of the table. I can't tell from the video if that's where the trash can is located or not, but I did see that immediate response after he was handed the final jury instructions. Another
Did that
thing.
include the verdicts or just the jury instructions? Okay, it's just the jury instructions, but thank you, because I didn't see that given some of the things I was looking at up here, so I appreciate that.
Were all jurors, or will all jurors then be told to report with an overnight bake?
That's part of the instructions that
Okay,
they were
and you're
given.
gonna make that available to us?
Yes,
Okay.
I'll get Lauren down here right away, and I'll make sure that before Mr. Brooks is taken back to the cell. I see your arms waving. I'll get you in a second. That he's provided with that as well.
All right.
And you as well.
And then one final thing as to timing, and again, I don't mean to be disrespectful to Mr. Brooks or anyone involved in this matter, but should there be any guilty verdicts in this case, would you be intending to proceed to sentencing yet this week or at a future time?
You know, that's an interesting question because I don't know how many victims will want to speak. If we have time, I would certainly consider that. I mean, I have this entire week set aside yet. And I have Monday morning, but I have some other things Monday afternoon, and then I am not available the rest of next week. So it really just depends on the timing. I would need to know from both the parties whether they anticipate anyone speaking other than the parties themselves. Any family members?
Yes,
I don't think I need a PSI. This is a trial. This is not like a guilty plea. So, Mr. Brooks, I'll get you. I'm unmuting you. Go ahead. Go ahead. You're unmuted.
And since we're all making records to make me look bad, I think we should say for the record that one of the rights I have is to demand that the court place in the evidence any unrevealed contract, statute, laws, rules, or information being used against me under the Sixth Amendment. So how come that hasn't been placed in the evidence?
What law are you referring to, sir?
I'm referring to my rights under the Sixth Amendment.
And what
My
case law
constitutional
says you
rights
have a
under the-
right to do exactly what you just said you have a right to do?
The Constitution, Amendment 6.
So that is very general. your statement. It's vague. There's nothing
So we gonna
specific
go what?
you have
What
referenced.
You want paragraph 2 or something like that? Is that what you want?
No, that's not what I'm saying, sir. You're making
So,
general arguments
also-
that aren't based in fact and are overgeneralizations of what the law requires as well.
I accept for value and return for value any documents in this matter. Since, you know, it might be another record of what I'm doing.
Let me know if you guys have any sound
Always
issues,
a
okay?
record of what I'm doing. And I also have the right to ask, is this common law or admiralty law? Because judging by the gold eagle on top of the flag, it's some explaining that needs to be done. That is a military symbol. So is this a common law court or admiralty law court?
Mr. Brooks, I'm frankly not going to address these nonsense legal theories of yours. I'm muting you. They have been debunked. They are typical sovereign tactics that have no place in our judicial system. We are in recess. I'll see everyone tomorrow morning at 8:30. I'll just direct the bailiffs to wait until we have the verdict forms to give. And if it takes us longer than 30 minutes, we'll make sure they're delivered to him in his jail today. Thank you, everyone.
Thank you.
Well, we'll give it a minute here and see where this goes, because it's, you know, they might have to do a little more. I'm glad you guys can all hear it. Okay, we're going to touch on a couple other things here before we end it here, but ending early on my part sounds great. Griffin, have a good one, man. I feel like they're just keeping it on him right now because, yeah, okay. Well, so he is done now with being Darrell Brooks for the day. The persona that is this court pro, aficionado of the legal system. Wow, you know what I mean? Is just a huge wow situation. I'm amazed that we're sitting through, that we've made it through 13 days of this, and that we've had to hear the raging amount of nonsense that we have. But to your credit, to my credit, to everyone's credit here, we have been, and we're going to see it through to the end. Because yeah, we're pushing for that guilty verdict, and we're looking forward to seeing that. It's what needs to be, it needs to be swung out, and I don't think it'll take a long time. I think the judge is feeling that there's going to be, a lot of, I think the issue they have is how many charges are being filed. And so the jury is burdened with the task of having to figure out what's going to stick and what's not. And the question really is, isn't so much if he's guilty, obviously. It's not at all if he's guilty, but it's whether or not they're going to go with 6 life sentences plus 900 years, if they're going to hit the full leverage of the penalty for all the crimes that he's being tried for. If they go for reduced sentencing, if the judge goes for reduced sentencing on anything, that's, I think, still on her. So, but tomorrow, you guys definitely have notifications set up on all of your channels. And I do appreciate you guys with the stars and the super chats today. Disgruntled 11B, appreciate the super sticker. Everyone that's been dialing in. I want to swing over though before everyone disappears on me, and touch base on another trial that happened today. This is the Ethan Crumbly trial, the Oxford shooter, who we're going to jump in here. He just pled guilty today, and I really want to show a little bit of what's happening with that. This was just earlier today. He pled guilty to, which is wild. He pled guilty to 4 counts of murder, I believe, and terrorism charges. So we're going to go ahead and pull that up here and take a look at how that went earlier today. Because now, I remind you, in the Crumbly trial, let me get rid of this here. You good, bud? Jits over here is. Having a hairball moment, little man. Jits. What a fella. But the Crumley trial. So Ethan Crumley is on trial. Well, now has pled guilty to for the Oxford school shooting, all right, where he shot and killed. And I want to make sure, because it's been a little bit since I've revisited this trial, where the 4 students who were killed, and this is back in November 30th. Okay, so we just went through the Darrell Brooks situation, November 21st, 2021. And then we swing over, a week and a half later, we have this school shooting. And it's just, it's terrible. The things that we've had to, witness over the course of these last 2 years is just wild. Now, one of the things that's interesting about this is his parents are being held, and they're in jail right now. Their trial is being pushed back. Excuse me. And I believe that their charges are both, I want to double check and make sure that I'm not giving you guys. You see, they were both charged with involuntary manslaughter. They're arrested in Detroit a few days after the shooting. They've been in jail since that. And they're being held on a $500,000 bonds for each one of them. The trial has been delayed, however. They went on the run, if you remember. They took off and then were arrested later. But when you're found with multiple burner phones, gift cards, you're on the border of another country, you're held up in a warehouse, all signs point to the fact that you were fleeing. So they found them in that situation, fleeing the country, basically. So it reads on, Jones and other Oxford parents are upset with the latest request from the Crumleys, calling them a slap in the face. The motion filed on Monday would, and this is back on, I believe, the 11th, Monday the 11th, I might have that date wrong, would limit the number of people prosecutors share case information with through the Crime Victims' Rights Act. Prosecuting attorneys are emailing more than 1,800 email addresses in the Crumley case each time a notice or case update is shared. If the number of victims was to be limited, they would be they wouldn't be contacting this many people. But let's go. I'm going to pop you guys over to the actual, the trial. Well, this is where Ethan Crumley is actually pled guilty, but I want to make sure that we're not missing anything with old Darrell Brooks here. No, that's up the reset. All right, cool. We're good there, and we're going to jump in over here. So pardon the sound of the ocean there. We've got a lot of work going on with the computer over here. So let's do this. All right. Sorry, guys. Takes a second, but you know how these things go. Okay.
Good morning, Your Honor. We have on behalf of Ethan. Good morning, Your Honor. Deborah H. McKelvey on behalf of Ethan.
Thank you, and good morning to all counsel. Today's date and time set for a pre-trial.
This morning, Detroit, Michigan, this morning.
Judge, it's my understanding that the defendant is going to plead guilty to all 24 counts.
Thank you.
That is our understanding as well, Your Honor. First, we filed a notice asserting the defense of insanity on January 27th of 2022. At this time, we are withdrawing that notice and we'll be proceeding with a guilty plea.
Thank you. And I will let all counsel know you may remove your mask if you're comfortable.
Thank you. My client has completed a plea form. May I approach her clerk?
You may.
Judge, for the record, we've also executed a written statement of guilty plea for the court.
Thank you. Thank you. With that being said, is there anything else we need to address before I take your client's plea, Ms. Lofton?
Your Honor, I would ask the court to inquire of Ms. McKelvey as the LGAL if she had time to meet with Mr. Crumley and what the decision should be.
Thank you. Ms. McKelvey?
Good morning, Your Honor. Your Honor, I did, after Ms. Lofton and I spoke that this was going to take place today, I went to see him at the jail. On Thursday, we did spend an appreciable time discussing all this. I believe, as his lawyer guardian ad litem, he does understand what this process is, what his intent is to do today. And I believe, and I know that as part of the plea form, that he's doing this freely, voluntarily, and knowingly. So I do believe that this is something he desires to do today.
Thank you. With that being said, anything else from the people?
No, Judge, thank you.
Thank you. Mr. Crumble, if you could please approach the podium. Please raise your right hand. Under penalty of perjury, do you swear or affirm that the statements you're about to make will be the truth?
Yes, I do, Your Honor.
Thank you. You put your hand down. What is your name?
Ethan Robert Crumbly.
And Mr. Crumbly, how old are you?
I'm 16 years old.
Can you read, write, and understand the English language?
Yes, sir.
Can you hear and understand me, the prosecutor, as well as your attorney?
Yes, sir.
Are you satisfied with the advice your attorney is giving you?
Yes, sir.
And you also have been appointed another court-appointed attorney as well as a legal guardian ad litem. Did you have an opportunity to speak to your legal guardian ad litem?
Yes, sir.
And having spoken to your legal guardian ad litem, are you still prepared to proceed this morning?
Yes, sir.
And you're comfortable with proceeding?
Yes, sir.
You understand that you have the right to have an assistance of an attorney throughout all proceedings. And if you cannot afford an attorney, the court would appoint one for you.
Yes, sir.
You understand that you will be pleading guilty to count 1, terrorism causing death. That is a felony where you face up to life without parole or a minimum sentence of 25 to 40 years and a maximum sentence of at least 60 years. You may have to reimburse the government for expenses incurred from the violation. You're also charged in count 2, first degree premeditated murder. That is a felony where you face up to life without parole or a minimum of 25 to 40 years and a maximum sentence of at least 60 years. You're charged in count 3 with first degree premeditated murder. That is a felony where you face up to life without parole or a minimum sentence of 25 to 40 years and a maximum sentence of at least 60 years. You're charged in count 4 with first degree murder. That is a felony where you face up to life without parole or a minimum of sentence of 25 to 40 years and a maximum sentence of at least 60 years. You're charged in count 5 with homicide, first degree murder. That is a felony where you face up to life without parole or a minimum sentence of 25 to 40 years and a maximum sentence of at least 60 years. You're charged in count 6 with assault with intent to murder. That is a felony where you face up to life or any number of years. You're charged in count 7 with assault with intent to murder.
24 felony
that is
counts.
a felony where you face up to life or any number of
Charges.
years. You're charged in count 8 with assault with intent to murder. That is a felony where you face up to life or any number of years. You're charged in count 9 with assault with intent to murder. That is a felony where you face up to life or any number of years in prison. You're charged in count 10 with assault with intent to murder. That is a felony where you face up to life or any number of years with the Michigan Department of Corrections.
They're reading through his charges, but
You're
I'll
charged
touch
in
on
count
the
11
details
with
of this
assault
one here
with
in
intent to
2.
murder. That is a felony where you face up to life or any number of years, again, with the Michigan Department of Corrections. You're charged in count 12 with assault with intent to murder. That is a felony where you face up to life or any number of years with the Michigan Department of Corrections. You're charged with count 13, possession of a firearm and the commission of a felony. I will note for the record that you're charged in counts 13 through 24, all being felony firearm offenses. Counts 13 through 24, you face 2 years consecutively with and preceding any term of imprisonment imposed for the felony or attempted felony conviction. You understand the maximum possible penalties you face here?
Yes, sir.
You understand that the maximum possible penalty you face here on the underlying offenses is up to life in prison?
Yes, sir.
And that would be life in prison without parole. You understand that?
Yes, sir.
Mr. Keese, is there a plea agreement?
No, Your Honor.
Thank you. Sir, did you have an opportunity to review People's Exhibit number 1 with your attorneys?
Yes, sir.
And this is the plea form that covers all of your rights, sir?
Yes, sir.
And did you have an opportunity to sign this form?
Yes, sir.
Thank you. And this form goes over all of your rights. Is that correct?
Yes, sir.
I'm going to cover your rights with you here in court. Sir, if your plea is accepted, you will not have a trial of any kind, and you will be given up the following rights: the right to be tried by a jury, and throughout the trial, the right to be presumed innocent unless the prosecutor proves your guilt beyond reasonable doubt. You'll be given up the right to have witnesses against you appear at the trial and to question witnesses against you. You'll also be given up the right to have the court order any witnesses you have to appear at the trial, and you will be given up your right to remain silent during the trial and the right to not have that silence used against you during the trial. On the other hand, you could testify at trial if you wanted to testify. If your plea is accepted, then you'll be given up any claim that the plea was the result of promises or threats that were not disclosed on the record, or that the plea was not of your own choice. Additionally, if your plea is accepted, you may be given up the right to appeal issues that would be otherwise appealable if you were convicted at trial. Any appeal from conviction and sentence pursuant to this plea will be by application for leave to appeal and not by right. A plea means you have a conviction that may be used against you in the future. If you're on probation or parole, these pleas could affect your status. You understand that?
Yes, sir.
Were you born in the United States?
Yes, sir.
I do have to advise you that if you were not born in the United States, that this plea could affect your immigration status. Sir, has anyone promised?
And I would love Darrell Brooks to try
to
to pop off to this judge.
Is it your own choice to plead guilty?
Yes, sir.
Do you need any more time to talk to your attorneys about any of your rights?
Yeah.
No, sir.
And I will allow the prosecutor to conduct the voir dire. However,
Yeah,
I will ask you, sir.
Both of his
did
parents
these
are being
offenses
charged with
occur
involuntary
on about
manslaughter.
November 30th, 2021 in Oakland County?
Yes, sir.
What city or township?
Oxford.
Thank you. People?
Thank you, Judge. Sir, on that date, November the 30th, 2021, in Oakland County, Michigan, did you bring a 9mm 6-hour handgun and 50 rounds of 9mm ammunition with you to the Oxford High School?
Yes, sir.
Did you keep the gun and ammunition in your backpack with you that day?
Yes.
Is it true that approximately 12:49 p.m. on that date you entered a boys' bathroom in the Oxford High School?
Yes.
Is it true that
I'm
while
sorry. Can you keep your voice up for me?
Yes, sir.
Is it true that while inside the boys' bathroom, in the stall of the bathroom, you removed the handgun from your backpack?
Yes.
Is it true that you ensured that the handgun was loaded?
Yes.
Is it true that you exited the bathroom approximately 12:51 p.m. on November the 30th, 2021?
Yes.
Is it true that when you exited the bathroom, you began shooting at students and staff members of the Oxford High School?
Yes.
Judge, for the specific factual basis, I'm going to do counts 2 through 5 and then count 1.
Please.
Regarding count 2, first-degree murder. Is it true on November the 30th, 2021, while you were in Oxford, County of Oakland, you deliberately, with the intent to kill and with premeditation, use a 9mm handgun and shoot and kill Miss Madison Baldwin?
Yes.
Is it true on November the 30th, 2021, while you were in Oxford, County of Oakland, you did deliberately, with the intent to kill and with premeditation, use a 9mm handgun and shoot and kill Mr. Tate Meyer?
Yes.
Is it true on November the 30th, 2021, while you were in Oxford, County of Oakland, you deliberately, with the intent to kill and with premeditation, did use a 9mm handgun and shoot and kill Miss Hannah St. Julian?
Yes.
Is it true on November the 30th, 2021, while you were in Oxford, County of Oakland, you did deliberately, with the intent to kill and with premeditation, use a 9mm handgun to shoot and kill Mr. Justin Schilling?
Yes.
Could you repeat your answer, sir?
Yes.
Thank you.
Is it true that on November the 30th, 2021, when you committed the crimes of first-degree premeditated murder in Oxford, County of Oakland, that you acted knowingly, willfully, deliberately, meaning you consider the pros and cons of your actions, then you made the decision, after substantial reflection, to commit first-degree premeditated murder?
Yes.
Is it true that you knew or had reason to know that your choices on November the 30th, 2021, in committing these crimes would cause a substantial likelihood of death or serious injury?
Yes.
Is it true when you committed these crimes, you intended to put students and teachers in fear, and you intended to cause panic among the Oxford High School community?
Yes.
Is it true that your actions on November the 30th, 2021 caused the deaths of Madison Baldwin, Tate Meyer, Hannah St. Juliana, and Justin Schilling?
Yes.
Regarding count 6, is it true that on November the 30th, 2021, you assaulted Miss Phoebe Arthur by shooting her with a 9mm handgun and was your intention to kill her?
Yes.
Count 7, is it true that on November the 30th, 2021, you assaulted Mr. John Asciutto by shooting him with a 9mm handgun and was your intention to kill him?
Yes.
Count 8, is it true that on November the 30th, 2021, you assaulted Miss Molly Darrell by shooting her with a 9mm handgun and it was your intention to kill her?
Yes.
Count 9, is it true that on November the 30th, 2021, you assaulted Miss Riley Franz by shooting her with a 9mm handgun and was your intention to kill her?
Yes.
Count 10, is it true that on November the 30th, 2021, you assaulted Mr. Elijah Mueller by shooting him with a 9mm handgun and was your intention to kill him?
Yes.
Count 11, is it true that on November 30th, 2021, you assaulted Miss Kylie Osage with the intent to commit the crime of murder and was by shooting her with a 9mm handgun, it was your intention to kill her?
Yes.
Count 12, is it true that on November 30th, 2021, you assaulted Mr. Aiden Watson by shooting him with a 9mm handgun, it was your intention to kill him?
Yes.
For counts 13 through 24, Judge, I'm going to take the factual basis all at once. These are all the felony firearm crimes. Is it true on November 30th, 2021, that all crimes were carried out while you possessed and used that 9mm handgun?
Yes.
Is it true that the firearm that you used on November the 30th was purchased on November the 26th, 2021 by your father, James Crumbly?
Yes.
Is it true that you asked him to buy that firearm?
And this is where the parents get brought in.
Is it true that you gave him your own money to buy that firearm?
Yes.
Is it true that you picked that gun up to buy?
Yes.
Is it true that on November the 30th, 2021, that 9mm handgun that you used in Oxford High School was not kept in a safe or locked container?
Sorry, repeat that.
Is it true on November the 30th, 2021, when you obtained the firearm, it was not kept in a locked container or a safe?
Parents bought him the gun
Yes, it was
when he was a
locked.
minor.
People are satisfied.
And
Thank you. The court adopts the people's voir dire as its
And he
own.
used that gun
With that being said,
to
defense satisfied as well.
Defense is satisfied.
assault all these
Thank
other
you.
people.
Does the prosecutor and the defense attorney agree that the court has complied with sub rules B through D?
Yes, Your Honor.
You have, Your Honor.
Thank you. And if I haven't stated it, based upon that voir dire, I do believe there's sufficient factual basis to support the convictions in counts 1 through 24. With that being said, is either prosecutor or defense attorney aware of any promises, threats, or inducements other than those disclosed on the record?
No, Your Honor.
No, Your Honor.
Thank you. The court finds the plea to be voluntary, understanding, and accurately given, and I accept the plea. The court will set this matter for a tentative Miller hearing on February 9th, 2023 at 9 a.m. That will be in person here in my courtroom. As counsel is aware, we must continue to conduct a review hearing every 30 days because the defendant is a minor at the Oakland County Jail. As such, the court will conduct a review hearing in this matter on November 29th, 2022 at 9 a.m. via Zoom. With that being said, is there anything else for the record this morning?
Taking accountability
I do
for
want
his
to note for the
actions.
record that paragraph 2 of her statement of guilty plea does indicate that to the extent it ever becomes necessary, the parties do agree to supplement today's record with all case reports, all evidence submitted to this court during the juvenile justice and delinquency prevention hearings that occurred February 22nd, March 24th, April 21st, May 19th, June 23rd, July 22nd, August 25th, September 22nd, and October the 20th.
Thank you. So noted. Anything else for the record?
Just one more, Your Honor.
Yeah, his parents are cooked now. They're both going to be brought up. I mean, they made sure to keep that clear. That the gun was bought
Just so the
for
record is
him.
clear, the tentative Miller hearing date is February the 9th. We'll have a sentencing
By
hearing
his
after
father.
that date. Is that correct?
That is correct. The court will set it for sentencing after I've conducted the Miller hearing to give myself an opportunity to make a decision about the Miller hearing, as well as to allow counsel to supplement any record that they need to supplement.
And as you know, Your Honor, we have a lot of victims in the courtroom today, a lot of victims watching, and just to put on the record that they will have an opportunity to make a statement to the court at the time of sentencing.
Absolutely.
Thank you.
Thank you. With that being said, anything else?
No, Judge. Thank you.
Thank you, Your Honor.
Thank you. Deputies, you may take the defendant. Thank you. If everyone in the courtroom could please be seated.
So there's a massive difference between monstrous like acts that people can do.
Thank you. With that being said, the court is going to stand in recess.
All rise.
I mean, okay, so horrible. If you guys don't remember this, in Michigan, this is where the Crumley, the whole Crumley case right now is really pretty involved. Well, it's thinned itself out right here. So Ethan Crumley, premeditated, planned, went to school and opened fire, killing 4 people. And he was I actually have to double check the age. In the comments here, you guys throw up, how old was he when he showed up at school, when this happened last year? But the thing about it is his dad bought the gun, right? So when this happened, his parents, we're not sure how much they knew and what going into it happened, but they went on the run, and they were found on the run with like burner phones, gift cards. Like they were at the border as well. So they were 15 or 16, 15 years old is what we're getting. Anna Anderson, thank you for that. And Gail, Jamie, everyone, thank you. Yeah. So This 15-year-old kid is pleading guilty to all these charges. He knows he'll never see the light of day again. He's done. He's done. And help me if you could, please. Someone mentioned there was another school shooting today, which is, I mean, can we make it through a day? You know what I mean? Can we get through one day? Man, Patricia, thank you for that. Those stars are there. He's 16 now. Yeah. This 16-year-old, however it works, whatever happened, has sat down and said, I don't know his mindset, but what he's just done is pled guilty and acknowledged all of his crimes. What we've been watching for the last 13 days is a grown man thinking that he can dance through the system and find loopholes after plowing through a crowd of people, killing 6 people and injuring over 61 others. So it's amazing to me the stark difference between these two people. But here's a little bit of the back end. I'm going to show you this other video here of what was going on with Ethan Crumbley, which this is where it scares me, because you've seen there's I don't want to say, like, there are symptoms for situations like this where you see a buildup. And I'm not going to blame it all on bullying, but there's bullying. There's all these things that are happening with our youth today. And we just heard about another school shooting. I mean, it's put them to a place where they're bringing guns to school, and they're doing things radically. This kid had some real things going on in his head. And let's see if this explains it. If not, we might find another one for you guys to take a look at. But yeah, let me throw this in here for you.
Give us an inside look at the chilling plans detailed within the journal of the defendant in the Oxford school shooting, Ethan Crumbley. That journal was with the 15-year-old student on November 30th.
It was in his backpack along with a handgun when Crumbley was in his school counselor's office with his parents. Local 4 defender Sean Lay has a look at the journal that lays out sinister plans to shoot classmates. And Sean, it also contains cries for help, too.
Absolutely. I got a look at 2 pages of this journal. Let me give you 4 things written by Ethan Crumbley on 2 of these pages, like, I will tell close friends not to come the day of the shooting. He writes, I have lost every hope of life. Also writes, help me, and I want to shoot up the school so badly. And that is just the start. The local 4 defenders obtaining these key photos from the Oxford school shooting. That is Ethan Crumbley's backpack on the bathroom floor, where he first pulled this semi-automatic handgun from that backpack and began his horrific shooting spree. Also inside the backpack, Ethan Crumbley's journal, where in chilling detail, Crumbley lists his entire school shooting plan. The gun and the plan all in the backpack and with Crumbley in his school counselor's office before the shooting. Buck Meir, father of victim Tate Meir, and his attorney Ben Johnson say the counselor and other Oxford officials just needed to look in the backpack.
Looking at backpack.
Guys, in the backpack,
right?
The gun and
right. That's
and the journal.
Let's break down just some of what is written on 2 pages of the journal. It reads, quote, my name is Ethan Robert Crumbley. I want the world to remember me. There's a checklist, a 9mm pistol with extra mags, 2 to 5 Molotov cocktails, flares, gloves, hat, jacket, mask, and knife. Crumbley writes that he will exit the classroom and, quote, then shoot any girl pretty in the back of the head. I will shoot anyone I see, aiming for their head. I will then find a full class and throw Molotov cocktails in there. Crumbley goes on to write, quote, I will continue shooting people until police breach the building. I will then surrender to them and plead guilty to life in prison. The gun, the plan, the backpack, Ethan Crumbley, his parents and school counselor were all together hours before the shooting. Here's local 4 legal analyst Neil Rockeye.
The reason that this is such an important watershed landmark case is that all of this happens together at the same time with the parents, with the counselor. It is, in my view, a failure, an institutional failure of catastrophic proportion across the board.
Again, we're getting a look at 2 pages of the journal. I'm told there are more than 20 pages of the journal. Every word, I'm told, will be read at Ethan Crumbley's trial and at the trial for his parents who are charged with involuntary manslaughter.
So his parents are charged with involuntary manslaughter because of their involvement in purchasing the weapon for Ethan Crumbley. There's another look at it here. Maybe we'll go a little bit further in this. I'm hoping this talks a little bit about the parents. So yeah, we're gonna hopefully. I think this one will talk a little bit about the parents. I was caught up with so many other things last year that even following this was. Then you got Nicholas. Yeah, man, Nicholas Cruz. It's always the worst one since the last one, and that's what blows my mind. It's so sad. It's just always the worst one since the last one.
Accused shooter Jennifer and James Crumbley are asking the judge to reduce their bond from $500,000 to $100,000. But late this afternoon, Oakland County Prosecutor Karen McDonald filed a brief to argue against that. That brief revealing the concerning drawings made by Crumbley and discovered by a teacher at Oxford High School just the day before the deadly shooting. 7 Action News reporter Jim Kirchner is outside District Court in Rochester Hills with this brand new information. Jim?
The 2 parents are charged with involuntary manslaughter, and with this filing late this afternoon, the Oakland County prosecutor says the case against them is stronger than ever and that they're at a greater risk of flight. They bought their son the gun that was used in the shooting just days before it all happened. And remember the day they were charged about 3 weeks ago? They were found hiding out in a building in Detroit.
Clearly, this is a serious case. People died, and they have a responsibility for that, according to the prosecutor. I think a judge is going to have a hard time reducing the bond.
The Oakland County prosecutor says the Crumbley parents are $11,000 behind in their house payments. Their house is for sale. They sold horses they owned. And there are more critical facts known by the parents that have not been told to the court. They were called to Oxford High School the morning of the shooting when their son Ethan was found with this drawing and a picture taken by the teacher to preserve it. Picture includes the words, "The thoughts won't stop. Blood everywhere. Please help me. My life is useless. The world is dead." Court document also says the parents knew their son was depressed, was fascinated with guns, had been seen watching a video of violent shootings that morning. Their son's only friend had moved away in October. The family dog died. Much more evidence than we've seen before.
From the get-go, prosecutors like to get their case out there as much as they can, and the defense has given them an avenue with this bond reduction motion.
Attorneys for the parents are asking the judge here to reduce their bond $500,000 each down to $100,000 each. Prosecutor is arguing against that. This will be heard here before the judge on January the 7th. In Rochester Hills, Jim Kirchner, 7 Action News.
All right. Thank you so much, Jim. Now, tonight, we are also learning that Ethan Crumbley's parents are telling a very different story about their son's case compared to what we've heard from prosecutors. Here's 7 investigator Ross Jones with that angle.
What's the probability of these individuals showing up or appearing for court?
In a motion filed in 52nd District Court, attorneys for James and Jennifer Crumbley say their clients don't pose a risk to public safety and won't skip town during their criminal case. They're asking that their $500,000 bond be slashed to $100,000.
I think that there is a fair argument to reduce this bond. The whole idea is you want to be able to help your client, and it's going to be a whole lot easier to assist your client if he's out on bond, where you can meet him in your office.
Criminal defense attorney Ray Kassar reviewed the 7-page motion, saying that the defense team has its work cut out for them. The serious charges work against them, he said, and they'll have a tough time explaining why the husband and wife went missing during their arraignment.
They were found in some sort of a warehouse that's not in their home. I mean, why weren't they at their home at least? They're going to have an uphill battle to convince this judge.
In the new filing, attorneys introduced arguments that they hope could sway the judge. When Jennifer Crumbley texted her son, "Don't do it, Ethan," they argue it wasn't in reference to shooting up the school. Instead, it was a mother urging her son not to kill himself after the shooting took place. Attorneys also claim that the gun Ethan Crumbley used was in a locked and hidden location, contradicting what prosecutors have said. Ultimately, the defense says the prosecution will not be able to prove that the Crumbleys knew their son was a danger to other students, or that they knew there was a situation that required them to take care to avoid injuring another.
These are factual issues for a trier of fact. That's later in circuit court when it comes down to trials or other pretrial motions.
Attorney Dan Hodges said it'll take more than what the defense is offering in this motion to get the judge to make such a big reduction in bond.
These arguments, in my opinion, have already been made at the time of the arraignment. I think they were fully explored, and the judge set the bond the way the judge set the bond.
While more evidence could come to light based on the arguments being made today, both attorneys believe a bond reduction is a long shot.
The judge is going to really struggle with a reduction in this case.
There is no word tonight on when the judge will issue her ruling. The Crumbleys are due in court in February for a preliminary exam. I'm Ross Jones, 7 Action News.
All right. Thank you so much, Ross. Meantime, Oxford school officials are working to begin a slow reopening of the high school by the end of January. On November 30th, 4 students were killed inside the school and 7 other people were injured after Ethan Crumbley allegedly opened fire inside the building. The district says a team of school employees and staff members has attempted to personally contact the families of all 1,700 high school students. They were hoping to have input in decisions about the current return to school plan. The district is also planning virtual and in-person town hall meetings on January 5th and 6th for Oxford families to share their ideas and their concerns. As of right now, K through 8 schools are still planning to reopen on January 3rd.
Man, so yeah, that's this will be an interesting trial. If now that Ethan Crumbley has pled guilty and has acknowledged that his parents, or his father, however his parents, purchased him the gun at age 15, purchased the gun for him, rather, at age 15, just days before the shooting. And for however it looks, we're aware that he had, there was issues that the kid was, there was something wrong with him, that he was going through whatever he was going through. And not that I will ever give excuses for anyone in these situations, but what you do see is that there's a teeming amount of I don't even know the way to word this, man. There's a teeming amount of situations that have been coming up where there's a common denominator in these. There's very much a basis that runs kind of through all of them. And I'm not talking about Darrell Brooks. He's a world-class, asshat. But these kids that are involved in these school shootings and these things that are happening where they're felt that they get, it seems that they feel through all the things they find thereafter that they have no outlet, that they have no place to go. They have no pressure release in their life. And then they do get inundated with violence. They get inundated with, and I'm not going to say it's all video gaming, but video gaming that involves just shooting everybody and everything. And then it's major media, we and it sucks because we're covering a trial that involved horrific acts right now, but there's not enough opportunity to look at things. We don't see things enough. There's not enough exposure to the positive. There's not enough exposure to opportunity for life and love and change and all the things that we need to push as a people. And especially with the divide we've seen in the last 2 years, there's not a lot of talk about unity and about camaraderie and brotherhood and things of that nature. You know what I mean? It's been built up to be a divide and destroy mentality, but it's terrible. We want to see more for the children that we've got out here they're the ones that are going through all this, and they're not handling it. These kids are not handling it as well as I think a lot of people think they are. But a trial was scheduled for the parents of the accused Oxford high school shooter. And let me show you who these folks are. But I'm I'm not going to keep you guys on too long here. Hey, what a day, man. I'm just glad we got a chance to get rid of old Darrell Brooks, man. I was at a break point with looking at that guy. You know what I mean? Like it was getting to be too much in one day. So, yeah, the trial for these two right here was scheduled. It's been pushed back now. They both face involuntary manslaughter charges. The trial originally scheduled for James Crumbley and Jennifer Crumbley was on October 24th, today. Has been postponed and will not occur on today's date, obviously, according to court documents. A new trial date has not been rescheduled. James Crumbley, 45, and Jennifer Crumbley, 44, are each facing 4 counts of involuntary manslaughter in connection with the fatal mass shooting at the Oxford High School on November 30th, 2021, in which their son is accused of shooting and injuring 7 people and killing 4 students. The couple have been lodged at the Oakland County Jail since the shooting, along with their son, though all are being lodged separately. Obviously, they're not going to keep them together. Judge Cheryl Matthews set the tentative October trial date for the Crumbley parents during a hearing in June. The judge and prosecuting attorneys hope to wrap up the trial before the holiday season and obviously before the anniversary of the shooting, but that's not going to happen now. The defense attorneys in June seem to believe that October 24th trial date would not be achievable, but they did not officially request an adjournment at that time. As of September 13th, the court information shows that the tentative trial date has been adjourned and as of yet, has not been replaced. Ethan Crumbley's trial was initially scheduled for September of this year, but as of today, as we've seen, he just pled guilty to 24 counts of 24 felony counts. So it says here that James and Jennifer Crumbley are being accused of negligence and failing to take steps to prevent the November mass shooting that left 4 students dead: 14-year-old Hannah St. Juliana, 16-year-old Tate Meyer, 17-year-old Madison Baldwin, and 17-year-old Justin Schilling. The Crumbley parents are both facing an involuntary manslaughter charge in connection with each student's death. In the several months following the mass shooting, prosecuting attorneys have brought evidence against James and Jennifer, the Crumbley parents, accusing them, take it easy, sorry about that, accusing them of neglecting to address their son's cries for help and mental distress, purchasing a gun for their son and teaching him how to use it, and apparently there's more. Yeah, Ethan Crumbley is facing the 24 felony charges, where the judge hasn't gone into sentencing yet, is 1 count of terrorism causing death, 4 counts of first-degree murder, 7 counts of assault with intent to murder, and 12 counts of possession of a firearm in the commission of a felony. He was, he's been in jail since. He was denied bond. They initially had a court filing in January revealed that he intends to assert the defense of insanity at the time of the alleged offense, and then they pulled that back. They reeled in that claim. So, yeah, this will be an interesting trial of the parents of Ethan Crumbley, James and Jennifer Crumbley. See what happens. So, the charges could be extensive on them as well. So, Cynthia, thank you for those stars. Yeah, I got a box fort to build right now, so I'm going to be a little strapped for time because I got to get my Darrell Brooks box fort going if I'm going to be in full form for court tomorrow. So hopefully when you guys see me again, I'm going to have my Xerox box fort going solid, and you can only come in if you become a supporter, a subscriber, or set up notifications or become a member on YouTube. And then I might be able to grant you access to the box fort. But between now and then, you guys take care of yourselves. Make sure to set up notifications. Yeah. And I will be back tomorrow morning, 8:30. Judge Shorter wanted to
That was before the
Don't get brazen with me.
Best not get brazen with that, man. I'm going to go handle this dog over here. He's anxious for attention. And I will see you guys bright and early tomorrow morning, 8:30.